The meeting of the Davidson County Election Commission, May 2nd, 2024 at 6 o'clock is called to order. Thank you all for being here. The first item on our agenda is public comments. We have a sign-up sheet, and each person who has signed up can make a comment. We have two people who've signed up. The first person is Ms. Savage Short. Ms. Savage Short, please come to the podium. Thank you for being here. You have 2 minutes. You have the floor for 2 minutes.
I guess if I'm not on, that's fine. I speak loud enough. I just want to start off by saying thank you for opening up to public comments. Next, I would like to say, thank you, ma'am. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our prosperity, do ordain and establish this Constitution for the United States. So, Father God, I come into you in the name of Jesus Christ, that you just cease and desist any demonic activities that is going on in and around this place. We shall not have any harm to come to either candidates in the name of Jesus. May Jehovah Shalom, the justice of Yahweh, and the Holy Ghost reign down in this place in Jesus' name. Amen.
Thank you. Mr. Garrett, you're next. Please approach the podium. You have 2 minutes. Thank you, Mr. Garrett.
And I thank you all, and I traditionally will say to you, thank you, each and every one of you, for the job that you do in our county. Most of us do really appreciate the thoughtfulness that you give, the effort that you put into these decisions. Tonight's going to be an interesting night. I think I can say that with some conviction, but tonight will be an interesting night. You will have some important decisions to make. And as Demetrius mentioned, I pray to God that you make decisions based on your own feelings and make the right decisions. Again, I thank you for everything you do, because I think you do a good job. Thank you very much.
Thank you. Ms. Justice. Thank you.
Thank you, everyone. I had a great conversation with Mr. Roberts. So thank you for your time today. You answered most of my questions, and so I was just curious if I could possibly ask another one before we get started. Mine was one of the challenges as far as the signature goes, which is why we're here, right? And my only question really is, if any of you guys sitting here making these decisions, did you actually compare any of the challenges on the signatures? Because I can't see any difference in mine from 2002, like the two examples that you have as a reference. Literally, it's J.R. Justice, all the way down the line. So I'm just curious, did anyone happen to look at the challenges and why we're here tonight?
Ms. Justice, I'm afraid that gets into the substance of the issue that we're going to have to resolve today. So I don't think we can start answering questions about our deliberations. But
okay, so so we don't know if anybody here tonight looked at the actual challenges.
I think it'll be clear before we're through.
Oh, okay.
Yeah.
Because you're going to look at them before you do anything, right?
Yes, we're going to have a big...
So nothing's been done to this point?
No,
that was my question.
No, ma'am. Nothing's been done.
I'm just trying to save some time. Thank you.
We've set forth some procedures about how this is going to be addressed, and both sides are going to have a chance to make their case, and then we'll talk about it.
Okay. Thank you.
Yes, ma'am. Thank you, and thank you all. The next item on the agenda is to consider the minutes from our last meeting, April 22nd of 2024. Have the commissioners had a chance to review the drafts that have been circulated?
Make a motion to approve.
We have a motion. Do we have a second?
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Any opposition? With no opposition, the motion carries. We now are at the point of item 3 on the agenda, which is to review, discuss, and vote on the petitioner challenges filed by the Election Commission. And the first one is Ms. Nelson against Representative Jones. There are 3 preliminary matters. One is that Ms. Nelson has requested that we change the date and time of this meeting, and I assume that's a moot issue. We addressed it at our last meeting, but if it's not a moot issue, Ms. Nelson, if you want to address us on that, I assume that's a moot point.
Good evening. I'm Miss Nelson, Laura
Yes.
Nelson. And what was your question as we're working on the computer right here?
Okay, there were three requests that have been made, and one of them was yours to change the date of the meeting. I assume that's a moot point at this point?
Yes, sir.
All right, okay. Then there is a request to exclude Representative Jones's evidence. Are you going to address that in your side of the case?
Yes, sir.
All right. And then there is a request by Representative Jones that the chair recuse himself. And do you want that heard now?
We can do it when I can get some opposition.
Okay.
Will I be able to play the recording that was left for you?
As part of your evidence, yes. Okay. All right. Under the procedures that we established at our previous meeting, and I believe all the parties have received a copy of this, the next step is an opening statement by the challenger, which in this case is Ms. Nelson, and that will be 5 minutes. And then Mr. Jones will have 5 minutes to respond. Ms. Nelson, you're on the...
Well, are you going to ask us to take an oath?
If you're going to testify, yes. Each side will have 30 minutes to present their evidence in addition to making an opening statement.
Okay.
So we will swear the witnesses when the evidence starts, unless you're going to be testifying during your 5 minutes.
I am not.
This is in
I'm
the
not going to
nature of
testify.
an opening statement.
Okay.
As if this were a trial. It's not really a trial, but it's in the nature of a trial.
Okay. Very good. I'm ready to get started.
All right,
Okay.
you're on the clock.
Good evening. My name is Laura Nelson. I am the Republican candidate running for State House District 52. I would like to thank the commission for taking their time to evaluate my challenge of Representative Jones's nominating petition and for looking at this according to the laws and rules of the Election Commission in an unbiased manner with tolerance and discretion. I would like to thank my friends, family, fellow Republicans that are here today, as well as the news media, for attending this hearing in support of election integrity in Davidson County. I would like to share that the election process is made up of we the people, not we the attorneys. What I mean by this statement is that everyone should feel comfortable and safe to be involved in this election and candidate support procedure. The case challenge we have here today is simply procedural. The word is procedure, procedural. When rules and procedure are respected and followed as intended, it fosters a sense of stability and predictability in various aspects of the election process, and equally as important, it fosters trust in the people making the rules and setting precedent. Our intention is to discuss the evidence that we submitted regarding the legal timeline according to Mr. Roberts, Administrator of Elections in Davidson County, and the legal time frame in which Representative Jones submitted his evidence to the Commission. The Election Commission set the legal deadline for evidence submission for both parties in this challenge to be on or before Wednesday, April 24th, noon. Representative Jones and I had the same amount of time to prepare for the challenge, 6 days. From April 16th through April 24th, I submitted my initial evidence the morning of April 24th, before the noon deadline. He did not. This was confirmed by AOE Roberts, that stands for Administrator of Elections, in an email to me Wednesday the 24th at 1:35 p.m. after the deadline passed. Therefore, any evidence received after noon on Wednesday, April 24th, in accordance with the 2021 Tennessee Code Title II-Elections, should be ineligible for review, disqualified, and not heard by this commission. Representative Jones submitted his initial evidence late on April 26th, has been allowed without dispute by the Election Commission. How can legal deadlines apply to one campaign and not the other? This commission allowed his evidence to be submitted after the initial deadline. As a result, I was denied my due process. As Representative Jones did not submit any initial evidence for anything and related to the 10 signatures challenge on April 24th at noon, it could not be shared with my committee and the commissioners in accordance with AOE Roberts' mandated timeline. Again, due to Representative Jones's neglect to submit his initial evidence, to comply with the rules and procedures set forth by this commission, the details of his evidence could not be shared with my committee nor the commissioners for the April 24th noon deadline. Representative Jones' initial evidence was accepted as supplemental on Friday, April 26th at 10:22 a.m. The Laura Nelson Committee did not receive his initial evidence until 12:11 p.m. on April 26th. Because of this violation and AOE Roberts' delayed communication to us, we had no time whatsoever to review the initial evidence and therefore submit our supplemental evidence by Friday the 26th. Supplemental evidence deadline day, Friday, April 26th. By AOE Roberts accepting the initial evidence as supplemental, it would be a clear violation of the Commission's timeline of deadlines set forth. This is a discriminatory matter in nature. Respectfully, the Laura Nelson Committee requests a vote to disqualify Representative Jones's initial evidence package submitted in violation of protocol and procedure in order to continue with proceedings tonight. It's clear that any evidence submitted by Representative Jones after the legal deadline of April 24th noon should be immediately disqualified before we move forward with a 30-minute presentation of facts. Otherwise, any other decision would be in violation of my due process and my rights, which would hinder the fairness of today's meeting. Respectfully, I, Laura Nelson, request a vote to disqualify Representative Jones' initial evidence package submitted on February 26th at 10:22 a.m. in violation of the Davidson County Election Commission protocol and procedure in order to continue with proceedings. Election integrity starts right here. Thank you.
Mr. Jones, you're recognized.
Thank you so much. Good evening, Mr. Chair, members of the commission. The truth is powerful and it prevails, which is why my Republican opponent is here today. The truth is that the Election Commission staff, the independent administrative staff of this commission, certified my petition before the deadline. Days later, my Republican opponent, with the help of the Tennessee Republican Party chair, called the chair of this commission, and I want to play that voicemail of what was left.
Hello, Mr. Delantis. This is Laura. Hello, Mr. Delantis. This is Laura Nelson, Republican candidate in State House District 52. Per the referral from Scott Golden, our state Republican chairman, he asked me to contact you immediately. Thus, I am doing so. have found out information about Democrat Justin Jones's nomination petition. It was submitted on April 3rd. There are suspect signatures, and more than one. I have estimated that there are 6, and I am looking for your guidance legally. And Scott Golden said you're the man. So when you get a chance, would you please give me a call? My personal cell phone is 716-487-7207. My name is Laura, Laura Nelson. I am the Republican candidate that will be on the ballot August 1st. Thank you.
So my question to this commission, what did it mean when a candidate calls the chair of this commission after speaking to administrative staff to say that the Republican Party chair told me to call you because you're the man, that I'm calling you who will decide this case for legal advice? That's what she asked for in that voicemail, Mr. Chair. And so what they're trying to do now is that we have the evidence on our side. The truth is powerful and it prevails. We have affidavits that have been notarized. I left session on Thursday, and until 10 o'clock at night, we went to go knock doors and get notarized affidavits. What this commission requested of us, 10 affidavits, notarized, the notary public checked the IDs of people, saw them sign it, went through the whole process, and they're terrified of the facts, they're terrified of the truth, because the truth is powerful and it prevails. The truth is powerful and it prevails. You can shout, but the truth is powerful and it prevails. And so I come before this commission today to say that this challenge is not only frivolous, but it is about a pattern of political harassment that is being used in this building right now. And so the chair said that I did ask him to recuse himself because I also have text messages from the Republican candidate to the chair of this commission. And so I will leave it to the chair of this commission to determine if the ethics would require him to recuse himself after being in correspondence about this very matter that you are to decide today, Mr. Chair. I will leave it to your integrity and to your ethics to see if that is right. Because as an elected official, I represent the 52nd District. And one thing I've done in every vote that I've taken is avoid even the appearance of impropriety. It is improper for a candidate to directly contact the chair of this commission, getting your cell phone number, going around the staff, after she spoke to the staff here to say that you're the man and I need your legal advice. Because the truth is they need a lot more legal advice than just from you, Mr. Chair. They need to consult the facts of this case. That this election challenge came after the day before the filing deadline, we got an email certifying our petition from the staff in this building saying you have been certified as a candidate. We were approved. And so this is not about challenging just us, but it's about challenging the staff who work here so hard for the people of Davidson County. That's what this challenge is about. It's not just about challenging me, but the last time we ran against each other, I believe I got 77% of the vote. It's about challenging the voices of the people of District 52 because they cannot win fairly, so they have to find backhanded tactics of deceit and deception and deflection and distraction to confuse folks because they cannot win fairly. And so, Mr. Chair, the truth is powerful and it prevails. I look forward to showing you the evidence that we submitted on time. I called the staff here, the director here, to make sure that it was submitted on time. He said it was on time. We tracked him down at the warehouse for the election commission to make sure that it was on time. And he said it was good. And we got it before the deadline because some of us had work, the people's work to do that week. And we were in session from 9 a.m. to 9 p.m. instead of going through on Facebook trying to figure out how to cheat this election. So power to the people. The truth is powerful and it prevails.
Commissioners, I think there's a threshold issue, and that is the motion that's been made by Ms. Nelson and the response now by Mr. Jones to this request to exclude all of Mr. Jones's evidence. And, I just open that up for discussion among the commissioners. Ms. Hertzfeld, you're recognized.
Sure, I just want to make sure I have a proper understanding of the facts. We set these rules at our last meeting in order to make sure that everybody had the information about how to present evidence to this commission. Is that right?
Yeah.
Okay, and Mr. Roberts, you gave that information to all the candidates and communicated it to them and they had it.
Right.
Okay, and the way that it worked is Mr. Jones submitted his petition. Our staff said that petition has been certified as appropriate, and you will be a candidate, and we'll put you on the ballot when the election commission votes. That's right? So it's the burden of the challenger to try to undo it otherwise. So the evidence would have to come from the challenger. Supplemental evidence would then come from Mr. Jones to, rebut or, argue against anything that Ms. Nelson presented. So Mr. Jones's evidence came in time on the supplemental evidence deadline. Is that right? Okay, I don't see an issue.
Any other discussion?
Mr. Chairman, just appreciate what Commissioner Hertzfeld indicated, and it seems to me that she's outlined it pretty well.
Right.
As I said, he was advised he was on the ballot, burdens upon the challenger. He wouldn't know what to provide prior to that challenge being officially provided, so I agree with Commissioner Hertzfeld.
Right. Yeah, it was my understanding that the challenger would go first and then the respondent would have a chance to come back with his information. So I had no issue with Mr. Jones, Representative Jones, submitting his evidence on the 26th. Is there any other comment or discussion?
Yes, sir. Mr. Chairman.
Yes.
Yes, I think this evidence ought to be submitted. We set those dates, and it wasn't like we said you couldn't bring anything else that was pertinent to the issue. So, Representative Jones bringing that additional information, and he submitted on a timely fashion, I would agree to allow him this evidence.
Any other? Are we ready for a motion? Does anyone have a motion?
Mr. Chairman, do we need a motion? I think it's accepted unless we move to disqualify it.
I'm comfortable with that.
Me too.
Sounds like we have at least close to a consensus. Yes, Commissioner Davis.
Well, question, should we just make a formality of it, or in regards to, just in case there's some detail we're going to find out later since we've had other issues previously in the past? Question to the commissioners.
I'm certainly comfortable if anybody wants to make a motion.
I'm just asking for if there's any technicalities we need to make sure we handle.
If we need a motion, if you want to make it official, I would make a motion that we accept the evidence that Representative Jones has submitted.
All right.
Okay.
Do we have a second?
I'll give you the second then.
All right, we have a motion and a second. All in favor say aye.
Aye.
Any opposition? With no opposition, the motion carries. Representative Jones, you've requested that I recuse myself, and I have considered that issue carefully. We are in a quasi-judicial function, at least possibly. The law is not completely clear, but we are probably in a quasi-judicial function. And so therefore, I have looked at the rules and precedents that are applicable to judges. And in the two areas there that are pertinent are recusal and ex parte communications. The party seeking recusal bears the burden of proof. A party challenging the impartiality of a judge, I'm not a judge, but it's similar, must come forward with some evidence that would prompt a reasonable, disinterested person in the judge's position to believe that the judge's impartiality might reasonably be questioned. The law of judicial bias is intended to guard against the prejudgment of the rights of litigants and to avoid situations in which the litigants might have cause to conclude that the court has reached a prejudged conclusion because of interest, partiality, or favor. And the law focuses on not so much what the candidate or the party has done, but on what the judge, or in this case, the commissioner, has done. And when I received these messages from Ms. Nelson, I immediately contacted AOE Roberts, and we responded. We jointly prepared a response that essentially said, you'll have to talk about that with Mr. Roberts, and I can't talk to you about it. And I have not spoken to her about this case. I don't know Ms. Nelson. I didn't know who she was when she was approaching the podium. So I believe I can sit on this case impartially, and I swear that I will do that. The other part of the issue is ex parte communications, and they're dealt with under the Code of Judicial Conduct. And if I were a judge, in this case as a commissioner, I am not supposed to initiate, permit, or to consider ex parte communications, and I have not. The only part that I considered was the scheduling part, the administrative part, in which basically Ms. Nelson was filing an appeal, and so I transferred that responsibility to AOE Roberts. I don't believe that there's been any procedural, substantive, or tactical advantage that she has gained by making that conduct. And I did notify all the parties of the communication, and you've had an opportunity, and they have had an opportunity to respond. There is law to the effect that if the other parties receive a copy of the communication, that it is no longer a ex parte communication. So with that, I do not believe that the communications from Ms. Nelson will affect my impartiality, and I believe that I can sit on the case, and I promise you that I will sit on the case impartially. With that, the next step in this proceeding is Ms. Nelson, you have 30 minutes to present your evidence. And if there are witnesses that will testify, we will have to swear them in. But you've got the floor, and you can present the evidence as you see fit, with the proviso that witnesses who are going to testify live would have to be sworn in.
Okay, thank you.
Yes, ma'am.
You don't want me to open it? Okay.
Yeah, you can. Yeah, sure. Yeah, sure. Yes, whoever's gonna, yes, everybody, yes. Are you?
My name is Greg Nelson. I'm a member of the Lord Nelson.
But we have to swear you first. We won't start the time until you're sworn, but if you're going to testify, we'll have to swear you as a witness.
Mr. Chairman.
Okay.
Should we just swear in everybody?
I do. So help me God. Okay.
Is
My name
there
is Greg
anybody?
Nelson.
I'm sorry, we're not starting your time yet. Representative Jones, do you have any witnesses? We can swear them in right now, if you'd like.
Me? May I ask if they were on the witness list that was supposed to be submitted to the?
I think,
I don't know. They're just.
let's deal with that.
You'll be able to object when they come,
Oh.
you'll be able to object when they come to the podium.
Well, the
We're just, because we're swearing them doesn't mean we're necessarily ruling that
Okay,
they're
just
going to
wanna make sure they're on the
be,
witness
sure,
list.
I understand.
So these are all the witnesses that were submitted. You have the list.
And they're on the list.
They're on the list, yeah.
Okay. All right, okay,
Yeah, so maybe, everyone comes up? Okay.
yes.
Excuse me, I want to make it a point that Representative Jones's witness list, again, was not given to us in time to see these witnesses were here.
Okay, but
We
I
never
understand.
received the witness list in time to know that these people were going to be here. We never received the evidence.
All right, hold on.
Evidence.
Wait a minute, is this,
Okay.
hold on. Oh,
Full discovery.
There you go.
I've never done that
We don't
before.
have this package. We have no package.
No, all right. Order in the room, please. All right, we'll swear the witness. I think we've already ruled on that issue, on whether these witnesses will be permitted. If there are some witnesses that are not on the witness list, you may make an objection, but right now we're just swearing these people in, and we'd like to be able to do that right now.
Mr. Chairman, before we start
Yes.
swearing them in, if we're swearing everybody in, we've got all Mr. Jones's people, and if we could also have everyone from Ms. Nelson's side, who's
Right.
here as a witness,
Right.
as well as both the candidates, if you're planning on giving evidence, stand up and we'll swear everybody
It
in.
was just me. I already did.
Okay, well, we're doing everybody again, so why don't you stand up, sir? Thank you. Okay, we're gonna just do it all at once, make sure we got everybody good. Thank you. Thank you, Mr. Chairman.
Just for clarity of the record, can everyone identify themselves?
Sure.
So that
That's
it's
a
clear
good
who
point.
is being sworn in?
Good point.
Just have everybody go to the podium and give their name.
Chandler Quayle, witness for Representative Justin Jones.
Representative Justin Jones, House District 52.
Joe Rita Justice, witness for Justin Jones.
Leneva Head, witness for Representative Justin Jones.
Laura Lavasser, witness for Justin.
Clara Snyder, witness for Representative Justin Jones.
Megan Robindorf, witness for Representative Justin Jones.
Melissa Moss, witness for Representative Justin Jones. Mulholland Robert, witness for Justin Jones.
Laura Nelson, Republican candidate in District 52.
Greg Nelson, Laura Nelson, committee member.
Okay.
Do you solemnly swear or affirm that the testimony you will give tonight will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay, all right. Mr. Nelson, you have the floor.
Okay. I'm going to present the evidence here in just a second. But I have to say, it's a little upsetting. If Mr. Jones would have come in with his petition, Representative Jones would have come with his petition 2 days after the deadline on April 4th, that would not have been acceptable. If there is a voter that wants to register to vote and there's a deadline before the election day and they come in after that date, they would get disqualified. So it is upsetting that we have a bunch of rules here. We have a timeline of deadlines here on this email, okay, from April 16th. This is a timeline of deadlines, and Mr. Roberts had most of the deadlines. The burden was on him, and then the different campaigns had a few other deadlines. Everybody met their own deadlines except for Representative Jones. He was delinquent. And because he was delinquent, we didn't get a chance to submit supplemental evidence because we weren't notified of his initial package until after the deadline on Friday. So I'm just saying that was really unfortunate how that went. And we didn't get due process because we couldn't submit our supplemental evidence. That being said, since we were deprived of that, what I'm asking is that we can use 2 of his affidavits as added to our signature evidence, because that's what I would have done. We didn't have the 2 days. We didn't even have the hour and a half after he submitted the evidence to be able to respond to it, because that's why we had the supplemental period, so that we can respond to the initial evidence. So at a minimum, I'm asking to use 2 of his affidavit signatures as our evidence.
All right. It's already in the record. I don't, you know,
Well, I
I don't
understand it's
see
already
any,
in the
I don't
record.
see any problem with them commenting on something that's already in the record.
This is your time to make your presentation. So
Yeah,
the
no,
inform-
and
so
I
the- sir,
am, and
if you
I'm
could not
asking-
interrupt me, sir, please, when I'm speaking.
Okay, well, I am
Sir,
asking.
please do not interrupt me when I'm speaking. I'm trying to answer your question, okay?
Mm-hmm.
That information is in the record, and this is the time that you can go ahead and make your presentation. And if you want to talk about information that's in the record, we're happy to have you make the presentation, however it is you want to make that presentation. And then we will ask you questions about your stuff after your presentation. But I don't want you to use your time in this
understand.
back and forth, because I'm sure you have a lot to say.
Well, I do, but I was asking permission to use 2 of the affidavit
That's
signatures.
fine. That's, yes,
That was what I was building up
yes,
to.
that's fine. That's
Okay,
fine.
that is okay. Okay, very good. Okay. Okay. So once again, my name is Greg Nelson. I'm a member of the Laura Nelson Committee. I am here today to discuss the signature evidence that was submitted by the Laura Nelson Committee to the Election Commission on April 24th, 9:30 a.m. There is no doubt that the petition signers are all registered in Davidson County to vote, and they reside in House District 52. The purpose of the Laura Nelson Committee challenge is to dispute the authenticity and legality of certain suspect signatures on Representative Jones' nominating petition submitted and dated on April 3rd, 2024. The Nelson Committee initial evidence package was submitted to the Davidson County Election Commission on the morning of April 24th. Our evidence is voter signature records that was provided to us by the DCEC, and we're using it to compare to the certain suspect signatures on the Jones nominating petition. We do have 2 other sources of evidence. One was what was just approved here, the 2 affidavits, and then the other one is from a quit claim deed that we found online, which was already been submitted. The original on-record challenge pertains to 10 specific signatures. However, due to limited presentation time tonight of 30 minutes, I will limit my discussion today to just 3 of these challenge signatures. So we're reducing it from 10 to 3. Number 4, Jennifer Bontusa. Number 8, Caitlin Bolt. And number 17, John Adam Sensenbrenner. Get a little cotton mouth, you gotta bear with me. So we're going to start with signature number 4, Jennifer Bontusa. Signer number 4 has her name misspelled on the print here line of the petition form. Red flag. Also, compared to her voting record card, her address is misspelled. When comparing the evidence signatures marked 4A, 4A, 4B, and so we see her signature. And let me ask, all the commissioners have a copy of the evidence, right? Okay. Okay, so we can see the one marked 4. We can see her unique signature.
Security number that's obvious for everybody to see. Can you shift the screen so that you can see the signature constantly?
Thank you.
Okay, well, anyways, it's my time. It's my time to talk, right?
Yeah, can we pause? Let's just pause
Yes,
for one moment. Everybody pause,
we're not going to
pause the time.
penalize, we're not going to penalize your time, but that's a legitimate
Let's just take the
concern.
screen down. Is it down off the big one? There we go. Okay, excellent. Thank you for pointing that out.
What was going on?
Well, but can we,
There were no socials on it. They were whited out.
there's no
by the
social
commission.
security,
There were no social security numbers on that.
there were no social security numbers
Well,
on
They
that.
were whited out
Okay, let's,
by the commission.
we are, okay, it's a phone.
The social security numbers were whited out by the Davidson County Election Commission.
Can we just, let's everybody take a deep breath for just a second, if it's okay, Mr. Chairman. I realize that everyone has very high emotions and we're all trying to get through this, okay? We're just not gonna take your time away while we're having this conversation. I appreciate the concern about someone's privacy and social security number going out all over the television. So if you can just give us a moment to take a look and verify that that was not indeed a social security number, we will go ahead and fix that and we will get your time back, okay? But I think this is gonna go a lot smoother if people aren't trying to talk over each other and talk over the commissioners, because I want you to have a full amount of time to present your case, and I want to be able to listen to it fully without people talking over each other, okay? So if everybody could just give us 30 seconds to verify that there was not a social security number, we'll be right back with you. Okay, do we have social security numbers in anything anybody gave? Okay. Okay, apparently, we have now looked at it as phone number. It's not a social security number. I appreciate the concern for everyone's privacy. We believe they're all phone numbers. Anybody sees otherwise, raise your hand, let me know, okay? Thank you very much. We can start the time again, Ms. Nelson.
Question. Point of order. Do we need to, I think we need to at least, run her back 30 more seconds with all that.
Sure.
Totally fine.
Oh, at least, yeah.
Absolutely.
Mm-hmm.
We would appreciate 50.
Yeah. All right.
Mr. Chairman.
Okay.
Mr.
Yes,
Chairman,
yes,
you know,
Commissioner Starling.
Yeah. In fairness, why don't we do a full minute?
That's fine,
Okay.
yes.
Totally
Fair
fine.
enough.
Thank
Yes.
Okay.
So it's at 24:39, so it needs to go to 25:39.
There, okay, all right, okay.
No.
No?
It needs to go back to 25, so she was at 24:39, you need to add a minute.
Well, that's what isn't that what she
Oh, we
did?
need to add a minute, yes. Yes, 25:39.
Okay, yeah. Mhm. Okay. There we go.
Okay.
Okay.
Okay for me to start, or?
Yes.
Okay, so we have the signature evidence here on these documents that the commission provided us with, and we can see it's a unique signature. And this one's a little hard to see because it's computer modified. Can we go to the next one?
Here, I can
Okay.
zoom it in.
Okay, this was the quick
Hang
claim
on.
deed I was referring.
No,
Okay.
here's voter card number 1, voter card number 2.
Right,
Voter card number 1 is handwritten. Voter card number 2 is an electronic mail-in ballot.
okay, let's go to the next one.
So on 4, you can see Jennifer Bontusa's printing, how she prints her name.
And signs it.
And by the way, she prints her name with 2 N's. On the petition, the nominating petition of Mr. Jones, whoever signed her name
Printed her name.
and printed her name incorrectly. Printed her name with 1 N instead of 2 N's. And then signed her name inconsistently without a match on the following evidence.
Okay, so we have 2 signatures there, and this one here in the middle is the quick claim deed, and towards the top is her signature again. It's the second signature down. It's totally consistent with the other 2 signatures that we just looked at. And then we just got permission to use this here, and if you could pass that and just confirm that that signature matches up with the other 3.
So this particular sample of Jennifer Bontusa's name in handwriting from Representative Jones's affidavit shows Jennifer's handwriting, and she spells her name Jennifer. Also take a look closely at the signature. That very signature that Representative Jones obtained from Jennifer last Thursday, April 25th, looks exactly like the voter cards and the public document referred to as a quitclaim deed. A quitclaim deed is a public document that can be downloaded or received or paid for as evidence in procedure and policy legally.
Okay, so let's go to the next slide. Okay, now we see her signature up here on number 4. You see her name is misspelled, like Ms. Laura said, and right above it is the signature. It doesn't look anything like those 4 signatures that we just looked at, so I'm assuming that you all have a copy of the petition signature, number 4. It doesn't come close to the 4 signatures.
Is Miss
right?
Jennifer Bontusa here? Okay, I didn't think so.
Okay.
Pardon me for just 1 second. If we could just refrain from talking to other people in the audience. Your time is to make your presentation to us as the commissioners, and I think it'll go a lot smoother if we just keep us talking to us, okay? Thank you.
We showed the 4 signatures on record that were evidence, and then comparing it to the petition, it doesn't look anything like it. Her name was misspelled. And additionally, the pen, ink, and handwriting style appear nearly identical to signature number 3 on the petition. So just wanted to make that point. Okay. Signature number 17, we're going to cover three different signers here, John Adam Sensenbrenner. I would like to discuss signature number 17 in detail. Let us remember that this challenge is a petition signature challenge. The signature on line 17 of the Representative Jones petition is not a signature, it's 3 initials. It is not an initial petition challenge. Now, if signature evidence 17, okay, which is in front of us, in 17A, and then we also have the affidavit that we just added to the evidence as well. We have 3 very defined signatures, first, middle, last name, on all 3 of them. Did we go through all 3 of them? Okay.
Yes, we did.
Okay, good. And so, let's see where we are here. They're all, okay. I would concede that initials could qualify for a signature if that's the way it was on the records with the commission, but that's not the case. We had three very similar signatures and very unique, and they all coincided with each other. But once again, if we look at the petitioner on line 17, it's 3 initials.
I'd also like to add, if you take a very close look at print here on number 17, print here, John Adam Sensenbrenner, somehow, we don't know who signed this, but they signed Sensenbrenner. If you look at the D, and then you look how he spells his name, if that were the case, if you look closely, his Brenner B looks like a B everywhere else. On this petition, it does not look like a B. There is a difference between a B and a D, and that is a D.
Okay. So I just want to define initial versus signature. An initial is the first letter of each word in a full name. A signature is defined as a person's name written in a distinctive way as a form of authorizing a document. And we see that the signatures that are on file with the Election Commission, they were all consistent. They were all signatures, first, middle, last name. It wasn't initials. And because of that, we feel that this should be disqualified as one of those signatures. Now, we have one more to look at, and it's signature number 8, Caitlin Bolt. The evidence, we have 3 different signatures that were on file with the Election Commission.
Come to the microphone.
Once again, they all look similar, and they all look unique. And this was another initial. So same as signature 17, initials are being used here. Once again, this is a petition signature challenge. Initials are not signatures. We just discussed that, unless that is the way the person signs their other documents. We have document 8A and 8B. And as with the previous 2 evidence signatures discussed, we see similar and unique full name signatures on the evidence documents provided by the Election Commission. Ms. Bolt did not sign this signature petition, but she initialed it. Her historical signature from the Election Commission evidence was not signed the same way on the signature petition. It was initialed and should be disqualified from the Representative Jones petition. And that concludes our evidence.
Yes, commissioners, now's our time to ask questions. Commissioner Hertzfeld, you're recognized.
Sure. I just want to make sure I understood. So I think initially, because there's been a lot of back and forth communication, and apologies, I've been trying to make notes and keep up, but I want to make sure I understand 100%. So initially, when you'd submitted your challenge, it was for voters, for petition signers, number 4, 5, 8, 9, 11, 12, 14, 17, 18, 19, and 22. Is that right?
Yes.
Okay, and are you still challenging all of those signatures? Because I think you just talked about a subset of them.
We did not think we would have enough time to do all 10 today with a short 30 minutes. So we're just focusing on the 3.
Just on the 3, okay.
On the 3.
I think you still have time, so if you want to present evidence that you have on the others, I don't want you to feel limited in any way, because if you don't present any evidence on those others and we limit it to the 3, I think we only have 3 that we can consider.
Yes, that's how we want it. We want the 3 considered, and that's all at this point.
Okay, so
We were shorted our time to provide supplemental evidence, as Representative Jones did not meet the Wednesday, April 24th deadline for his evidence to be submitted, initial evidence. We were discriminated against, I was. The fact that he turned his evidence in on Friday at 10:22 a.m., which was April 26th, and the first notification I received from the Davidson County Election Commission was at 12:11 p.m. on Friday, with the beginning of evidence 1 through evidence 4 from Representative Jones.
Okay, Ms. Nelson, I don't mean to interrupt you, but I think we've already ruled on that issue. So I'm trying to get to the questions about the signatures that you have, and I just want to make sure I understand.
We're concluding with those 3.
Okay, and if so, you are withdrawing your challenge to the other 7.
That is correct.
Okay, so it's just the 3. And other than the evidence that you've just presented, which is, this signature doesn't match this signature, right? Like looking at them one to one. Do you have anything else to submit for proof that those signatures are not valid?
We do not.
Okay, those are all my questions. Thank you so much.
Sure.
And the PowerPoint was very nice.
Thank you.
Any other questions?
Point of order, Mr. Chairman. I don't have any questions of the Nelsons, but I just want to make sure that at the end after we've heard from Representative Jones and asked him any questions we might have, there'll still be an opportunity for us to ask questions of legal staff with the coordinator. Is that correct? As we deliberate?
Yes, I'm not sure whether we do that in the open or whether we ask them. I think we have to ask our questions. Yes. Yeah, we'll have that opportunity.
Yeah, just want to make sure. I thought so. I just want to make sure.
Sure.
Your hesitancy scared me there for a minute.
All right. Yes, State Coordinator Goins.
I just want to make sure, Ms. Nelson, what you're saying is that you only want the Election Commission to consider 3 signatures. That means the rest of the signatures that you have challenged are not going to be deliberated on today. Is that what you're saying?
Yes.
Okay, thank you.
All right. We are now at the point, Representative Jones, for your 30-minute presentation.
Thank you, Mr. Chair. The truth is powerful and it prevails, which is why we've got down to 3. I'm not going to play amateur CSI. I'm going to call the people up because each of these people's names was published in the media and they were slandered by this candidate. And so I'm going to bring each person who they challenged on this petition because that was submitted as evidence and have them come explain how they signed this petition. Because I don't have my spouse or a family member to testify on my behalf. We have the people of District 52 who signed this petition. And we also have a notary public who observed them sign the affidavit, check their ID, check their identification, and is certified by the state as a notary public to validate their signature. And so let's go through the list. If we can start with Ms. Jarita Justice as a witness. According to my opponent, and this is just to show how absurd this whole thing is, according to my opponent, and Jarita Justice, the signature on the voter registration card and the nominating petition do not appear to match. The T was not crossed, the I was not dotted, and the E does not curl the same as it appears on the voter card. This is what they said about Ms. Jarita Justice. Ms. Jarita Justice, would you please come forward and explain, respond to their challenge of your signature?
Mr. Chair, I just wanted to make a comment.
Yes, you're
Before
recognized.
this commission,
Point of order, can we stop the time?
Yes.
so it's my understanding that the challenger has withdrawn 7 of the initial
Right.
signatures.
Yes.
So really, at this point, really what's before the commission,
Ms. Justice is not one of the 3 that's being
Right.
challenged.
it's just number 4.
You know, you may do whatever you like,
Yeah,
but
I'm going to use my time. I wanted to show how frivolous this complaint is, and so I'm going to bring up each person. And it is a witness who was approved and submitted prior. And so, is this a member of the commission? Are you a member of the commission?
no,
Okay.
Ms. Ecke is our lawyer from Metro Legal, so she advises us on the law. But I think she just raised a point for efficiency purposes. If you want Ms.
I would like
Justice
to
to testify,
Yes.
that's fine.
I would like to use my 30 minutes to show just the pattern of frivolousness and absurdity of this challenge. And so, Ms. Jarita Justice, again, they said that the T was not crossed, the I was not dotted, and the E does not curl as the same as it appears on her voter card. Ms. Jarita Justice.
Yes. Do y'all have a copy of my signature that they challenged?
Yes.
So
Yes.
you're looking at it now?
Well, I can't say that. We have a thick stack
If you
of
would,
documents.
I would love for you to just pull that up. We're talking about frivolous here, so it's worth it. Pull up my signature from when I signed the card. I moved to Davidson County in 2002, I think, after whatever. So we're going back to 2002. I bet everybody's signature has changed since 2002. And especially when you sign a petition after work, probably 6:30, I don't know what time it was. But, you're just signing. And if you compare the signatures, I think you'll notice from the petition I signed and the 2 cards on file are pretty close. And if I was blowing and going, sometimes, you just don't get that cross the T. So that's what I wanted you to actually see right in front of you. And that's the reason we're here spending time tonight, is because of that challenge. And I'm just one of 10. And I think the reason who knows the reason there. But that's why I was asking originally, do y'all have an opportunity to look at these signatures and decide before we ever get here in this arena? I was just curious about that, because I think anybody can look at it and wonder why that it was ever challenged.
Anything further?
So I don't get to ask the question.
Well, this is your chance to put on proof.
Yes. Well, I guess we'll
Okay.
just go through the list and then we'll go through.
Okay. But that would that's what I wanted to know, if you could just answer that question for me. I didn't know if you had the opportunity to ever look at and compare the
We've got a
signatures.
thick stack of documents here, and yours is right here on top.
So, okay.
We ask questions later.
Yeah, I
Right now,
mean,
it's just
we're-
a presentation.
Yeah.
Right.
Thank
Okay.
you.
Thank you. And we're just showing a pattern because the idea of voter and election integrity is brought up. And I just want to show that this is really about trying to intimidate people. They had us go knock on people's door to get a notary public to validate their signature because they came up with this concocted list that was rooted in falsities and fiction. And so we're going to bring the people up. So the next person we have is Ms. Laura Lavasser. They said that her name is Laura Ann Dibble Lavasser, and she missed one of her middle names on her signature. This is the complaint.
Hi, I was not aware that whenever someone brings a petition, you need to sign your 100% full name. I typically sign with my first and last name. My voter registration card has my first, middle, and last name, but it's still me. I happily sign the affidavit. I think this is a complete waste of everyone's time, and it's unfortunate that I have to even say this.
Thank you. Thank you. Next, this one is actually deeply concerning because they falsely accused this signer of being a felon who's not a felon. Ms. Roberts, they falsely accused that she was a felon, and that was slander, and it was inaccurate, and it was wrong. And so if we turn, point of order.
Everybody,
Point of order.
direct your comments to the commissioners. This is your chance to make your case to the commissioners.
And so this one, sorry, let me just go through here so we can. They say the voter card indicates that she is a convicted felon. This is the evidence submitted by my opponent. And they're saying that there's issues also with the signature. But the thing that was just so offensive was falsely saying that she was a felon. And is it racial profiling? I don't know, but it was wrong. And so,
I am not a convicted felon. I've never been charged with anything. And that is my signature. Is that it?
yeah, that's, thank you. Thank
Anything
you.
else?
That's it. Thank you. Thank you. The next person they challenged another deeply concerning one. This is somebody who is a newly registered voter, 18. This is their introduction to the election process. Ms. Claire May Snyder, who they're challenging, somebody who just is getting involved in democracy, and this is their welcome. I mean, it's shameful. But they're saying that the signature does not match, and that when they looked up on benverify.com, I don't know if that's an official website, but this is the website they went to. benverify.com did not show evidence of Claire May Snyder residing at the address listed. So thank you for being here.
I'm Clara May Snyder. I've lived at my house since the second grade. My parents are here. They know that I also live there. And that is my signature.
Thank you. Thank you. And thank you. So I just want to take a moment, I have 23 minutes, just to apologize to the people of District 52 that you all had to show up here for this absurdity. But we know that the truth is powerful and it prevails.
Mr. Jones,
Please
direct your attention to us.
Yes, sir. Thank you.
We want to hear your evidence.
Thank you, sir. The next person I would like to bring up, and sorry, I'm trying to read, if Chandler can come up real quick, I'm trying to read your handwriting. How about? Okay, thank you. The next person we want to bring up is, I'm going through the complaint, trying to make sure we get everybody. Megan Roggendorf. And for Megan, they're saying the signature does not match the signature submitted on the voter registration card, and that the handwriting does not match either. So they're saying.
I moved to Davidson County 15 years ago and have since had 2 children. One of them is with me. He's 14 years old. My last name is Roggendorf. So when I used to sign my name, I used to sign it Megan Roggendorf, and then I had 2 children. And so my signature looks like this. So it is my signature. I happily signed it and then signed the affidavit.
Thank you.
Yes.
Thank you. Thank you. So the next person that they challenge, Pauline Barocas. Miss Pauline. And for anybody not here, because some people had trips planned, we also have, I want to bring up at the end, the notary public who went to everybody's house, looked at their ID cards, watched them sign the affidavit. And so we also have a notary public here who I want to bring up to testify. Am I missing anybody who's here? Melissa, yeah, sorry, thank you. Melissa Moss, sorry. This is not my handwriting. I'm sorry. And we have Melissa Moss here as well. And for Melissa, and Melissa also has a Ring video of signing the petition from her Ring doorbell camera as well of when she signed the petition, if you would like to see that. But for Melissa, they're saying that 4 voter registration cards conclusively established that the signature and printed name on Jones' nomination petition are not a match. The handwriting on Jones' nominating petition does not match the handwriting on the voter registration card. And so, Ms. Melissa Moss.
Thank you for your time. Thank you for your service. I was there. I happily signed it that day and happily signed the affidavit saying it was my signature. Thank you.
Yes, the chair recognizes State Coordinator Goins.
So I do have a question. I'll be honest, when I saw your signature, it does look substantially different. So what is there, when did you change it? Because if you're looking at the records, it does, would you admit that it does look different?
It was a slanted clipboard, 6 o'clock, rushing, signed it.
So the next question, you signed an affidavit, correct?
Correct.
Is the affidavit that you signed correct?
I signed the affidavit.
I mean, is what you wrote on the affidavit correct?
Yes.
Okay.
That I signed this signature?
Yes.
Yes.
So you, in your affidavit, you say you signed on April the 1st. However, the challenge signature for number 8, which is before you, says they signed the statute that they signed on their affidavit that they signed on April the 2nd. And then if you look at the challenge signature for 17, they state that they signed on April the 2nd. So how does that work? You're sandwiched in between two people where you are saying you signed on April the 1st, but they are saying they signed on April the 2nd.
They didn't obtain signatures on, can you not obtain signatures on multiple days? I don't know. I know I signed on the 1st.
Do you see what, so when you signed it, were there signatures already after your signature?
I don't remember.
I mean, it just doesn't normally flow that someone would sign number 8 on April the 2nd, and then they would sign, on the 12th or 13th signature, whichever one you are, on April the 1st, so you go back a day.
I think these questions are better for me. If you want to direct those on behalf of the Secretary of State, Mr. Goins, you can ask me because we were the ones who collected the signature. So you can ask me how that ended up, because the challenge is based off their signature. And so your questions have nothing to do with the signature, which is why we're here saying that the signatures were fraudulent. Now you're trying to play semantics and games about the petitions being signed. And so if you want to ask questions about how we obtained the signatures in the order, you can ask me, Mr. Goins, and I'll be happy to answer your questions.
So Mr. Jones,
Representative Jones, you're out of order. This is the state coordinator. He's allowed to ask the witnesses questions. That's part of our procedure. He's not doing anything wrong by doing that.
Mr. Goins, wait, pardon me for 1 second. Can I be recognized?
Yes, you're
Okay,
recognized.
thank you for recognizing me. Is there a way we could let him finish his presentation and then do the questions during the questioning period?
Certainly, but she is the one that signed the affidavit. And if her affidavit is true, and she stated that it is, April the 1st is it is very central to looking at some of the other signatures. So I think I've established it. I may have more questions for Representative Jones, but this is the written evidence that is submitted to the record, and he chose to bring up this witness.
I know Mr. Goins is the chief of voter suppression, so I'll happily answer your question, Mr. Goins, when you want to direct that to me. I know you're used to kicking people off the ballot and suppressing votes, but today the truth will prevail. So I'm happy to answer your questions when I reclaim my time.
Mr. Chair, can I be recognized, please?
I know you like to throw those things out, Representative, but I'm looking at a document. The document says April the 1st. I'm not questioning anything else other than documents. These are the documents that you submitted.
I don't know if you've ever had a petition, but people can skip around where they sign too. And so the challenge is based off of their signature. So you have nothing to say about the signature, but now you want to say, oh, somebody signed ahead of you and after you, which is not what is being, which is not the challenge today, which is not a basis to kick somebody off the ballot.
Representative
but today,
Jones,
Mr. Goins, today.
You're running time off the clock. This is your time. This is your time to put on evidence.
Okay.
And
I'm reclaiming my time from Mr. Goins. Reclaiming my time.
We want to hear the evidence. And how much time has been expended?
Chair, so the last 2 minutes clock wasn't running. It's running now. So he basically had a free pass to have that conversation.
All right, so no time was running.
It was not. I was looking at it. Thank you, audience.
All right, okay.
But it was not running until she just started about 15 seconds ago.
All right. Okay.
So.
For the sake of time, if he wants to cut off 2 minutes, you can give me 5 minutes and I'll tell the truth and make sure that to show you how ridiculous this is. You can give me 1 minute. So whatever you want to take off, sir, go right ahead. But I'm going to continue with my presentation. Next question. I'm going to continue bringing up the list, Mr. Goins. And so at this point, I would like to bring up the notary public who went to every house, looked at their ID card, and watched them sign the affidavit that you're asking questions about. And so Ms. Leneva Head, notary public and attorney, state of Tennessee.
Hi.
Hi.
I'll clarify, I'm a lawyer. I'm not a practicing attorney yet, but I am a notary, and I own a real estate firm in the city. So, you just want me to?
I guess just talk that every one of the 10 people went to with the affidavit.
Okay, so on April the 25th, we did go to the homes of each person listed and challenged, knocked the door, explained the purpose of our visit, which was that there was a challenge to the signature, the details of the challenge, and asked them to sign an affidavit affirming that they did in fact sign the initial petition. They did so. They signed the affidavit. I reviewed and watched them sign. I reviewed their ID. Some had passports. Some had restricted licenses due to age. Everyone else had Tennessee driver's license. The signatures lined up. I signed the affidavit accordingly for each person, and you have those 10 affidavits in your records. They also signed the notary logbook so that I could track that I did verify ID, the type of ID, and I had them write their own names in print, sign a date, and list their address to keep track of the document. So that is what happened on April 25th from 7 p.m. till approximately 10:30 p.m.
Any questions?
No questions. Thank you.
Thank you.
Thank you. And so what we've shown is that every single list and signature on that list that's being challenged was notarized. I believe I'm the only candidate in the state of Tennessee who had to go with a notary public to get people to show their ID cards, to verify their signature, and have it officially stamped and submitted as an affidavit. The members of this commission have a copy of each of those 10 affidavits. There is proof beyond a reasonable doubt that each of these people are who they say they are. Legally submitted proof. And so I'm happy to answer questions. Representative Goins, former Representative Mr. Goins asked, how did somebody sign in the middle? And sometimes when you have the petition, you notice people are in a hurry at night and they will skip a space. So we'll say, make sure you sign there so we can fill out the whole paper before we turn the page. And so I don't know if you've done petitions before or if you've had people.
Representative Jones, are you done with your presentation?
No, I'm also submitting this as evidence. I have 12 minutes. So
the way this is supposed to work, and we spent a lot of time setting this up, is that you make your presentation and then the commissioners and the staff get to ask questions.
Okay, I'm not done with my presentation, so I want to reclaim my time, the 12 minutes I have left. I'm not finished with my presentation.
Well, then, fine, go ahead with your
Thank you.
presentation.
Thank you.
But there isn't a place in the presentation for you to question
I'm not
Commissioner
questioning, I'm
Gomes.
responding. But I'll move on.
Okay, all right.
The second part of this challenge was that my opponent challenged the name of Forest Avenue in East Nashville. I submitted as evidence the Metropolitan Nashville Davidson County ordinance changing the name of Forest Avenue with 2 R's to 1 R. They said there was only 1 R. If you look, Metro Nashville City Council and the Historical Commission made that change. That is submitted as evidence. I also have submitted as evidence an email from the Election Commission, Ms. Kelly, verifying the signatures the day before the deadline date. So we were verified by the staff, the independent staff of this commission already. And so I would like to submit that. I submitted that as evidence. And what I want to end by saying, because I have 11 minutes, and so we're going to use this time, is that as I drove over here today, I thought about what this is really about. Every single one of the signatures that they are challenging, we have submitted official affidavits. They have made slanderous claims that those were fraudulent signatures, but we have brought you physical proof that those are authentic, legitimate, notarized signatures. Many of the people my Republican opponent asserts did not sign the petition, even standing in this very podium, are in fact in the room with us today. And so what is this challenge about? This challenge is about silencing dissent. It's about sowing distrust in our elections and distrust of our own election staff who verify these petitions every year. It's about a pattern of political harassment. And since August 2022, this will be my 5th election. Every time I have submitted petitions and won. Last election, I received 78% of the vote. My opponent who came before you today received 22% of the vote. So what is this really about? It's about trying to undo the will of the people of District 52. 78% of the vote, despite all the money they tried to use against me, despite all the money they tried to use against us. And so what do? They connive and concoct and conspire these backhanded attempts, cheap attempts, pitiful attempts, desperate attempts to try and steal power from the people. And they should be ashamed. This challenge is about desperation, and it is the hope of my opponent that the members of this commission will ignore the evidence before them and do the wrong thing or vote according to partisan lines. But I let the commission know today that no matter how you decide this challenge, the voices of the people of District 52 will prevail. That if we have to write in, we will win. That if we have to run the harder ways, whatever you tell us to do. We went knocking doors at 9 o'clock at night and the people showed up. You can't stop the power of the people. No matter how much you cheat, no matter how much you lie, the truth is powerful and it prevails.
Mr. Jones, you can reclaim your time, but I just want to make sure that you have a chance to address the contentions about Ms. Bantusa,
yes,
Ms. Bolt, and Mr. Sensenbrenner, because your challenger has restricted her challenge to those 3 people.
Yes.
And if there's any more evidence you want to put in on those, I want to make sure that you're given a chance to do that.
Yes. John Adam Sensenbrenner, notarized affidavit, signature. I, John Adam Sensenbrenner, signed the petition for Justin Jones on April 2nd, 2024, signature of affidavit, date April 25th, 2024, notarized State of Tennessee Public Notary, Leneva Head. My commission expires 11/3/2025. Jennifer Bantusa, I, Jennifer Bontusa, signed the petition for Justin Jones on April 2nd, 2024. That is my signature and handwriting on the petition. Signature on this affidavit, notarized, Leneva Head, State of Tennessee Public Notary, and this was on April 25th, 2024. Caitlin Bolt, I signed the petition for Justin Jones on April 2nd, 2024. Sometimes I sign with my initials versus full name. Notary Public, Tennessee State of Tennessee, Leneva Head. This was dated April 25th, 2024. Also, if you look at your packet, each of the 10 people challenged, you see a picture of them with me at their door signing these affidavits. Do you see the pictures? You have the picture of each of these people who signed the affidavit. You can look up their ID cards, which they all had to present to the notary public as part of the process.
I do want to be clear that these 3 individuals that have been challenged, I did witness their signatures. They did sign the log accordingly. I did check their identification. Photographs were taken with each person as they were signing with their ID for the record. Thank you. Sorry for
Thank you. Thank you. And so that is the evidence that we're submitting today. That is what is before you. You have it in your folder. And I know that regardless of how the vote happens, I know that the truth has won and that the people of Davidson County have seen the circus that was put on around this frivolous complaint, and that the evidence is before you, and that the reason it's dropped from 10 to 3 is that they decided to pick the 3 people who cannot be here in person today. But it's okay because their affidavits are submitted to you, their photos are submitted to you, their identifications were checked, and so all the evidence has been submitted. In the words of a famous attorney, I rest my case.
Commissioners, this is our time to ask questions. So take your time. You may not want to look at some of the materials. And commissioners, at this point, we have three names that are at issue. That's Ms. Bontusa, Ms. Bolt, and Mr. Sensenbrenner. AOE Roberts has pointed out to me there are 2 Ms. Bontusas. We are looking at Jennifer Bontusa.
Point of order, Mr. Chairman.
Yes, sir.
At what point will they be making their 5-minute closing? Do our procedures not provide for a 5-minute closing for each party? And do they do that before we have our deliberations, or?
Under our procedures, they get a 5-minute closing after we ask our questions.
So are we asking questions of Representative Jones at this point? Is that
We
what's-
can, or any of the witnesses,
Okay.
any of the witnesses that are here.
So you can ask questions of both parties at this point.
Yes.
Then we'll come back and have a closing statement from both parties. Then the commission will have its deliberation and vote.
And it's during the deliberations that we're, again, I'm sorry for asking the same question again, but I just need to make sure I'm getting my clarification right in my mind. When we do our deliberations, that's the time for us to asking questions we may have of Coordinator Goins.
Right.
Or
Yes, sir.
Keiki.
Yes,
Okay,
yes.
thank you.
Does anybody have any questions for the challengers?
I don't have any questions. Thank you, Mr. Chairman.
I do not have any as well.
I do have a question. Representative Jones? So you took pictures with all the people who have affidavits in this packet we have, correct?
Correct.
Can you identify the three people, Sensenbrenner,
Yes. If you give
Bolt,
me. Yes.
and Ontusa?
Yes.
The first one,
That photo right there is Adam.
okay, this is him?
That's him. That's Adam.
Okay. Yeah. That was number 30. Yeah, that's all I was trying to get there. That's number 30.
Thank you, appreciate it.
Continue, Representative Jones?
Yes. So page 30 is Adam.
Okay. All right, is Catlin Bolt?
Yes. That's 32.
32.
Page 32.
Caitlin, I'm sorry.
And 33 is Jennifer Bontusa. Sorry, 34 is Jennifer Bontusa.
34.
Yes.
34 is Bontusa.
I believe 30, yeah. They live by, yeah.
Okay, so just for point of order, so number 30 is Adam Sensen. I'm sorry, that is Sensenbrenner, correct?
Yes.
All right.
Sorry, give me 1 second.
Sure.
I want to make sure that we're
Please.
completely accurate. So 30 is Adam.
Okay. Thank you.
Please ask one question. Yep, that sounds right, yep.
All right, so take the microphone back and so everybody can hear.
Yes, sir. We just wanted to make sure that we were sure. So that was correct.
So which one's, so,
So page 30 is Adam.
thank you.
Page 32 is Caitlin Bolt. And page 34 is Jennifer Bontusa.
All right.
Thank you.
Hold on, I have another question. And for point of order, neither of the three of these are here tonight, correct?
For point of information?
Yes.
Yes. So they all submitted an affidavit, but they were the three who we said we could not make it today. But they did submit the signed affidavit.
I have those.
The notary public witnessed them sign it and looked at their identification card.
Okay, just
Yes.
make point of order. Thank you.
May I respond to something else about that, sir?
Go ahead.
You said that these three could not make it, and I think that was the hope of this challenge, was that people would not be available. So we did the affidavits, we got them notarized, because not everyone has the convenience to come after work and be here in this commission. And that is something I just want to point out, this is a point of privilege to be able to come here and to show up, and that it's putting this undue burden on the people to prove their signature when the burden of proof should be on the challenger and not on us. But we went above and beyond to show our proof. But the burden of proof is not on me, sir. I just want to make that clear, that under this process, the burden of proof is on my Republican challenger. So thank you.
Are you, Commissioner Davis, are you done?
Well, I just wanted the clarification because we had the
Right.
pictures and I had no idea who these people were. So
Okay, all right.
I wanted to make sure he addressed everyone that's in the
Right.
challenge.
Okay. Representative Jones, I have a question. Looking at the nominating petition for Jennifer Bontusa, one thing that stood out to me was that the name Jennifer is spelled with one N on that petition and yet spelled with two N's everywhere else. Do you have any information, and especially do you have anybody here with personal information about why it's spelled with one N on the petition?
I would like to bring up Leneva Head, Notary Public for Tennessee.
Hi, good evening again. On my log, Jennifer Bontusa's name is spelled JENNIFERBONTUSA in print and signed accordingly with her signature.
Right. But my question is, on her nominating petition, it's spelled JENIFER. And is there any explanation for that? And the challenger has made a real point of that in her papers, and it's not addressed in the affidavit.
So if we look at, let me respond, let's see. Sorry. So the first part of the challenge for Jennifer Bontusa is saying that that is not her signature, that it does not match, and that it's missing an N. On this affidavit that Jennifer Bontusa signed to give to you all, she said that she signed this petition and that is her signature and handwriting on the petition. So Jennifer Bontusa signed this affidavit under oath, that I, Jennifer Bontusa, the undersigned affidavit, being sworn hereby certify that the statements made below are true and correct. I also understand that these statements are made under oath and are subject to penalties of perjury. I signed the petition for Justin Jones on April 2nd, 2024. That is my signature and handwriting on the petition. So the only thing that we can say is that she, like many people, was in a hurry to sign the petition, but she's telling you on this affidavit that you all told me to get filled out by her and to get notarized, that she signed it. You have a notary public here who's telling you that she looked at her identification card, her Tennessee state ID, verified her identity, and watched her sign this affidavit attesting to that being her signature. And so the question before us is that her signature? And this witness has told you that that is her signature, has signed a sworn affidavit under penalty of perjury that that is her signature, has had a notary public check her identification card to prove that is her signature. And so that is all the evidence that we submitted to you all to prove that Jennifer Bontusa did in fact sign this petition and that that is her signature. And so we submitted that as evidence to you.
Right, but you were aware that this was an issue when you went back and had her do her affidavit. Did you consider whether or not putting in her affidavit something like, well, you know, I go by Jennifer sometimes as a nickname. I go with one N. I'm known as Jen, or something.
No, the thing that we want to tell people was that there was a claim that these signatures were fraudulent. That was the claim, the assertion that was made by the challenger. So we went with an affidavit, and so this person has signed an affidavit telling you that she signed this petition, that is her signature. That is beyond a reasonable doubt proof that she signed this petition. That's what this challenge is about. And so now the question is that it's somebody in a rush in the evening had a letter missing, but then signed an affidavit afterwards. And the issue that we have with her signature, if we look at this, we submitted the evidence, so we'll leave it at that. You have the affidavit before you as evidence. You can look at the affidavit. You can see if that was sufficient. That's what we were told by Director Roberts, to get these affidavits, to get them notarized. We went through your process and got them notarized and submitted that. So.
Yes, the chair recognizes Coordinator Goins.
So what's a little troubling about the affidavit, though, when you look at the signature on the affidavit, it still doesn't match the signature that's on the petition, which is also on the voter registration forms, which is what we look at.
So what the Secretary of State's office is asserting, working for Secretary of State Trey Hargett, is asserting that this person, you're saying that they committed perjury by signing this, because you're saying that this is not true. And that is a very charged complaint. Let's just lay the facts out. That somebody signed an affidavit under penalty of perjury, got it notarized, had their ID card checked by notary public, and you're saying that that is not sufficient and that maybe they didn't sign it.
That's not what I've said.
And so people have.
I ask a question.
And I just want to have a point of clarification too, Mr. Chair. Is Mr. Goins, and here under the capacity of the Secretary of State Trey Hargett, is he deciding on this case? Because under the process, I understood that the commissioners were deciding this case. Is the Tennessee Secretary of State also a party to this case and going to be deciding it, or is he here under an individual capacity?
Under Tennessee law, the state coordinator's office has supervisory responsibilities for this election commission and is particularly for hearings of this nature. So he is here in that capacity. The 5 commissioners will make the decision, but we may ask him for his advice on matters of law, just as we may ask the Metro legal counsel for advice on matters of law. And he is permitted to ask questions.
Okay, I just wanted clarity for the record, because I'm just curious if the Secretary of State sends somebody to every election commission meeting for every election county commission in the state, or if he's just choosing this one because this is being derived from people in the state of Tennessee Capitol. I don't know. I just want to get clarity as to that. I'm happy to answer his questions, but I just want clarity as to whether the Secretary of State asked you to be here, the Speaker of the House, who asked you to be here, because you work for the state of Tennessee under the Secretary of State.
Representative Jones, this is under our procedures, and you were advised of this. This is our time for the commissioners to ask questions. It's our time to ask questions, and we're trying to make a decision.
And he is not a commissioner. He is not a commissioner.
But he is also allowed to ask questions. So let's just stick with the procedures we set forth. Did you All right, go ahead. Yes.
Well, for the record, the Tennessee General Assembly is the one that gave me the authority to be here in the Tennessee Code. In a law, I think it's passed in 1972.
The Speaker of the House, okay.
1972. And the Tennessee Supreme Court, to answer your question, anytime there's a qualification hearing, either myself or the Assistant Coordinator of Elections attends those. Typically, it's me. And this is actually a Supreme Court case that focuses on the Election Commission and the Coordinator of Elections being there jointly doing it. So to solve any conspiracy theories or anything like that for me being here, it's Tennessee law and it's the Supreme Court of Tennessee. I do have one more question. How often do you misspell your name?
How often do I misspell my name?
Yes.
I have a name with a double letter in it.
Ma'am, we're talking about Ms. Bantusa. I'm sorry, you're out of order. Do you have any personal information about Ms. Bantusa and the way she signed this? That's what we're trying to work on right now.
That's the question is, are you, the director of the elections, Mr. Roberts, said get these affidavits. We got them notarized. You have the person before you. Now we want to play games, but it's okay. Do I ever spell my name wrong? Sometimes when you're in a rush, you misspell them. In fact, we get bills all the time, Mr. Goins, where words are spelled wrong, including from that General Assembly that gave you authority to be here. They're called amendments. And so we make often grammatical amendments. We make amendments to spelling multiple times. And so that is how the process works when you're doing things, and which is why we went above and beyond and got this affidavit. And so do people make mistakes? Check your own office about the people you accidentally purged because they had a wrong letter in their name, who then went around and said they are rightful voters in Tennessee, and you had to correct that mistake, or because they had the same last name and same first name because of cultural differences. Think about how many times you've been challenged in court because you accidentally purged the wrong person, and then ask us if people make mistakes, because yes, people do make mistakes, including your office, including our office, including regular everyday people.
All right, Mr. Jones, did you talk to Ms. Bantusa about this mistake, and did you consider bringing us some evidence?
Yes,
about
we brought you evidence.
Hold it, let me finish, about this misspelling.
We brought you evidence saying that she signed the petition and that is her handwriting, that is her signature. If you want to challenge the affidavit that she's submitting saying that is her, then you can do that.
Sure, I'm just asking simple questions, and if the answer, excuse me, if the answer is no, I didn't think about that, that's fine. I'll accept your answer. I'm not here to argue with you. I hope everyone in the audience understands that in the case that's coming after this one,
so
there is
the notary
excuse me. In the case that's coming after this one, there is a handwriting expert that's going to testify, and he's brought in by Mr. Mitchell.
Yeah, but that's not germane.
And he is going to go in great detail into some of these same issues. There's nothing improper about people doing this. We give all the candidates a sheet with places for 175 names to be written in, and this one, there were 26. It's clear there's not even an issue that now we're down to 25. That's a bare minimum. So,
which was certified by your election commission.
Nobody on this commission,
which was certified.
Nobody on this commission decided to turn in 25 names. We're just wrestling.
Were they
we're
certified?
Just wrestling. Excuse me,
we're not going to
Mr.
do,
Jones.
They were certified.
Mr. Jones, you're out of order. I'm trying to explain something to the audience. You're trying
but
to.
It's not germane.
Excuse me.
It's not germane to why we're here.
Representative Jones, you're trying to inflame them as if this commission is against you. We're just asking some questions so we can get on with making a decision. Nobody's against you here.
Sir,
it's just
sir, we heard the voicemail at the beginning of this meeting.
It's just an anomaly that you got this misspelling here, and nobody has explained it, even though the challenger brought it up and made a big deal about it in her papers. So I'm trying to figure that out. That's one of the things that caught my attention.
Can I respond? So the notary public did mention that when we went to Ms. Jennifer Bantusa, for everyone who we had them sign this affidavit, we read the reason why they were being challenged. this is a very meticulous page for each person, and we went through the page with each person. And so Ms. Bontusa believed that all she had to say to prove this was her, under penalty of perjury, was that I signed the petition for Justin Jones on April 2nd, 2024. That is my signature and handwriting on the petition. She wrote this as a response to all the claims made in this frivolous complaint. And I want to respond to your other point that under Tennessee law, we get 25 certified signatures. The day before the deadline, these signatures were validated and certified by the Election Commission, by your commission, sir. It was not until days later that this candidate called the director, got an answer, and then called you to say that the chair of the Republican Party told her to call you for legal advice because you're the man. That's what that voicemail said. And so you can say this is all neutral, but we know it has not been neutral. And so regardless of what happens, we have the affidavits. These are valid in court, in the court of law. Someone saying this is them, someone saying they signed it, someone saying that that is their handwriting. And that is the basis of this challenge. That's the basis. Also, we have Jennifer Bontusa on the phone. We can FaceTime her. We can FaceTime her. She's listed as a witness. Mr. Robert, she's listed as a witness. We can FaceTime her, so you can ask Jennifer Bontusa herself. And so can we FaceTime her because she's listed as a witness, and because of accessibility, we want her to be able to defend herself. So she's on the phone, and she can be on FaceTime, so you can verify her face with the photo there before you, and she can testify because the truth is powerful and it prevails.
So that raises a legal issue. Can we accept evidence at this point?
It's a response.
Over the telephone.
We did Zoom court.
This is you asked.
Excuse me. I'm directing this question.
Hey, Jennifer, can we FaceTime you?
Excuse me. I'm directing this question to our legal counsel. Let me ask you this, Mr. Jones. Is it possible to get her here? Where is she? How far away is she? If our lawyers say that we can't accept evidence over the telephone, can she be here?
Mr. Chairman?
Yes. The chair recognizes Commissioner Hertzfeld.
I don't believe the rules of evidence actually apply in this hearing, so we could accept hearsay testimony, could we not? Can somebody not just talk to her and then say what she says? I mean, I don't think there's a bar against hearsay. We can weight it how we weigh it. We can weigh it.
Yes.
But I don't think the rules of evidence. It is what it is, but I mean, I don't think there's like a prohibition against hearsay.
Are you still there, Jennifer?
Yeah, I'm here.
Okay.
Again, we need to consult with our lawyers.
I have a computer in front of me. I was working, so I can do whatever.
Yeah.
Okay.
The election commission can Zoom her in.
I think you had asked a legal question. It's my understanding that there is listed on the witness list
Yes.
a Jennifer Bontusa.
Yes, she's on the list.
It is ultimately up to you, the commission, whether you will accept remote testimony. That is for you, your decision. But that is if you direct testimony.
Mr. Chairman, can I make a motion that we accept her testimony via email or whatever? FaceTime.
Well, question. Two questions, I guess. One's to Metro Legal and to the point that we're making here. Because since we have requested people to be here, and they're not here. So my questions, I know you said that we can if we so choose. Is there any other legal bar that says that a witness would have to be here?
I don't know whether the commission voted on that issue. I think what was raised at the last meeting was whether or not the challenger could appear remotely,
Right.
and a decision was not made. And I think the comment was if an issue comes up, then we'll decide it at the meeting.
Okay.
So I don't think the commission has made any decision on that issue.
All right, second question is that since he allegedly has this person on the phone and we don't have a way to verify it, my question is this.
We have FaceTime.
FaceTime, thank you. However, since we don't have a way to verify this person here, what are our legal options?
What I can say is the commission, as a trier of fact, makes credibility decisions. It is for you to assign weight to the evidence as a trial of fact. You determine the weight to be given to a particular piece of evidence.
So it could be direct or hearsay to,
Okay, this is a quasi judicial proceeding. So the general rule of evidence that appears, that applies in a court of law with regards to trials do not apply here. So at the end, it's for any piece of evidence that you have, it's for you to weigh that evidence and assign credibility to that evidence.
thank you.
Mr. Chairman, I renew my motion.
Do we have a second? No, he's moving. He's not
you
removing.
move
He's
it?
moving it.
Okay.
Yes, and sure. And so we can have her in the court reporter. You can pick this up and we can swear her. We will be able to swear her in if that's our decision. Is there any further discussion on this?
Point of order, Mr. Chairman.
Yes.
Do we have a second?
We have a second.
Yeah, do we? Right.
Who's the second?
I'll second. Ma'am, we're having a conversation.
yeah,
If you
we're-
could just wait a minute, please.
Yes, we have a motion and do we have a second?
We have a second.
All right, we have a motion and we have a second. All in favor, say aye.
Aye.
Any opposition? With no opposition, the motion carries. So let's see. She needs to be sworn in.
The signal is bad. She also has her ID card to show you all.
Sure. Okay. Oh, gee.
She showed her identification
Sure.
card. And so their question is why does your name only have one N on the nominating petition?
I'm sorry, I'm going into another room where my son is not watching TV. I was in the middle of a meeting when they came to the door, so I was quickly doing it. I mean, I go by Jen, so it's Jen, but my full name is Jennifer, so. Jennifer Bontusa. I work from home.
Yes, Commissioner Davis is recognized.
Good evening. Please spell your name for us. Please.
Jennifer,
Say that again.
Jennifer, Bontusa, Bontusa.
Thank you. No further questions for me at the moment.
Any other questions?
Any other questions by the commissioners? All right, okay. Thank you.
Oh, yeah.
I just want to attest that this is the face of the person that I saw on April 25th that notarized her signature. Thank you.
All right.
Thank you. And so is she okay? Oh, the chair has a question.
No, there's no, I think she can, you can sign off with her.
Thank you.
We'll tell her she might need.
We may.
Hold on.
Hold on.
Ms. Bontusa, just be aware that this is going on, so be by your phone just in case we need to get you back.
Okay, yeah.
Thank you.
Okay, all right.
I'll be here. All right.
Okay.
Thank you. Thanks, Jen.
All right.
And so,
Commissioners, do you have any other questions? All right. Those are all the questions we have. We are at the point in the procedures where the parties make closing arguments. The challenger goes first, and the respondent goes second.
I know we're setting precedent here tonight, and I appreciate all your time. I do want to say a few words here, and my words are predominantly this. We each have a choice as candidates to question each other's nomination petition. It's a matter of legal and procedural matter for each and every one of us. And so the evidence that we are contesting or the evidence that we are disputing are not the signatures on the affidavits. They are the State of Tennessee candidate nomination petition. It is this document, this legal document. This legal document says, cannot sign for another, no dittos, no marks, signature required. The difference between a signature and initials is very different. But I'm going to touch on signature. The evidence we presented relating to signature number 4, Jennifer Bontusa, is simply not a match to the 3 and 4 pieces of evidence that we have shown earlier, and then Representative Jones has showed again on the affidavit. There is no match. It's simple, it's easy. You can make any excuses in the book, but at the end of the day, if we don't know how to spell our own name, we should not be signing this legal document. The Davidson County Election Commission.
Everybody gets a chance to make their argument. It's not about you. She's talking to us, so please let her do that.
The Davidson County Election Commission has the opportunity today to set future precedent that initials on a signature petition are not an acceptable signature. If the Election Commission records and has records that show the voter has never used their initials to sign other Election Commission documents, then that's evidence. Therefore, signature 17, John Adam Sensenbrenner, not here, and number 8, Caitlin Bolt, not here. Signatures written on the petition as initials must be immediately disqualified from the Jones petition. I would like to remind the Commission the definition of a signature is a person's name written in a distinctive way as a form of identification in authorizing a document such as a legal nominating petition by the state of Tennessee. Hence, initials have less importance in the authorization process of a document versus a legal signature that is legally binding and the final step in the authorization of any document. And the nomination petition is a legal document. In the event that Representative Jones has referred to me in all types of slanderous ways, we did not force them, meaning the Jones camp, to do anything. We did not force his witnesses to show up. We did not cause a witch hunt. This is not a witch hunt. By the way, a witch hunt would be me. The witch hunt is on me. I did not get my due process in the process. that this commission laid down in a procedural manner, starting on the 16th of April and confirmed in public on Monday, April 22nd. I lost all my procedure from the 24th to the 26th. We point out that the Notary Republic affidavit is a very nice gesture. We say that these are correct. We use this as evidence to additionally prove that the signatures on the petition are invalid. We agreed that the name of the street changed once we were told that there was a change, but there's a lot of documents out there, including the wild, wild web. And so in closing, I would like to say, in the event that, now, hey, excuse me, but Representative Jones got a lot more time than I did. The Nelson Committee.
Audience, please.
In the event the Nelson Committee loses this challenge, we would like to explore options for appeal. What are the legal steps involved, paperwork and process to notify the commission of such an appeal moving forward in support of the Nelson Committee case?
We can't address that today, but if you have final summation of your closing arguments, I'll give you just a little bit more time. But if you're done, then we'll turn to Representative Jones.
I do want to finish my thought. We use this evidence that was available to us to prove that the signatures on the petition are invalid. We agree on a lot of things, but what we don't agree on are that the three, number 4, number 8, and number 17 are unequivocally not a match. Thank you.
Good evening. So what we have before us is a threat, but no matter what you decide, the challenger is going to try and continue with this frivolous complaint. We see that. This complaint started with a voicemail to the chair of this commission saying that there were 6 suspect signatures, then it became 10, and tonight it became 3. If you look at my opponent's own petition that she submitted to be validated before you, number 6 is an initial signature. Number 22 is an initial signature. So I encourage you to look at the precedent you're setting here, because maybe there has to be some other, if we're going to challenge initials, perhaps we don't need this complaint, we need a mirror to look at what we did our own selves. Because the thing is, to this commission, is that the next case you're going to hear, the person challenging brought a handwriting expert. The burden of proof is on the challenger. My opponent brought her husband. That is not evidence. The evidence before you today was submitted on behalf of our campaign to show affidavits. We submitted evidence. That is not, the burden's not on us, it's on the challenger. They don't have a handwriting expert. They have nothing but quickdeeds.com, which tells you if you log into that website to not use for official legal verification. And so let's look at what is going on here. This is about making a mockery of our election commission. Your own employees who do hard work to verify the petition of Davidson County candidates verified this. And now the challenger went through quickdeeds.com and found people's deeds and looked up their voter registration card from 20 years ago to try and sow distrust. And then told this commission that the burden of proof was on us to prove that their lies were lies. That is absurd. And so I'm not going to threaten you as she did to say, however you decide, we're going to continue with the legal challenge, because we know that the truth and the facts and the evidence are on our side. Anybody watching this will know who submitted evidence and who brought witnesses. Witnesses. People who took time off of dinner, off of being with their kids, off of coming straight from work to be here today to tell you that this is a lie. And then when they saw these people here, they said, oh, we only want to go after the people who are not here, because they didn't want to have to challenge the people who are sitting here before your face, because they're telling you, this is what they're telling you, Mr. Chair. This is what they're telling you, commissioners. They're telling you to close your eyes and close your ears and ignore the evidence in front of you. And that is absurd. It is absurd. It makes a mockery of this commission. It is very sad that no matter what is decided here today, they're going to continue with these tactics of deceit, deflection, deception, and distraction. But I want to end with just one D for you that we're going to continue forward for, and that is democracy. She has initial signatures. I'm not going to challenge them because I know that we can win fairly at the ballot box. I know that we have the integrity of a campaign. I know that we have the integrity of our actions with ideas to let people know where they should vote. And we don't have to rely on games. And so to this commission, I just ask you all, are you all going to be pawns in this game? Are you going to let someone come up here and threaten to appeal no matter what, even if it is based off of evidence, even if it's based off of fact? I say appeal and appeal and appeal. Because no matter how many times you appeal, no matter how many people you tell us to knock on their door, get their signatures notarized, we will do it. Because the truth is powerful and it prevails. And we have the truth on our side. We have the facts on our side. We have the evidence on our side. I don't understand the absurdity of this whole hearing. And it's insulting to the people of Tennessee, to the people of Davidson County, that this is what our resources are being used for. And so again, you have the affidavits before you. It is your choice whether to believe the affidavits. It's your choice whether to believe the photos and the witnesses and the people coming telling you that that is their signature. The only question before us today are those signatures valid or are they fraudulent? That is the assertion, is that these are fraudulent signatures. This is what they've told everyone. Allegedly, whoever signed these, the people who signed them are the people whose names they are. The people who are here today, that's who signed them. And so the question is today is, do we believe the affidavits? Do we believe the witnesses? Do we believe this process? Or it's just a formality of political games and political harassment that is really about undermining trust in our election and trust in our election employees? That's what this is about today.
All right, commissioners, now it's our time to deliberate and to ask questions of our lawyers if we need to, and to talk to each other about this decision. The chair recognizes Commissioner Hertzfeld.
So I guess I'll start. I have a couple questions I've written down as we've listened to everybody's presentation of evidence today. Thank you very much. It was very thorough and very passionate, and I appreciate the fact that everybody's put together a ton of stuff for us to look at. You've seen us all kind of flipping through everything as you've been making your presentations, and that's because we're looking at everything you gave us. There's a giant binder here, that we've been trying to go through very carefully. I just have some questions. I think you all heard me talk in the beginning a little bit about what is the burden and where the burden goes and how a burden shifts, and who has the job here to prove, right? And by how much. So I just want to make sure I understand the burdens, if I could confirm them with our lawyer. Hate to put you on the spot there, Ms. Ecke.
Yes, thank you. The burden of proof is on the challenger.
Okay.
To prove the allegation by a preponderance of the evidence. The ultimate issue is whether the evidence shows that a particular registered voter signed the petition. So proving an allegation by preponderance of the evidence requires a challenger to convince this commission, who is a trial of fact, that the allegation is more likely true than not true. A party proves an allegation by preponderance of the evidence when the aggregate weight of the evidence demonstrates that the allegation is more probably true than any other factual alternative. So those are just the various ways that the preponderance of the evidence standard is explained in cases.
And I think we tend to say 51%, right? A little bit more than 50% is typically how we talk about it with a jury. 51%, that's preponderance. Okay, but so I just want to clarify the way that it's worked in our commission. And that is when petition signatures are turned in, our nonpartisan staff who have been doing this for an extraordinarily long time, they take a look at it. They look at the petition to verify the signatures according to the verifying petition signatures document that I believe was provided to us by the state. In this case, our staff looked at the signatures and verified 25 of the 26 signatures for Representative Jones. Is that correct, Mr. Roberts?
That's correct.
Okay, so now the burden is on the challenger to come forward with sufficient proof that it would be any one signature would be sufficient to disqualify in this circumstance, but she's come forward with 3 allegations. Is that right?
That's correct.
Okay, and my understanding from the evidence that was brought forward by the challenger is that her evidence was, I don't think these signatures match.
I can't really weigh in on the evidence
Right.
itself. That's your job,
Right, that's what I heard, okay? The only evidence I heard her say, because I think I asked this question, was we don't think these signatures match, these 3 signatures. So the question is saying that these 3 signatures, we don't think they match. Is that sufficient to shift the burden to Mr. Jones to then come in with evidence to say, no, it's all good? Am I understanding this process correctly, all lawyers down here?
Just, to summarize, I think, like I had indicated, is under that standard, again, the burden of proof is on the challenger.
Right.
So the evidence is essentially weighed on a scale.
Mm-hmm.
And whichever side of the scale is heavier is what the commission's finding will be.
Right.
You know, if you weigh that evidence.
Okay.
But the burden is on the challenger to prove their allegation.
Right. Okay, so far as the questions we got about, can you sign with initials? I think that was one of the concerns. Can you sign with initials? And I just want to read from this document that we've received from the state from 2014. So this is how we've always done it. Verifying petition signatures for Roman numeral 4, B1 and 2. It says in 1, 2, A, B, and C. Okay, so if you go to B2, there's examples of regular signatures versus legal signatures. And I just want to make sure we have this down for everyone. Examples here. Quote, Mark K. Goins signs petition M.K. Goins, so initials instead of your full name. And the instructions from the state is you count it. Okay. B, Elizabeth Henry Robertson, hello, signs petition Beth Henry, right? Elizabeth, Beth, and she does just Henry instead of Henry Robertson. The instruction from the state is count it, okay? The third one, Catherine R. Summers signs petition Kathy Summers, and the instruction is to count it. So far as the allegation about initials versus full signatures, this is the standard that our staff applies. Is that right, Mr. Roberts?
Yes, ma'am.
Okay. So I think that was, which signature was the concern there? And then the next one I think that really came up was Jennifer Bontusa. And so I had some questions about that one. With Ms. Bontusa, it seems to be the concern is the line that says print here, not the signature. If I heard this, if I heard the evidence and the concern of the challenge correctly. So I want to read from the nominating petition, which says nominating signatures must be registered voters who are eligible to vote to fill this office, cannot sign for another, no ditto, addresses listed on registration, no P.O. boxes. So from what I heard, the concern other than you are saying the signature doesn't match, but the concern about Jennifer, how we're spelling your name, if it's 2 N's or 1 N's, is really in the printed signature section. And I don't know that that's ever counted as the actual signature for a nominating petition. I think it has to be like in the signature, like the signature portion, not the printed portion. I was wondering if there's any legal advice, any lawyers here, because we have state and metro lawyers, about the print here versus the signature. Is there any precedent on that issue?
Mark Owens, coordinator of elections. There is no precedent, but I think I hear it a little different. I think that she's challenging the signature and she's saying the misspelled name just shows evidence that someone else may have signed it.
Oh, okay, but if I could just, I hear that. If I could just, though, you said you don't think there's any precedent for like the signing of the name. So I guess my question is, would it be okay if someone was out collecting signatures? Like say I'm going down my street, right? I live on Dakota Avenue. So I'm going down Dakota Avenue and I'm picking everybody up and I've got this neighbor sign it and this neighbor signs it and these ones are on the corner and they all sign it. And then I'm like, oh, wait, I've walked away. I've got my dogs now. Everything's going crazy. And I'm like, you know what? My neighbor, Mike Smith, I know he signed this and I know his address, so I'm gonna write in his address and I'm gonna write in his name, Mike Smith. Is that permitted or is that not permitted?
That would be permitted. The signature is what you're looking at. That's
Okay.
correct.
That was my question because I just needed clarification on that. At this point, I don't think I have any other questions. Thank you so very much for the sage legal advice.
The chair recognizes Commissioner Burns.
Thank you, Mr. Chairman. Thank you, Commissioner Hertzfeld, for your very thorough presentation. It kind of helps narrow my focus a little bit. I don't so much have an issue with Ms. Bolt or Mr. Sensenbrenner. The initials that they used are very similar to those corresponding letters in the name on their registration documents. And in fact, on Ms. Bolt's affidavit, she indicated that sometimes she uses CB as her signature. So I don't have so much problem with that. My problem in a major way, quite frankly, is with Ms. Bonatusa. And it relates not only to her signature, but to the printed part of it. Now, I realized and I heard that the printed part can be done by someone else. However, in her petition, in her affidavit, she said that she signed the petition for Justin Jones on April 2nd, that is my signature and handwriting on the petition. Now, I think that seriously calls into question the credibility of the witness and allows us to then, therefore, look at that printed language on there. And let's start with the signature. The signature on the petition bears zero resemblance. I tried hard, I promise, I tried hard to make that work. But it doesn't have any resemblance at all to either her petition, any of the documents, or registration documents. I'm not going to get into the quitclaim deed because I don't think we need to go there. But in her registration documents, it's a very precise signature. It's quite unique. It's pretty cool, actually. But when you look, and same thing on the affidavit. But when you look at the nominating petition, it is a scribble. I mean, there's no, I can't find any way to justify those two signatures. So in my mind, the preponderance of the evidence, it's not so much what somebody may or may not have said, but with the submission of the documents, as well as Ms. Bonatusa's statement and affidavit that she did all that writing. And the writing, I didn't say this, the writing on the petition where she prints, where her name is printed and the address is printed, again, bears no resemblance at all to the printing that is on the registration document that she signed on April 27th, 2018. It just again, there's not a single letter that closely resembles. I mean, you've got a B that this is totally, I just don't see it. So I think that goes to her credibility. I think that gives weight to the preponderance of the evidence, and I've got serious issues with that signature, Mr. Chairman.
Commissioner Starling, you're recognized.
Thank you. First of all, I want to thank all the people that showed up tonight to see democracy work. And I really appreciate that for the time that you spent away from home. Shows a testament that in this state that we want to do things right. And I appreciate both parties presenting their case in a professional manner, and I do appreciate that. I am of the position that we have the best election workers in the state. Out of all 95 counties, I would say Davidson County is super number one. And when our staff certifies signatures and everything else, it is 100% accurate in most cases. And I appreciate that. And I want everybody to know that, that the Davidson County Election Commission works super hard. And if we don't, we will hear from the coordinator of elections from that. I have looked at this evidence all week. I've had documents going back and forth, and I've looked at them. And when an individual or individuals sign an affidavit to swear that their testimony and their signatures and what they did was right, weighs a lot on me. And I take that to heart. Reality, you get put in jail. And I'm sitting around a whole bunch of lawyers here, and I know they can say that. But I see no problem in some of the signatures or any of the signatures. I do know that I sometimes sign my documents or my signature as A.J. Starling, when in fact is Osmond Jefferson Starling. And if you see most of my documents, it's A.J. Starling. So I would say probably if somebody came up into me and signed a petition, which I hadn't done since I've been on the election commission, because I want to keep the integrity right. I would have probably signed A.J. Starling real fast and left. So I see that when people sign a petition, when they have an affidavit by a notary that's sworn by the state of Tennessee, I mean, this young lady could lose her license and probably a lot of other things could happen to her if she didn't do the correct thing, which I've seen all that. Seen the photos. I looked at all. I've looked at the evidence of Miss Nelson. And I looked at it, and I'm going to be fair. I've called the shots the way they've always been called, and that's fairness. And I am of the opinion that we should move forward with allowing Representative Jones to accept these signatures.
Is there any other comment by other commissioners?
I do have a question.
Yes, sir.
If I had a question for one of the witnesses that was here or dialed in, can that be brought back up, or are we past that point out of curiosity? I don't know. I am asking.
I think we can always change our rules when we want to, but.
Well, I'm not here to change the rules. I just want to ask a question as a point of order.
Well, we set a schedule.
Okay, that's fine.
and
That's why I
we can-
asked.
We can change that, but do we want to? Because
I'm not here I don't want to change the rules. I was asking as a point of order, because a question, of course, comes up later.
Okay, all right. Do you have any comments?
Give me a moment. I think I do have a legit question about one of the other issues.
Well, let me speak while you're thinking. Hopefully you can listen to me and do your thinking. I, like my colleagues, want to thank you for all being here. This has been a very hard-fought case. Sometimes we have challenges where people make challenges and then they don't show up. And so we have to make a decision in a vacuum. Here, it's been very hard fought. Both sides had points to be made, and we appreciate that. And as Commissioner Starling indicated, this is a large part of democracy. This is a legitimate process. People get to make challenges. After this case, there'll be another case. The parties will be switched. In that case, there's a Democrat challenging a Republican. So this is just part of the process, and we appreciate your all being here and being very passionate. For me, I was the only signature I had issues about was Ms. Bontusa, and I asked questions about that, and she testified about that. So we have not only an affidavit from her, but testimony from her. Her signature is a scrawl, no question. The printing of her name, however, it does appear that the same person printed her address, fully printed her address and her name. She explained the one end rather than two. There is a concept in the statute. Let me see if I can find it. It's in 25101.3. 25101B13, and it says a person's regular signature shall be accepted just as that person's legal signature would be accepted. So there is a concept here, both in the statute and in the case law, of substantial compliance. And based on Ms. Bontusa's testimony, it appears to be that the signature on her petition is her regular signature. So for me, that tips the balance. I'm not so sure that the challenger has the burden. At least for me, I'm looking at the totality of the evidence and making a decision as to whether or not there are enough signatures here. Now, I must say, we wish we had more signatures to deal with. It's just like an election. The election commissioners hate to see a really, really close election. They hate to see a decision come down to one vote or one signature in this case. So I know, Representative Jones, you've run 5 times. I just wish the next time you could have a big party and have twice as many people sign. But at least based on my preliminary decision, and I think I should wait till everybody speaks, I think that there are 25 valid signatures here. But again, I need to hear from all the rest of the commissioners if they want to be heard. You're recognized, Mr. Davis.
In regards to the initials, and I'm asking our legal representation, I reread the state statute and I looked at the examples provided. Here is my question, so I have clarity, is that in the examples provided is, in the case, I think it's MK Goings, but there's a last name that is actually signed in the initials. In some of the cases here, there is just the initials, period. Does that qualify as a signature? So in other words, there's just a signature, there's just the initials, you know, ABC, versus in the example is AB Boston.
Right. So Mark Goins, again, Coordinator of Relations, we didn't contemplate that when we did that 10 years ago. The initials, AJ is a perfect example. AJ signs it AJ Starling. He doesn't sign it AJS. So then, looking at the statute, it comes down to, would this be considered their regular signature? It may be that someone has initials as their regular signature. And I wasn't, as you were asking your question, I didn't go back and look at the affidavits, but it may be answered in the affidavits that were submitted. It may not be. But at that point, we have not given guidance on all three being initials. We have given guidance on MK last name, because that's typically what you see. So it will become a question, as the chairman has pointed out, the statute contemplates accepting legal signatures or a regular signature. So so now the question is, are those initials their regular signature?
Mr. Chairman, can I respond?
Yes, Commissioner Hertzfeld, you're recognized.
I would just point out that my signature is actually also just initials, because Tricia Hertzfeld's really long to write, the F and the Z, and I just did really fast and always in a hurry. And if you look at the minutes that I just signed, because I'm the secretary, so I have to sign the minutes. If you look at every single one of them, you can't read my signature. It is literally a T, scribble, H, scribble, and that's my signature.
Yes, but there's a scribble. There's no scribble on one of these. So I was asking, that's why I was asked the coordinator. The scribble could indicate the last name or the first name. That's why I asked the question of the coordinator.
It's just a line. But anyway, if you want to look at it, it's funny because that's literally my usual signature versus my, when I'm spending time writing my name for something official, on the candidates, when we sign you're sworn in, I try to be nicer so you can read it. But mostly I just scribble.
All right. Any further comments or discussions by the commissioners? With that, do we have a motion?
Mr. Chairman, my position is that he's already been qualified. Representative Jones has already been qualified by this commission to appear on the ballot, so I don't think that anything is necessary unless we choose. I don't think a motion is necessary unless we are choosing as a body to overrule the previous certification of our staff. So I will not be offering a motion.
If I may speak, because there's an actual...
Yes, Ms. Ecke.
Yeah, thank you. Because there's an actual challenge, that is my recommendation, is that the commission actually take action on that challenge by motion. And usually you act by motion. So because there's an actual challenge that's been filed, that is my recommendation.
I believe there is case law saying the commission makes these decisions, even though our staff, does a fabulous job. Now that we have a challenge, my suggestion is that we have a motion.
Mr. Chairman, I'd like to make a motion that we accept the signatures Mr. Representative Jones has submitted, all 25.
We have a motion. Do we have a second?
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Any opposed?
No.
So we have the motion carries 4-1.
3-1, abstain.
You abstain?
It's 3-1.
I'm sorry. Excuse me. Hold it. Correct. Right. Right, but I want to get it on the record if that's, all right. There's a correction on the vote. The motion carries 3-1, one nay, and one abstention. Unless the
Okay,
commissioners
one abstention.
object, I call for a 5-minute recess. Thank you. Have a safe trip home. And call to order under our procedures. The challenger is entitled to a 5-minute opening statement. And this, of course, is the matter of Mr. Mitchell or Representative Mitchell versus Ms. Webb. And so we are going to give the challenger a 5-minute opening statement, and then the candidate gets a 5-minute opening statement. With that, Mr. Hollins, you have the floor.
No S, Mr. Chairman. Jamie Holland on behalf of Representative Bo Mitchell. Good evening to you, Mr. Coordinator of Elections, and the few remaining folks that are assembled here tonight. Do you want to swear in the witnesses, Mr. Chairman, first?
Yes, that's as we did in the
Let's go
previous
ahead and do
hearing.
that.
If we have all the witnesses, anyone who will testify, please come forward and we'll have you sworn. And as the last time, I think we need to get everybody's names on the record. Everybody who's going to testify, please tell the court reporter slowly and distinctly your name so she can get it down.
Mr. Chairman, if our expert could go first, I would appreciate it.
Sure, that's fine.
Go ahead.
My name is Diane Peterson, and that's with 2 N's and S-O-N.
Joseph Allen. William Jameson.
My name is Mary Ann Sonny.
Robert Jeffrey.
Could you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're going to give tonight will be the truth, the whole truth, and nothing but the truth? Yes.
Thank you, Mr. Chairman, Commissioner. I got to start with something uncomfortable first by asking a question or two of you, Mr. Chairman Delantis. Did you ever represent Representative Mitchell's former business partner in your private law practice?
Yes, and I did represent him in a case that was concluded about a year ago against Mr. Mitchell.
If so, can you put that being the case, can you put that aside and treat Mr. Mitchell's claims fairly and impartially here today?
Yes.
We will then waive any claims of a conflict. Tennessee Code Annotated 2-1-102, 1 through 4, specifically subpart 1, provides the stated purpose of the election code. Quote, "The purpose of this title is to regulate the conduct of all elections by the people so that, 1, the freedom and purity of the ballot are secured," end quote. On behalf of my client and myself, we're grateful for this process as it reflects well the commitment of the staff, the administrator of elections, and this commission to election integrity. And I thank you for that commitment today. As a procedural matter and for purposes of the record, I'd object to the consideration of any evidence beyond the nominating petition and the voter registration or signature cards from commission consideration, as I believe that to be peril or parole evidence outside the scope of items to be considered by this body. TCA 2-5-101B informs this opinion and only contemplates the nominating petition and the voter registration card. If you intend to consider parole evidence, and I get what would just happen, but I've got my own record to perfect in this case, I request that you make a determination on that issue prior to the presentations of the parties. Further, it is my understanding when it relates to election law crimes, this commission is acting as law enforcement. and is responsible for reporting evidence of alleged crimes to the district attorney for prosecution. TCA 219-109 states, quote, a person who knowingly makes or consents to any false entry on any permanent registration, poll list, election tally sheet, or any other official registration or election document like a nominating petition commits a Class D felony. I humbly ask that if evidence is submitted today demonstrated that an election crime has been committed, that you would report said evidence to the district attorney for prosecution. And where I'm going with that, just to set your mind when you start hearing from the opposition, is this. On April 11, 2024, Councilmember Jennifer Fremsley Webb emailed AOE Jeff Roberts the following, quote, Alan Sipe signed for his son, Joseph Walker Sipe. That was in Navy training with his permission. I submit to you, based on 219-109, 2 people allegedly just committed a crime. 1 for signing it, 1 for allowing it to happen. That is not something I said. It's not something I wrote down. It is something someone did in this case, and I yield the balance of my time. Thank you.
All right.
First of all, thank y'all for letting me come here and speak. And I'm going to defend why Mr. Sipe signed for Walker, because he is out serving our country. They had power, Alan, his father, had power of attorney because he is out serving. His other son is now serving too, and his third son will be going in to serve our country. We did not know that that was breaking the law, and as soon as I was inquired and found out, I withdrew the signature from my petition. Okay? Thank you. So first of all, I was fully shocked that I found out that I must defend my signatures simply because my opponent wants an unchallenged road to victory. Prior to coming here tonight, I gave the commission sworn affidavits for the signatures themselves from everybody that signed. My opponent has invested in counsel and an expert to challenge my supporters simply because he can. There is absolutely no merit to his challenges and his allegations. This simply is his last-ditch Hail Mary of my opponent. My supporters have sworn that their signatures are their signatures. My opponent's expert is here to muddy the waters. An expert opinion is just that. It's an opinion. It's not a fact. Everybody needs to look up what an expert is on an opinion and look up what the word affidavit means. An affidavit is a sworn document governed by the state in the court. Hopefully, those will supersede any opinion of any paid expert to prevent the democratic process from taking place. Hopefully, y'all will render a decision that my signatures are accepted and that I was certified when Miss Harrison did her job the first time around. I know she takes her job very seriously, and I was certified the first time around, and I hope that y'all certify me this time. Thank you.
Thank you. The challenger has 30 minutes to present evidence.
Yeah, and Ms. Kelly, we're going to set the computer too. Sorry. I apologize. While she's doing that, Mr. Chairman, I want to ask her a few questions, if you'll allow that. You ready to answer while we're going here? All right, Ms. Peterson, what is your profession?
I'm a forensic document examiner, handwriting expert.
What does a forensic document and handwriting expert do?
We examine documents, anything that's disputed, anything in question. Many of my cases are question signature cases, and we determine if something's been altered, alterations done, obliterations, additions, or substitutions to documents. We determine if something is genuine or not. And we also write reports and give expert testimony.
How long have you worked as a forensic document and handwriting expert?
Since 2009.
How many question cases have you handled?
Over 900 at this point.
Do you maintain a laboratory?
Yes, I have the latest software. I have Adobe software. I have Iconico software, which is protractors and calipers, and also have a high scan resolution scanner and an electronic microscope.
In what courts have you qualified as an expert?
I have been court qualified in testimony in Alabama, Tennessee, Kentucky, Georgia, and Florida, and the Bahamas.
Mr. Chairman, pending your questions, I'd like to have her deemed an expert on handwriting.
I don't see how we can, I suggest that we all ask her questions before we concede that. We've got
Okay.
5 people that may have different opinions on that. It's kind of a legal point. I'm not sure we're quite there as a commission. Mr. Starling is giving me a quizzical look, and he's about to tell me again that he's not a lawyer.
Well, I'd like to offer her up for that.
I understand that. I don't, at least I would be more comfortable with our just asking questions. I don't think we want to prejudge her qualifications at this point.
In your packet that's been presented to everyone, it's a little plastic binder. Her CV is in there as well, along with the written report relative to this case.
The full report is not in there. The demonstrative exhibits are.
I've previously submitted that report.
Mr. Chairman,
Yes, sir.
I'm certainly not an expert to challenge anybody's credentials at all. And if the witness says that what she submitted to us is true, is true. And I don't have any problems not disqualifying her at all. I accept her as a witness.
I mean, I don't think we're being asked to disqualify her. We're being asked to qualify her.
Well,
and my point is just, we probably should wait until everybody asks questions before we make up our mind on that point, because we're implicitly prejudging her testimony against the challengers. I mean, the respondents, and we haven't heard what the respondent has to say yet.
One thing I'd just like to note for the record before I let her go on her report is that during that Q&A, y'all were having amongst yourself, the timer was still running. I hope that's not an issue later. We can wait and see if it is. Go ahead.
How much? Okay, all right.
Thank you all for giving me this time to explain my process in this case. My statement of duty is always, as an expert, is to remain impartial and objective and to assist the judge or the jury, or in this case, the trier of the fact, in matters that fall within my skill, knowledge, experience, education, and training as a forensic document examiner. The request in this case from the client was from Jamie Holland. this attorney, he asked me on April 10th, 2024, to determine if Michelle R. Armstead and Jeffrey Webb's signatures on the state of Tennessee candidate nominating petition were genuine. And so that's what the request from the client was to do. And there's two basic laws of handwriting identification, and that is no one can write their name right the same way twice, and handwriting is unique to each individual. And this is demonstrated through natural variation. Some people variate a lot, some others variate less. Some people's signatures change throughout time, and some people's do not. I have seen an 84-year-old person sign as if they were my age. So, it's not always true that it does change, but it is oftentimes true. So, in handwriting identification is what I was asked to do in this case. There's all the features to look at handwriting. I'm looking at how someone utilizes their space on the signature line. I'm looking for letter size and proportions. I'm looking for stroke direction, line quality, pressure patterns, rhythm, slant. As you can see in my report, there is a plethora of things that you look at. You're just not looking at letter forms only. And in this field, it is a science. You can only compare signatures that are in cursive or any handwriting. You have to have the same form, cursive to cursive or print to print. You can't crisscross. So if I'm given a case with something to crisscross, I'll walk away from it, okay? So in this case, or any case, I'm to weigh out significant similarities or differences and weigh them accordingly and give an appropriate opinion to the case. And that's what I did in this case. And what I did was analyze, compare, and evaluate the genuineness of this question signature. And let's see. And so what I do, I place everything in chronological order. I extract the signatures, so you're only seeing the signature strokes from the documents themselves. I label and identify each document, so I can source each document and where each signature came from. And then after I do that, I do an intra-comparison of the known signatures against what's in question to gather the assessment of the natural variation that occurs in the knowns and then compare it to what is in question. And then weigh those out and give it an appropriate opinion, okay? Opinion levels vary. They vary from identification to inconclusive, and then levels of probability in between. They can be strongly probable, probable do not, or inconclusive. So based on the case, it's not always a yes or no. It can be a variable of probability, okay? Because when there's a handwriting case, there's so many different variables that enter a case. So that is the only appropriate thing to be done. So in this case, I've identified and labeled the document, the type, the title, and the date. And you can see this in this first table that I've done for the question document. And on this case, the Q12, which I've got an image of in here to come, this is the document that contained the question signatures. Okay, so for the known documents, this was Michelle Armstead's known documents, and we have a duplicate of permanent registration County of Tennessee precinct record, a voter declaration, and an affidavit. And those are, I won't read out the dates, but you can see them, they're on the left. And so they go through a range of time. And so then we have Robert Jeffrey Webb with 3 signatures for comparison on him, and that's a voter declaration, a voter ID, and an affidavit. And if a document does not have a date on what I'm looking at, I put date not present, or DNP. So this is what we had here. As you all know, and I guess this has been going through all night, but this was the form, and this was the first page. I try to put in all pages of the question document, okay? So this is page 2, and it says page 2 of 4 at the top, and then I've gave it my appropriate label in the bottom. And the Michelle Armstead is on that line, let's see, at the top, let's see, and Jeffrey Webb is below that. And so then we go through that, and this is page 4. There was, let's see, this is page 3, sorry. And then this is page 4 of 4, and of course it is blank. So those are the question documents. These are the known documents that we were just identified with Michelle R. Armstead. This is the first one, MRA1. That was her initials and the number 1. Then we have number 2, election committee. And then here's the affidavit, okay? And looks like I left out the A on that one. I apologize, but that should be A on that one. So, and then we have Jeffrey Robert Webb. We have these 2 documents from him and this affidavit. Okay, so I assume that this was the best evidence available and that the signatures were genuine for each person in this case. They were a lack of contemporary exemplars, and they were only photocopies delivered to me for this examination purpose. So there were some significant dissimilar characteristics, and I think instead of me reading through all of these, I think I'll go into the demonstrative exhibits so you can visually see these as well as while I'm describing them, if that's okay. So I'm going to jump to what you have in front of you. And it was my opinion that it was strongly probable that Michelle R. Armstead, if I'm saying that incorrectly, did not write the question signature on the nomination, and that it was probable that Jeffrey Webb did not write. So I had a strongly probable or highly probable and a probable, okay? And here we go into the terminology. There is standard terminology for expressing conclusions in this line of work, and I have that in there. I put that in my report so you can, if you have questions about opinion levels and how they're given, how that weighs out, okay? So let's go down to the demonstratives. So on the left, here we have Michelle R. Armstead, and on the left we have the 3 knowns. And this is a side-by-side comparison of each signature, okay? So, and this is the cursive name on the nomination petition. And what I found was that the initial stroke goes up and down in a very angular fashion on the question signature. And in the known signatures of Michelle's, we have this embellishment, this rounded curvature stroke that sort of sweeps in from the left to the right. And then people maintain their proportions, and so with their letters. And if you notice, the first L in Michelle and the second L, the first L is shorter than the next L, the second L. And the opposite is true in the known signatures, okay? And we have that from 1985, 2015 to 2024. And so you can see like my arrows and how descriptive that is, the difference there. I would call that a structural dissimilarity, okay? And also, I've put bubbles or, yellow ovals and circles. And you can see in the known signatures of Michelle, they're very bubbly and rounded. And then we have very narrow retraced strokes on the question signature. So one is true for one set, but it's not true for the other set. So this was a significant dissimilarity for me, okay? The next stroke, the next set of exhibits. I'm sorry. Okay. Okay. Okay, I think so. Okay. All right, and here is proportion 2. We're going to speed through some of this, but you can see the proportion differences. The M's trail from left to right, and the knowns, they go left down from left to right. So opposite direction. So I think that's very visible to see, and that stem of that A is taller in the Q, and in the knowns, there's the loop over the stem of the A. And so now we go to Jeffrey Webb. We have...
Before you get...
Okay.
Before we move to Mr. Webb, Mr. Chairman and members, Michelle, you just heard her say that those signatures don't match. And Michelle Armistead's affidavit does nothing to refute the fact that it was not her signature on the petition, only that she endorses Council Member Webb in her campaign. She had an opportunity. She didn't take it. When faced with penalty of perjury, she said, I'll pass. All right, go ahead.
Okay. Here we have a side-by-side comparison of Robert Jeffrey Webb, and on the left is the question signature, and on the right is the known signatures of Jeffrey Webb. And if we scroll down to my next exhibit, you can see this oval, dotted oval red loop. You can see this signature, this letter is above the baseline, okay? And it looks like a cursive large A instead of a J. And then in the known signatures of Jeffrey Webb, there is that upper and lower proportion made. It has that retraced stroke or loops in the bottom ones, but you can see clearly that there is a dip below the baseline to make that lower loop of the J. And then if you look at the arrows, there is a lot more rhythmic movement, and it's wider in the Q1 than it is in the knowns. You can see the green arrows and how they kind of bumble around, but in the question one, we have a lot more rhythmic movement. Okay, so here also it has a really awkward entry stroke, and then the connection stroke between let me specify, in the question signature, I'm going from the first letter to the second letter, and you can see this broad span, and it's a very U shape. And then, and that's exhibited with that green curved C. And then there's a lot of space, and the space is close to the top of that letter, and that's demonstrated with that double blue arrow. And then, most notably, the red arrow shows that the connection stroke starts at the top of the letter, then goes to the bottom of the letter. But in the knowns, that connection stroke begins at the bottom of the J loop and then trails upward. Totally opposite direction. And I think that's it. So that's where I weighed my evidence, give my opinions appropriately, I feel like, and that's it.
Okay. Mr. Chairman, I'm going to carry on. Let you have questions for her later. Ian McWilliams, printed name on the petition cannot be compared, as you heard her say, to a signature on his voter registration. But they're plainly not the same. His affidavit is lacking in that he doesn't recite under oath that he signed the petition, only that the print on the affidavit belongs to him, and that he endorses Councilmember Webb's campaign, not that he signed the petition. We're going to ignore the fact that he lives at the home of Councilmember Webb. He omitted language like, I signed the petition for Councilmember Webb to run for State House or something similar. William Campbell Sipe. That last name Sipe should ring a bell for you. That's what I was talking about when I said Joseph Walker Sipe, according to Miss Webb. And I hope to goodness Jay Allen Sipe doesn't get up here and testify to anything, because he has a Fifth Amendment right against self-incrimination. He shouldn't do that without counsel. But what does it say in that email? It says that he didn't sign it, that his father signed it while he's away. But staff verified that as being a valid signature. Not until the email from Councilmember Webb did that signature from Joseph Walker Sipe get excluded. Again, William Campbell Sipe, printed name on a petition versus signature on a registration card. Lastly, George Wyatt Sipe. Again, there's a pattern here. Sipe. Printed name on a petition versus signature on a voter registration card. On the petition, what do you see? George Sipe. I doubt very seriously, based on what I'm going to say next, he goes by George Sipe. How do I know? Because on his voter registration card, it's a signature and it says Wyatt Sipe. But there's no affidavit. Pending your questions to me or the expert, we'd reserve that time for rebuttal if given the opportunity.
I don't think we've provided for that.
Well, it's not question time yet, right? We have to wait.
Well, I think.
I just thought I'd throw that out there, Mr. Chairman.
I don't, unless the commission votes to change our procedures.
No, I'm a big
All right.
believer in our, no, wait. 30-minute presentation of
Right.
by challenger, questions from commission members. So we can ask questions now?
Right.
Can we stop the clock regardless?
He wants rebuttal, and I said that's not in our rules unless the commission changes the rule. So, unless there's a movement to change it, then the answer is no.
That concludes my comments, Mr.
Okay.
Chairman.
All right.
I do have some questions, though.
Yes, Commissioner Hertzfeld, you're recognized.
So I'm anxious to get to questions. Okay, so I just want to make sure, Mr. Holland and I think Mr. Roberts, that I have a good handle of what's going on with this petition. So somebody stop me if I have the facts wrong. Originally, when this petition came in, it came in with 31 signatures. Now, at the original time that the staff looked at it, 1, 2, 3, 4, 5, looks like 5 signatures were kicked off. Is that right?
That's correct.
Okay. So if we started with 31, 5 were kicked off. I'm not a math major. That left us with 26. Is that right?
That's correct.
Okay. And then under challenge and voluntarily, and I think everybody agrees that the signature of Mr. Walker Sipe has been withdrawn. Okay, so if you do the math, that leaves us with 25.
That's correct.
Okay, and Mr. Holland, I want to make sure I understand. You are challenging, Mr. Mitchell is Representative Mitchell, apologies, is challenging Michelle Armistead, who's signature number 10, which was a signature that was accepted by the commission. Is that right?
Correct.
Okay, and you are also challenging Jeffrey Webb and Ian McWilliams, who were not accepted. Is that right?
I'm affirming those. Ms.
Correct.
Webb has challenged their exclusion.
Okay.
I'm supporting staff on those, obviously.
Okay, and there aren't any other signatures that are at issue from your perspective at this point?
But that is incorrect.
Okay, who else?
William Campbell Sipe, George Wyatt Sipe, and Robert Jeffrey Webb. I sent an email to Administrative Election Roberts earlier today.
Yep.
Asking him, my email is slow here, sorry. It's populating, to drop certain individuals.
Okay.
And internet connection is slower than I want.
It's okay.
Mr. Roberts, do you have that? Can you get your email up sooner in the
While
cycle?
you guys you're looking for it, everybody's looking for it, if you don't mind me just clarifying one thing. Okay, so.
Here we go, I got it.
You got it? Okay.
No longer challenging Stephen McClure, J. Allen Sipe, and Mary Ann Sipe.
Okay.
Instead, the challenge is limited to Michelle Armistead, Ian McWilliams, William Campbell Sipe, Jeffrey Sipe, and George Wyatt Sipe.
Jeffrey Sipe. George Wyatt Sipe. Okay.
Can you say that again, real slow for me, because I'm
Yes.
slow?
The following people have been removed from the challenge. These are removals. Stephen McClure, J. Allen Sipe, and Mary Ann Sipe.
Okay.
Thus, our challenges are limited to Michelle Armistead, Ian McWilliams.
That's the part, that's the part I want you to go slow.
Yeah. Michelle Armistead.
Uh-huh.
Ian McWilliams. William Campbell Sipe. Robert Jeffrey Webb. George Wyatt Sipe.
So, Mr. Holland?
And before we go forward, because I'm going to forget, I would object to your characterization that Joseph Walker Sipe's signature was withdrawn.
It's not at issue.
It has been excluded from commission consideration, but it has not been withdrawn. That's a legal conclusion that I would leave open for interpretation by court if necessary.
Understood, and I am certainly not a court. I just want to make sure, because we have a few Sipes and a few Webbs that I know, like which numbers on the petition specifically we're looking at. Could you help us with that?
Yep.
So I personally was a little confused between Michael and Michelle Armistead, because those names are pretty close and the signatures are pretty close. So it would be number 10 on the petition is Michelle Armistead. Is that right?
So you're wanting me to look at her petition and give you numbers.
If you wouldn't mind.
Okay. And when when I look at the petition, I see two sets of numbers, one in red ink. Is that the number?
I was going to go with the ones that were actually printed, the printed numbers.
Yeah.
Because I think the other ones have changed.
Okay, number 10. And, you know, it should be noted that the candidate signed the petition too, also not legal.
Then also number 14 is,
Number 14 has been excluded, and we support that exclusion. Number 15, Ian McWilliams, has been excluded. We support that exclusion. Number 26, George Sipe. Number 27 is William Campbell Sipe. It has been excluded, and we support that exclusion. On page 28, that's one we mentioned at the jump, that's Joseph Walker Sipe, and he's the one who has been subsequently disqualified, and we would support that one. And let me check my notes here to see if I've got it all. Michelle Armstead, Ian McWilliams, William Campbell Sipe, Jeffrey
And
Webb,
that's number-
George Wyatt
That's
Sipe.
number 27.
Yeah, that's correct.
Okay, and
Yeah.
then Robert Webb. That's number, what is Robert Webb?
So that's number 14.
Okay.
You know, if you go down to 15, you see Ian McWilliams. Then you 16, you see Jeffrey Webb. I think that's the candidate's spouse and father of Robert Jeffrey Webb, whose signature is on 14, but the print doesn't match up with the print here versus sign here. So that was a little confusing.
And then George Wyatt Sipe, what number is he?
that's 26.
26.
Okay. So we still have how many that you're challenging? Is it 5?
So
That's,
the way I count it, 1, 2, the way I count it, it's 2 being challenged and 3 that were kicked off you are in support of. Is that
Correct,
correct?
because Ms. Webb is wanting those to be included.
Okay.
And I'm wanting them to stay excluded.
So I've got just a couple more questions because I want to keep it clear. So you got 2 you think are on there, shouldn't be, 3 that we've kicked off that Ms. Webb thinks should be back on. And so I just want to be clear that the challenger would have the burden to remove, if I understand that correctly. And the person trying to get them back on, which in this case would be the candidate, would have the burden to overrule the decision of the staff to bring them back on. Is that everybody's understanding?
I mean,
that was, I think that's what Ms. Ecke said. I have some concerns about that.
I would submit to you the standard of review is whether or not the signature on the petition matches the signature on the voter registration card. That's the standard.
Okay.
Because that's what the statute says.
Okay.
Not what I say.
Okay. I don't think I have any more questions. Thank you.
Anybody? Commissioner Burns, you're recognized.
Mr. Holland, Ms. Peterson indicated earlier on in her presentation about there's levels of confidence, I think, probable, Holly. Remind me, I missed it during the presentation, relative to her opinion relative to Ms. Armistead and Jeffrey Webb. Is it highly probable?
I'm going to let her come up here.
Great question. On Michelle Armistead, it was strongly or highly probable, and on Jeffrey Webb, it was probable.
Yeah. That it is not their signature.
That it is not their signatures.
Thank you, Mr. Chairman.
That's a good question.
I'd like to have her back, please.
Ms. Peterson, I'm going to let you stay up here until they release us.
All right, so back to what he just iterated, was kind of where I was going. So you said Michelle was,
Strongly or highly probable.
and based, without me going back since I have you here, so even when you have these ratings, so what are quickly just two identifiers?
On her.
Yes.
Proportions, the L's and the M's were proportionally reversed. And then the entry stroke is different. And then the writing is more bubbly, rounded, loops. And another feature on that writing that I didn't bring out was that the signature, the terminal, like when it ends on Armistead, it trails downward on the signatory line, just a bit, but it's there. But the knowns do not do that. They rise above it. So her utilization of space, letter size and proportions, the overall letter forms, to me are inconsistent between the collection that I had, the question and the known.
Okay, second question, and for the other one?
On Jeffrey?
Yes,
Yes, I put that it was probable.
and your 2 points?
And my major points was that the first letter is supposed to be a J, right? But it looks like an A, and it does not descend below the baseline. And in the knowns, you have an upper and lower proportion. The top part of the J is to be made, and so is the lower part of the J. It may be retraced, they may be, and actually the loops are small in the knowns, as when compared to that large-looking A instead of a J in the question signature.
All right, third question. So you, as you authenticate signatures, correct?
Yes.
Do you do this just for court purposes, or do you authenticate other items?
I don't do items per se. I'm asked to do that at times, but the piece has to be authenticated as well. So I might get called on a guitar. I got that lately, but I don't know guitars. I can verify a signature, but I can't verify the piece that.
Right, but you could verify the signature on the guitar, correct?
Right, I could do that, but I wouldn't do it I wouldn't do it alone without conjunction of the entire piece. Do you see what I'm saying? It's kind of a tricky thing. I stay away from that kind of stuff.
Well,
I really just maintain to documents.
So here's my question, because you bring up something that now makes me a little iffy on this. If you can verify a signature on paper, but yet if I say that, verify the signature on a guitar, and you wouldn't do that, and I'm only asking for a verification of the signature, not the whole piece.
Well, it's not the same substrate, right? Like you're signing, if I sign this and I sign a piece of paper, that's a different body, right? It's different positioning. Like people sign, papers usually sitting down. They don't always, but it's.
But game memorabilia and things of that nature, when you have JSA, Beckett, all these people who do this, and they can look at the live, is it live ink or is it not live ink? They look at the same things you look at.
Right.
So in turn, that statement you just made is a little scary.
Well, it's kind of a niche market, and I don't go into, I'm not doing that all the time.
I'm just asking for a verification of signature, because what that statement makes me say, uh-oh, to be perfectly honest.
It should make you feel echo.
If you say, here's a guitar, don't want to touch it, because it's a signature, but you don't want to say yea or nay. On the signature alone,
Well,
medium, irregardless, versus paper, because when people are doing petitions, they're sometimes at Kroger, or they're getting knocked on the door, or they're just, hey, do you mind signing this? And it's on somebody's back. That's why I'm asking the question.
Well, what I'm saying is guitars are coming from different places. People sign famous people's signatures
And that's why they hire
a
experts.
lot more, they get more skillful in doing that, and they get more high-tech a lot of times.
But you have the best technology. You stated you have.
Yes, I do.
So why would you be wary if that was the issue?
That's just not my specialty.
Okay, well then I'm just
I want to
asking.
stay in my lane.
Okay, so let me ask a question on the web signature.
Mm-hmm.
So I see your notes here. Talk to me about the affidavit signature and the voter declaration signature in regards to the back end of the first part of the signature, because it looks like towards the end of the signature, you have some things that make it where, with all those things I just previously said, and it probably also goes to what you said probably as well, because you said probably versus strongly in your paperwork here.
Right. Well, with Michelle Armistead.
Oh, no, I'm about web right now.
I know, but
Okay.
I'm going to reference back.
Okay.
And tell you why. Okay, on Michelle Armistead, we had first and last name, clearly formed letters. We had initials on two of them. One of them did not have initial. Now, you go down to Jeffrey Webb. Here we have, on the knowns, we have a first and second effort to make the first and last name on two of them. And then on the third one, it's kind of the third signature is kind of a combination. And, it's not quite clear because the letters aren't fully formed if it's a combination of Jeffrey and Webb or Jeffrey Webb, because those letters are not formulated. Do you see what I'm saying?
You're the expert. That's why I want to.
Yeah, so, but with the signature that is closest to his, okay, which would be the third one, is all of it's kind of together, it still doesn't match. We still have the upper and lower portion on the J, right? It's just the rhythm's wrong, the connection strokes are more angular and higher pitched. And the Q1 looks more rhythmatic. So to me, it's not a match. And because I don't have more comparisons with that specific formula of his signature, we call it a highly stylized signature, then that's where I limited my opinion.
All right, one other question, back on Armstead. So you looked at her signature with known writings, correct? These are the ones that you have here?
Correct.
And I'm asking because we spend a lot of time doing this.
Mm-hmm.
Did you look at the print signing name of Armstead?
The print.
Yes, because you say you compare either signature to signature or print to print. Did you look at the print?
In this case, I did not do the print.
Interesting.
I didn't have, I wasn't hired to do that.
Okay.
So I'm
That's
not-
why,
right.
since you had information, I just want to know if that was done and
That was not the request.
just on the signature, not on the print.
Yes.
Okay, thank you.
You're welcome.
Do any of the other commissioners have questions? Yes, Coordinator Goins.
So I have a question. On the print, seems to me there's three questions other than the two that you've mentioned, where print seems to be the way that the individual either did or didn't put their signature on that petition. Did you have cause to look at those signatures? Did you look at those printed signatures?
On which signatures?
Ian McWilliams and the other two SOPs that are in question.
Okay.
I'll answer that for you, Coordinator Goins. When she told me that she can't analyze print to signature, that told me I don't need her opinion.
Okay. Well, Ms. Pearson, are there any instances where you can analyze printed signatures?
Yes.
And so what are those instances?
Well, I have to have something comparable to go by. Something that's known, a collection of known comparisons, and then I take the characteristics and determine if I think they match within the inter-comparison of the gnomes. And then after I do that, it's just like you do the cursive.
So if the voter registration card, there's printed letters on there, you could look at that and determine whether it's probable, strongly probable.
With appropriate evidence. I mean, I can always examine a body of writing or anything in question and have something comparable to make an assessment and, render an opinion if I have comparable evidence.
Do you need more evidence to verify something that's printed versus something that's done in cursive?
It depends on the case. It just, I like a good collection of evidence, no matter what I'm working with.
Okay. All right. Thank you very much.
You're welcome.
And I would just highlight that all the known signatures were signatures on the voter registration card. The only time print came into the equation was when it came time to putting those names on a petition.
Do any of the other commissioners have questions? Ms. Peterson, I have some questions. Thank you for being here. Is examining documents your full-time occupation?
It is.
Okay. Do you have any other jobs?
No.
Okay. All right.
I am a registered dental hygienist.
Right.
Okay. I have a license in that.
Right.
I've not practiced for 2 years.
Okay.
Okay.
All right.
So.
Okay. Now, your study of document examination has been online?
Yes.
Okay. Have you had any personal training or education in document examination?
Personal, you want to clarify that?
Yeah, I think I've seen that you've had no personal supervision or evaluation as a document examiner, but rather your work has been done online.
I've had mentorship the entire time.
Right. Okay. All right. And was one of your mentors Ms. Klockenhammer?
Copenhagen?
Yeah, Copenhagen?
Yes.
Okay. All right. And you're certified by something called the ISFDE?
No, that was the first online or interactive school that I went to. We
Yes,
had
ma'am.
online training. I am certified through the Scientific Association of Forensic Examiners, which
Okay.
I've also been the treasurer of that organization since
Right.
2014.
Okay. You have not had any FBI training?
No, I've been certified by SAFE as well
All right.
since 2017 and have maintained that certification ever since. And I have a 100-page FDE, my journal of education. I attend classes each month through SAFE and also seminars yearly.
There is such a thing as in-person training like at the FBI lab and through the
I have not-
military, et cetera. You have not done that.
Right. I have been privately trained. I have not been government trained.
All right. Have you testified in an election matter before?
Not before. I've not had the request.
Okay. I want to ask you some questions about factors that might strengthen or weaken your ability to reach a conclusion. One thing that I've heard, and I think it's true, is that students nowadays are not being taught cursive, which is how we sign our names. Has that been a problem in your work, especially with younger people?
No, because younger people aren't usually my clients.
Right, but I'm talking about looking at their signatures. Has there been any research done about whether younger people not being attuned to writing in cursive, whether that will weaken a person's ability to examine the signature of a younger person? In this case, like like Jeffrey Webb, I think we would call him a younger person.
Yes. Well, I'm still looking at utilization of space and where people begin and end their signatures, their proportions, how large they are,
Right.
The arithmetic movement of them. Does it impact it? Yes. I mean,
Okay.
I heard earlier that,
All right.
People don't take time to sign their signatures appropriately or
Right.
have much complexity to them.
Right.
You really should. You should
Sure.
take your time, and if you sign anything, you should get a copy of whatever you've
Right.
signed.
Sure. And you don't have that information. You don't know how people signed these things. They might have been in an entirely different circumstance when they signed one exemplar as opposed to another exemplar. That's correct, isn't it?
I don't know the circumstances
Sure.
under the signing.
Yes.
No, I do not
Yeah,
know
you
that.
would have wanted to know that, right? I mean, that's something you'd want to know.
Right. I usually
Right.
ask if there's infirmities during the time of signing.
Right, but if somebody, for instance, signed a document at a kiosk, that would be one thing. Signing it on a flat surface would be another, correct?
Right, and to that
Okay.
point, if somebody signed at a kiosk on electronic signature, I would want a collection of electronic signatures to go by.
Right.
And then there's also an electronic trail.
Sure.
So, it's,
And
you want comparable evidence, and that's what
Right.
I try to
Okay.
educate any potential
Sure.
person that comes to me.
Sure, and you don't have any information about whether these signatures were done on a kiosk as opposed to on a flat table or desk or anything of that nature.
This was a voter declaration card, and I mean,
Right.
I can't substantiate that's ink to paper, but I think it is. On the third
Right.
known signature.
What about Ian McWilliams?
I didn't review that signature.
Okay, all right.
It was just these two.
Okay. But you are aware, aren't you, that many voter registrations are done through the motor vehicle
She's not
division on a
qualified to
kiosk?
answer that, Mr. Chairman.
Let me ask her the question. If she tells me she doesn't know, then she doesn't know. You don't know whether any of these signature exemplars you looked at were done at motor vehicles, for instance, on a kiosk.
They're not identified at being at motor vehicle.
You didn't have that information. I'm not blaming you. I'm just trying to figure out what you knew when you arrived at your conclusions.
Well, I had a voter declaration and an affidavit and a voter declaration. I don't know where they were signed.
Okay, all right. Yeah, you don't know where the petition was signed, and you don't know where necessarily where the voter registration was signed, correct?
No, I
All
do
right.
not.
Now, also, isn't it an important factor when you're evaluating somebody's signature to know whether one signature was done at one age and another signature was done at a different age, because signatures change over time due to aging, correct?
Like I said in the beginning, they can, but they don't always.
But that's a factor you
But
want
that can be a
to
factor.
evaluate, right?
Yes,
Okay.
absolutely.
Arthritis is a factor, correct? Any health issue is a
Any
factor.
infirmity that can impair
Right.
the writing skill of the individual can be a factor.
Stiff fingers would be a factor. You have arthritis from stiff fingers, correct?
Mr. Chairman, can we stop with the leading questions at least? I don't mind you questioning her, but leading questions seems a little aggressive and not reflective
sorry.
of what we're trying to do, which is get to the truth.
Right, okay.
I would appreciate you not
Okay, objection overruled. What about the death of a family member? Would that be a factor? Any kind of stress, for instance?
Anything can be a factor.
Right, a divorce could be a factor.
Anything can be a factor
Okay.
to the effect.
All right. Taking a medication might be a factor. If you're taking a medication at one time and not taking the same medication at a different time.
Answers that you don't know. Your answer is, I don't know, all I can be doing is
Each case is a case in and of itself, and
Right.
each case presents its own set of factors. And,
Right.
you know, that's different for each case. Some
Right.
things can factor into a case and make a difference, and that same thing could be in another case and not make a difference.
Right, and these are all factors that you don't have any information about, correct?
Right.
All right. What is a suitable time period for comparing one signature to another signature? In other words, if you've got one signature that's in 2016, is that suitable to compare it to a signature in 2014? I'm sorry, 2024.
I like signatures before, during, and after the event of whatever is disputed. More before is better.
Right.
You're right.
So I've heard it, I've seen it written that 2 to 3 years is a suitable time period, and that's kind of a sweet spot, but if it's longer than that, that could be a problem. Is that right?
It depends on the case.
Right.
Some cases span 20 years of signatures and there's not change.
Correct.
It could be that way.
But-
It can be the other way.
Right. But 2 to 3 years is thought in your profession to be a suitable period of time to compare one
Yes.
signature to another signature.
Absolutely.
All right,
Yes.
okay. So in addition to the other things we talked about, the angle of the surface somebody writes on would be a factor, whether they're sitting down or standing up, whether it's done through a car window, et cetera. Those kind of things would affect the signature and would affect a conclusion based on those signatures, correct?
Yes.
What about the space for the signature? If you were given a small space to sign, and then you're trying to compare it to a signature somebody signed that gave you much more space to sign it in, wouldn't that be a factor?
Yes.
And then I gather that when you studied these, you kind of either squished them or spread them out in order to remove that factor. Isn't that right?
That's incorrect, sir.
Okay. How did you, weren't these signatures, some of these signatures longer with more space as opposed to shorter with less space to write them in?
When I extract them and take them into PowerPoint, changing, when I align them, it does not change their proportions.
Okay.
So it does not affect this. Okay. And I do my alignment, you can see with this signature, the first stroke to the left is what I've lined up, and then it is to the right. So okay. I'm not changing proportions on these signatures.
Okay. Would it be fair to say that whether the signature was done by a ballpoint pen versus a fountain pen would be a factor?
Yes, that can be a factor.
All right. And a stylist, like, you know, how you sign sometimes without a pen, but just kind of something a little pointy, that would make a difference. And signing with a finger would make a difference also, correct?
Yes, but handwriting is your brain writing.
Sure.
And the movement is reflected. I mean, there's been studies done that people write with their feet, and they'll make the same letter forms with their feet as they do with their hands if they're in,
right.
In those.
The number of times something's been copied before it comes to you, that's something you want to know, isn't it?
You don't know how many times things have been copied.
Well,
unless you get the original.
Correct.
I mean, I would have to take hearsay that it's a first-generation photocopy.
All right, and you didn't have the original.
I did not have the original.
And by the same...
Everything, Mr. Chairman, everything that was sent to Ms. Peterson was provided by AOE Roberts.
Okay. That even the type of copy machine that the copies were made on would be a factor in comparing signatures, correct?
It could be.
The quality of the machine, how new the inkjet print was would be a factor, correct?
Yes.
Now, having an original is important, isn't it?
Yes, I prefer originals.
All right. Did you ask for originals in
Yes,
this
I always
case?
ask for originals.
Did you ask AOE Roberts to look at the original signatures on these petitions?
I wasn't hired by him. I don't.
So but you asked Mr. Hollins for the original? Mr. Holland for the
Yes.
original?
No
Okay.
S in Holland, sir.
Excuse me?
Please, it's disrespectful at this point that you keep doing it. But
Did-
in the document that was submitted timely for evidence, it has an exact copy of the petition of candidate Jennifer Fremsley Webb with color that matched the original as provided by Administrator of Elections Jeff Roberts.
Okay. But having the original is still important, right?
I would always examine an original if I have one.
Sure. And in fact, I believe you've testified that you need the original to make a conclusive opinion.
It depends on the case.
Well, wasn't that your opinion in the Yarborough case in 2018?
I don't remember exactly about that case.
But you wouldn't question me if I told you that's what appears in the judge's decision from the Tennessee Court of Appeals about your testimony, that you testified in that case. You need the original to make a conclusive opinion.
In that case, I did.
All right. Now, there's a distinction between informal and formal signatures, isn't there? I've seen that in the teachings on document examination.
Yes, some people have formal signatures and some people have just stylized signatures that,
Right.
some people can only sign an X. So,
Sure.
I mean,
And I think what I've read is that people sign their signature more naturally in an informal setting. And in that way, you'll get a more true signature. I believe I've seen that from your mentor, Ms. Koppenhaver.
I don't know what you're referencing, but I wouldn't say that's wrong. I'd say that's true. But
Okay.
I
So-
don't have your reference.
Sure. So then if somebody perhaps viewed their signature on the voter registration card as being formal or informal, that would change how they might sign their signature, correct?
That's a variable. I mean, it's
Right.
hard to say.
Sure,
I
that's,
mean,
I
a lot of these
understand.
questions, like,
Okay. And how many samples do you want? I mean, I think you've got, 2 samples to compare to for most of these, or maybe 2 or 3. How many do you want? What's optimal?
there's not a minimum, but, I'd like to get 10 to 15.
Okay, all right. And
Maybe
isn't it in a situation where you're trying to say somebody did not sign something, isn't it the case that you need many more examples to go by, many more exemplars?
It depends on the case, but not in this case. I gave an opinion that I laid out accordingly and appropriately, I felt like, due to the evidence that I had and the collection of evidence that was rendered to me.
I understand, based on what you had. When you trained with Ms. Koppenhaver, did she tell you that the average number of exemplars, if you're trying to exclude somebody's signature, is 25, and that 100 might not be enough?
I think that's case dependent.
Well, let me hand you an article that she wrote. Ms. Harrison, can you?
I would just like to repeat my objection that the statute constrains this commission and anybody's consideration to the voter registration card and the signature. This is hearsay on hearsay.
All right. Is Ms. Koppenhaver, is she an authority? Do you consider her to be an authority?
Yes.
She's one of the people that taught you. And would you consider that an article written by her to be authoritative?
I have not
Had
reviewed this.
had occasion to read this,
No,
and certainly not going to answer questions about it or testify about it. Her testimony is going to be limited to the signatures of Jeffrey Webb and Michelle Armistead. And that concludes it. What this is,
So you're
I
instructing
don't know.
You're instructing her not to answer my questions?
Correct. Some
right.
document, some
Okay.
7 or 8 page document that we have no idea, that cannot be authenticated by you. You can't authenticate this.
Ms. Peterson, do you object to reading an article by Catherine M. Koppenhaver? Is that a problem for you?
It is tonight because you can't authenticate it, Mr. Chairman. This is something you got somewhere off the internet, presumably. I'm going to get to speak. I'm going to get to speak right now, Mr. Chairman.
I'm asking the witness a question and you're interrupting me.
You'll get to it when I tender her to you. Not right now.
She's already been tendered, Counsel.
Not anymore. If you're going to badger her with something found on the internet that has no application to this case, if you individually don't want to credit her professional expert opinion, that is fine. I'm not going to let you use something that you found on the internet to disqualify her. It's hostile and unprofessional and unbecoming.
Mr. Holland, there's no need to raise your voice. Nobody but you is raising your voice. I'm just trying to examine the witness, which I believe I'm entitled to do. We move this document in evidence. Ms. Koppenhaver, Ms. Peterson.
Mr. Chairman, do you have copies of that for the rest of us?
I do.
Thank you.
I don't have a billion of them, but I got one for you.
If I could at least see it, that'd be great. Thank you.
How much time do you usually have to prepare a report when you've been given an assignment?
It's probably 8 hours.
So you can turn out a report in 8 hours?
I don't. But
I'm
take
sorry.
8
I
hours
was
worth of time.
I was unclear with my question. From the time you receive an assignment to the time you prepare a report in terms of days, how much time is usually allotted to you?
It depends on my caseload and how complex the case is at the time. It depends, how much time I allow I can put cases back and take cases in front of other cases to accommodate people at times. So, and that's what I did in this case.
Okay. Would you have wanted to have more time?
For this case?
Yes, ma'am.
Objection, it calls for speculation. Irrelevant. Don't answer that.
Okay. Now, I believe I've seen it written that if the signatures were too similar, that would be a problem. That might indicate some fraud. Is that the case?
In this case?
I mean, generally, if signatures are too similar, that's a problem.
Well, I have software where I can overlay that to know if they're identical or not.
But if the signature is identical, that could be an indicator of fraud, correct?
well, fraud is left up to the trier of fact, and that's up to, I identify handwriting, and it's up to the trier of fact to determine if something's fraudulent or forgery. I don't determine those factors. I give my evidence, weigh out, give an opinion, and let that fall where it may.
And Mr. Chairman, I'd remind you, to the extent fraud's been involved, Jennifer Frensley-Webb has already admitted to it, in as much as J. Allen Sipe signed for Joseph Walker's site. April 11, 2024, email 2:18 p.m.
Did Ms. Koppenhaver teach you that since no one can write his signature exactly the same way twice, identical signatures are generally evidence of non-genuineness?
Objection. Calls for speculation.
Is that part of? Is that part of what?
Koppenhaver's teachings have no relevance here today.
Is that part of what?
Up to you whether you want to answer that, but that's gibberish on gibberish.
Is that part of what you were taught by Ms. Koppenhaver?
That is not relevant to this case. There was not any identical signatures in this case.
Mr. Chairman, if you're questioning from the document, did she have time to read the document?
I'm happy to let her have that time, but her lawyer told her, not to. So that's my concern is my line of questioning has been cut off. And so I'm doing the best I can.
If you want to go into recess for an hour so we can read this and I can talk to her about it, I'm happy to do that, and we'll come reconvene in an hour.
It's a 10-page article of stuff she's already been taught.
I read very slowly, Mr. Chairman. Sorry about that.
Well, I don't believe it would be appropriate, Counsel, for you to be in there doing what you're doing right now, most respectfully.
I feel the same way, Mr. Chairman.
Now,
this is a piece of process right here.
Okay. Now, it is common, isn't it, for people to sometimes use printing when they're doing their signature, isn't it? I mean, that's not necessarily anything that would be indicate a lack of authenticity.
Are we questioning from the document again? I just want to know if we're taking a break.
I'm asking her a question.
You're just generally asking her a question,
I'm
not
asking her a question.
from the document?
Well, again, I'm asking her a question.
Can you re-ask that question?
Is it a problem when people use printing for, let's say, they might print their first letter of their name, when sometimes they use cursive for the whole thing, for their whole name? That's not a real problem, is it?
Again, comparable evidence. How do they normally do their signatures? And then you take that and compare against what's in question. And does that person write that letter A, or do they not? I'm looking for natural variation, and it was not found with this collection of evidence I had. And that is what is relevant in this case, and it's hard to speak about other cases, and because there's so many more factors that go into every case, and you can't apply what goes with one case to another case. It's all individualized.
Now, is there a role of where motive is a factor? If you're looking at somebody who's being accused of forging a document, is their motive in doing so? Can that be a factor?
With all due respect, I think I've said this multiple times, and respectfully, anything can factor in to a case. I don't see it factored in this case, and I've weighed the evidence appropriately and given an opinion accordingly, and I don't think it's aggressive in any form or fashion with what I had to work with in the collection I had.
Do you have any information indicating that the persons whose signatures you examined had any motive to falsify a document or do anything improper?
I don't like to know the background of any case, and I enter every case like everyone's lying to me, because that's what I should do as an expert. Okay? I should stay in my lane. I should weigh out the evidence and what it presents and give an opinion accordingly. And that's what I try to do each and every day with my job.
Now, what information were you given when you were first retained in this case?
There's a petition, and there was some question signatures, disputed signatures on it.
Okay.
Nobody said fraudulent. We don't know fraudulent. That's up to you all to determine fraudulent or forgery. It was disputed signatures.
And did you look at only the 4 signatures that are in your report?
Yes.
Did you discuss
Well, there's 2 in my report.
I'm sorry, I understand. Okay, and those are the only 2 you were shown?
Yes.
Did you know which side of this matter you were going to be testifying for?
No, not initially. I don't like to know anything. When people start telling me their story, I'm like, stop, I don't want to hear it. After I do my assessment, give an opinion, then you tell me your backstory. That's what I should do. I try to remain unbiased. I'm human as anyone else is in this room. I don't care what party you are. I don't care what you're running for. I only care about the signatures and what they can tell me, nothing else. And there's many times I have to tell people stuff they don't want to hear. But the truth only hurts until it sets in, and that's where I'm at in life, in work. It is what it is, and this is the way I see it. This is the way it weighs out, and this is how it's supported. And that's the front and the end of it. No bones about it.
Looking at the bottom of page 1 of your report, do you have that in front of you?
I have to pull it back up.
It says any significant unexplainable fundamental difference would be sufficient to eliminate the writer. Do you see that?
Yes.
Okay.
Excuse me, I need for you to slow down a minute. She's scrolling through here. And
I'm
I guess
sorry.
She's going to where you're going to be talking.
Now I think it's now up.
So let's just ease along and help me
Okay.
see it, please.
Sure. Now it's at the bottom of that page, I think.
Thank you, Chairman.
Okay. Now, when you're talking about unexplainable fundamental difference, did you try to find an explanation? Did you ask for an explanation for any of the differences you saw in these signatures?
Ask who? Ask
your lawyer, or ask anybody for information about how these signatures were done. We've identified probably 10 to 15 factors that could have made a difference about these signatures. Did you try to get an explanation so you could have a conclusive conclusion?
To To clean up your apparent misunderstanding, I'm not her lawyer. I represent Representative Bo Mitchell. That's my client. She's the expert hired on his behalf, but I'm not her lawyer. You understand, Mr. Chairman? Thank you.
Do you remember the question?
No, I don't.
Okay, I understand. We've identified a whole host of factors that could affect a signature. Did you try to find an explanation, or did you seek an explanation for differences you found in these signatures?
No, I did not.
And at the top of page 2 of your report, it says you analyzed, compared, and evaluated all the evidence in this case. It would be fair to say that you evaluated just the evidence you were given by Mr. Holland, correct?
Yes, the evidence that was rendered to me.
Sure.
Yes.
And then, let's see, under step 1, you said the quality and quantity of the exemplars were accepted for the examination, correct?
Thank you, appreciate it. Yes.
Okay. You didn't ask for more exemplars, and you didn't ask for the originals, isn't that correct?
Objection, asked and answered. No, I'm just kidding. I think you might have gone through a few of these already. I'm not trying to cut you off. I do really think she's answered.
She would have answered the question already by now, but can you answer the question?
My standard method of operation in what I'm doing, in my profession, and what I do personally, I try to educate any potential person that wants an answer from me, an opinion from me, on the quality, the quantity, and how contemporary things are. I have a verbal conversation, and I also have an email to that effect. And I'm welcome, and I try to remain very responsive if they have any questions about any of that. So, I feel like I have listed exactly what I've done in the report. I've identified and labeled everything correctly as I was given. And I've tried to be very forthcoming with my examination process and listing out all my steps and how I do it.
I don't have any further questions at this time. Do any other commissioners have questions?
I would just like to note for the record that your time in Q&A exceeded all our time in presentation of the case.
I do want to make sure that the article from Ms. Koppenhaver be made part of the record. And ma'am, if you want to take a moment to read it, and after you look at it, let us know whether you're satisfied that this is one of her articles from her attorney's guide to document examination. Let me ask you this, Ms.
And for the purposes of the record, I would object to its inclusion in the record.
All right. Ms. Koppenhaver.
Mr. Chairman?
Yes.
Wait, no, go ahead.
Were you Ms. Koppenhaver? I'm sorry.
Ms. Koppenhaver, Mr. Chairman.
Excuse me. Ms. Peterson, I apologize. Did you study under Ms. Koppenhaver and study her book, Attorney's Guide to Document Examination?
Yes, I have. I've got my CV with all of those.
Right. In fact,
and I've got her listed there.
Could it be that you have that book in your library?
Yes.
So it wouldn't take you very long, would it, to figure out whether this article I've been asking you about is actually from her book and the book you have in your library?
As soon as you get it authenticated, we will consider it, and we will come report back to you in 60 minutes after the conclusion of Ms. Webb's presentation of her case as already answered. Thank you, Mr. Chairman.
So, ma'am, how much time would it take you to look at this article and tell us whether it's from your mentor's book?
It's certainly not going to happen prior to the expiration of Ms. Webb's presentation of her case, because we're going to be listening to that, Mr. Chairman.
So you're refusing to let this witness read this 10-page, very big, double-spaced article that I've handed to her and asked her a question about. Is that the truth?
Number one, it's not double-spaced. Number two, I asked for time in rebuttal because I'm following the rules of procedure. And according to the rules of procedure, passing out homework assignments to the expert of the challenger was not listed. If I would have been on notice, I might have considered that. But here, we've not been on notice on that because you're changing the rules of the game in the middle of the game, and you're the only one.
Ms. Peterson, how long would it take you to look at this article and tell us whether or not it is from your
Asked and answered 1 hour.
I'm sorry, Ms. Peterson, can you answer the question?
It's late. I'm tired. I don't want to read a 10-page article at this point in time. I don't mind to do this and come back at a later point in time. Thank you.
Okay.
Mr. Chairman?
Yes, sir.
Yeah, I'll be honest with you, you've kind of lost me altogether anyway, so maybe if we just if you could just explain to us what you think she would say or what your point you're getting to. I have no clue about what you're talking about or where you're going with this.
Well, I'm sorry, but this article basically explains that there's a whole lot of factors that go into a signature.
I would certainly object now. Now he's testifying as a witness. He's supposed to be the chair conducting these proceedings, and now he's testifying. That surely must be excluded. If not, I'm objecting to it for the purposes of the record when we go up the way this is going. Thank you.
Mr. Chairman.
Wait a minute. Mr. Burns asked me a question.
I was going
to. And I'm trying to answer his question in a low-key way, and I'm trying to move on. But this is an article that talks about basically the process that this witness went through, and it talks about all these things like you should have an original. It's really important how many times something has been copied and over again before you can arrive at these conclusions with any degree of certainty. So I was trying to ask her questions about that, and under the rules of evidence, she's already admitted that her mentor is an authority in the field. So under Rule of Evidence 618, this comes into evidence as part of her cross-examination unless somebody says that this is just an unauthentic, phony document that really, I guess, I prepared myself and it's not authentic.
That's what I'm saying it is because you can't authenticate it.
That's why when I try to ask the witness a question, Mr. Hollins is interrupting me because, I don't see it. She's got to know what this is. She's got this book in her library. She's seen this before many times.
Mr. Chairman, can I recognize, please?
Yes, you unless Mr. Burns, do you have?
I might have a.
Do you have?
I'm trying.
Are you done with your question? I'm sorry. And yes, yeah, go ahead.
I'd like to try to just get this a little bit back on a procedural rail if we could. And I think the conversation that you all are having right now might be more appropriate for when we're deliberating. We still haven't gotten the case yet from the councilwoman who still has not yet presented her case or her witness. So I appreciate the back and forth and the dialogue, but that feels like deliberation, and that is not supposed to come on our agenda until we've heard from all the parties. We've kind of veered off after one party, and I think it's probably more appropriate if we get back on. And I know we ask questions and stuff, but I mean, if I was cross-examining people, I'd be cross-examining people. I mean, I'm trying to be, I'm not a lawyer for a party. I'm not cross-examining people. I just ask questions to learn the information. So if we could maybe, I'm not I'm not trying to cut off anybody's questions, because Lord knows I ask plenty of them all the time. But I think if we could get, I mean, it is 10:30, if we could maybe hear perhaps from our council person, I would like to move on to that portion if we're done with questions for Mr. Holland.
I did have a question for Mr. Holland on, in your letter of April 26th to Mr. Roberts, you indicated that we will be challenging the following, and you listed 4 people.
Can you put that up on the board so I can see what you're talking about?
I can hand you my copy.
That'll work.
Well, if you, yes. Here. And that appears on page 30 in our big notebook under tab 26.
Go ahead.
Well,
or do I got to give it back to you? Then you're going to ask me a question?
No, I can ask you. No, that's fine. It appeared to me when I read that you were limiting your challenges to the 4 people listed in that letter.
Well, that would be wrong.
You don't mention anybody else. Was there anything in that letter that would have put the respondent on notice that you were going to be challenging other people?
Yes, because on April 18 at 12:18 p.m., Administrator of Elections Jeff Roberts wrote an email to Council Member Jennifer Frensley Webb. And he writes, Ms. Webb, the following signatures on your petition have been challenged by Bo Mitchell, J. Allen Sipe, Mary Ann Sipe, George Sipe, Stephen McClure, Michelle Armistead, Robert Jeffrey Webb, Ian McWilliams, William Sipe. If that's not notice for the respondent, I don't know what is, Mr. Chairman.
But you've changed that since then. You've changed that list, haven't you? The long list you just gave me?
Yes, today.
All right, and then
as reflected in my prior presentation.
Right. And then you changed it again. You changed it again on April 26th, didn't you?
Oh, come back. I don't know the date on that piece of paper.
Yeah, that's April 26th, which was the deadline, I believe, and it sure looks to me like you changed.
No, I did not, and Mr. Roberts understood that to be the case because initially, Representative Mitchell emailed Mr. Roberts, I believe, and notified him of some challenges. I don't have that email because I didn't send that email. Representative Mitchell sent that to Administrator of Election Roberts. And thereafter, I was hired. And all these names are in this email. Michelle Armistead, Ian McWilliams, Jeffrey Webb, George Sipe, which also matches the names of the people that was presented in the challenge today.
Okay, I don't want to belabor the point, but...
Yeah, because I made a good one.
But
Thank
in the April 26th letter, you mentioned 4 people, correct?
I mean, you're trying... No, that email says more than 4 people, and if you want me to read them to you to prove that it's more than 4, I will pass it back. Okay. But don't tell me that paper says it's limited to 4, because that would be false testimony, and I know you don't want to do that.
Okay, I'm just looking at this page 30 under tab 26.
It is not limited to 4 names. No, sir.
I don't mean to
no,
cross,
sir.
I don't mean to
because I'm going to need to put you under oath here in a minute.
I don't mean to cross-examine the lawyer. I'm just asking the question.
Well, I would say that piece of paper has as many names on it as there are, not what Chairman Delantis can count to.
Okay, all right. I don't have any further questions. Unless, do any of the other commissioners have questions? Okay. Okay.
Wow, I really don't know where to begin after all this, but I'm going to begin just with some facts. First of all, I want to know, since there were so many signatures challenged, I'd like to know from Ms. Peterson, how many did she actually look at that were challenged? How many different signatures were looked at and that she challenged?
Mr. Chairman, I think that's been asked
What
and
was it?
answered.
I'm
I
sorry.
believe that she's looked at
Just the
two.
two? Just the two, okay. Okay, I wasn't for sure. Okay, so, second of all, anybody can look at her contract that she sends out to people, and in her contract, she states that in order to really do her, I'm using wordage, okay? Quantity, up to 20 signatures in the same allograph, print to print, or cursive for comparison purposes. Original documents with red ink are always preferred to examine. Next would be a high-resolution color. If a digital format is all you have, please forward it to me. I don't think she had that supplied to her on any of the signatures that she looked at mine. I'll make this easy because I know everybody's tired and everything. If Alan and Marianne and Will want to stand up, and y'all want them to come up here? I just want them to testify that they signed my petition and y'all have the affidavits.
All right.
Would you like for all three of them to come up here?
That'll be fine. But that's your decision, but that'll be fine for you to do that.
Alan, Marianne, and Will, did y'all not sign my petition, my original petition, and then sign the affidavits?
Yes, I did.
I signed as well.
Alan?
I signed the petition.
And the notary is sitting right over there, Mr. Steve McClure, which was challenged, y'all can sit down, thank you, which was challenged up to 2 o'clock today. All of a sudden, all these people that I had to search, hunt down, pay a mobile thing, because Steve wasn't always ready, it came down to 5 signatures now, okay?
All right. Let's make sure we have the last names of the people that just testified.
Okay, Sipe, and Sipe.
Okay.
George Sipe I could not get an affidavit from George Sipe, which I stated earlier. His mom and dad will testify they saw him sign it, but he is in boot camp now. Which can be verified. He did not go to boot camp until April the 15th. You can look on Facebook, under his thing, shows him hugging, going bye-bye. He signed the petition.
And he does go by George Wyatt.
Yeah.
He goes by George.
So, and as far as the printing, I'm glad he brought this up earlier. We don't teach cursive, so a lot of kids, I'm around a lot of younger guys, they print now because we don't teach cursive, and a signature at our age was cursive.
Before we go on too far, the lady in the second row just testified. Ms. Court Reporter, did you get her testimony? We need her identified on the record about what she said and her name.
He answers to George.
No, I'm sorry, your name is, the court reporter needs to type down your testimony, and she has to know who you are before she does that. What's your name, please? Marianne Sipe. Okay, this is court. All right, okay, tell us.
Object to the characterization that what she said was testimony. It's not testimony. She's talking about what her son goes by when he's a grown man, looks like, and he can testify for himself.
He's not here. He's across seas, if you would pay attention.
Okay, all right.
If we could get
Please,
Okay,
we want to
Let's
get.
move past that. Let's
Hold
move
it,
past
hold
that.
it.
She doesn't
If we can,
testify to somebody's not here.
hold it. We've got to get this down. Tell us what your testimony is. It is testimony. She's been sworn in as a witness.
Chair,
Yes.
yeah, anyone that's speaking needs to come to a
I
microphone.
think that would be
Okay, come
best.
to the podium.
Yes.
And
I'm just trying to save
if it
time.
is a witness, that witness needs to be sworn in.
Well, they've all been sworn.
Say what you just said again, please.
Well, it was brought up that
Just be simple.
it was unlikely that my son goes by George, and he does now. And he's proud of that name, and it was mentioned earlier that it was questionable, and I just wanted to make that clear as a mother. So
All right. Did
if you want to call that a testimony, it's just something I observed earlier.
All right.
Yeah. Anything else?
I thought you were asked about your son's signature on the petition.
Oh, so since he answers by George now, he signed his name, George Sipe, on that petition.
Did you see that yourself? Did you see that personally?
I did. And we called him Wyatt growing up, and for some reason, he's become a man, I guess, and he likes George. Therefore, he signed it George Sipe.
Okay, all right.
Anything else? Please?
I don't have, no.
Anyway, okay.
I think we're still in the presentation
Yeah.
section
Yeah, Ms.
of the
Webb.
program. We're
Yeah.
not supposed to
Now
be
I'm
in the
gonna call my
questioning
son up here.
section.
All right.
Which I wanted to leave him separate because I take it personal. I think if anybody knows me and knows how I feel about my two boys, they'll tell you I'm the toughest mama bear out there. And if he's being accused of something he didn't do, shame on the person that done it. Because my boys weren't taught like that. I stand up and I think if a lot of the council people will tell you on either side that I am a council person that tries to do things the fair way. I try to bring people together, but I am a person of integrity. And I speak how I speak. You don't ever have to worry about what I'm thinking. And for them, Jeffrey, where do you live?
I still live at home.
Okay, now, tonight, we were just thumbing through his billfold. He was over there sitting next to me. Show him what you found. Because this is important, because I just want them to know they really didn't file their stuff until after the deadline. They didn't file anything before 12 o'clock on February the 24th. They filed it, I didn't get it till February the 26th, but I didn't question that because I feel like the truth's gonna prevail here. And when somebody submits something, let him have his say. But I'd like to show this, if I can, to y'all. This was when he was 18 years old, when he did his voter registration. If you look at his original voter registration, it matches this. It matches this. And then if you look at the new voter registration that is in my packet, that we got new cars because we got put back into District 10, it matches the signature on the certificate, okay? My son signed the petition. Nobody else signed that petition. He lives at home. And I will testify that in a court of law.
Just get him to sign a piece of paper right now, Jennifer.
He's got his signed affidavit. If he signs a piece of paper right now, it's coming back.
Please,
You know?
speak
You know?
speak to the commission.
Okay, sorry.
Speak to the commission.
So, I just want y'all to know, I hope that y'all can see that this was just a forced about, I don't know if he challenged after Laura Nelson decided to challenge. I think so. And I believe both parties, to some degree, have made a mockery of our democratic system. I'm going to go back to Ms. Harrison over here. I know she tries to do her best. And I hate that what this election commission does has come in to say, because I know they're good people and I know they try. And I believe if we let petty signatures come into the play at the end of the day, we're opening a can of worms for our system that they do. I think we have to have some leeway that she knows what she's doing. She certified me. I want to be certified. I feel like I should come back and be certified, and I hope that's what y'all come back to. Do y'all have any questions?
Yes, Commissioner Davis, you're recognized.
So the voter registration card that her son showed, now would that be evidence? How is that viewed? I mean, obviously it was shown, so I'm asking legal.
Are you asking me what weight?
So
you
when,
give
so
to
when her son
evidence?
showed us the voting registration card, so how do we take that? Do we take that as evidence? Do we take that as just part of the presentation? How do we take that legally is my question.
The candidate showed, is that in this packet?
No,
No, it's not in the packet. So here's what happened, this is my understanding.
Okay.
As they were waiting, he was thumbing through his wallet, found his voter registration card with obviously his signature on it. And then in her presentation, she brought him up here and had him pull out the card and walked it around to the commissioners. The question is, how do I take that?
What I can say is that this commission set deadlines for submission of evidence, and that was the 26th. So that is the deadline that you set for evidence to be submitted.
Okay, now be careful there, because he didn't submit his signatures that went to Laura until after 12 o'clock on the 26th. Just pointing that out, so he wouldn't have no evidence. If you're getting ready to exclude any evidence or stay with the timeline, he didn't submit his evidence until the 26th. I mean, am I wrong? If I'm wrong, you can prove me wrong, that's fine. Okay, I mean, I didn't get them till after 12 o'clock on 26th, so if I'm wrong, I'm willing to say I'm wrong.
All right, are you done with your presentation?
Yes,
Okay,
yes.
so now we're in our time to have questions from the commission.
Wait a minute, Mr. Chairman.
Yes.
Let's get an answer to her question. I think I know the answer, but she asked Mr. Roberts something he was not able to answer about the timeline of Representative Mitchell's submissions. Did he meet the 24th deadline, and did he meet the 26th deadline?
They met both deadlines and submitting evidence on both deadlines. And it took me a few minutes because I'm dealing with all these people to send it back out to everyone.
I understand. I was just
Understandable.
wondering about the deadline.
Thank you.
Correct.
So she's done with the presentation. so-
Correct. Now is the time for the commissioners to ask questions.
Okay.
She is
Yeah, I mean, I
done with
think my
her.
affidavits
She's
speak for
done with her
themselves.
presentation, and now we can ask her questions.
Mr. Chairman.
Yes, sir. Yes, Commissioner
Kind of lost
Burns.
track of who all's here. Is Jeffrey Webb here?
Yes, sir.
Can I speak? Could you mind coming up, please, sir? I don't know if Mr. Holland read my mind, but he's put up there on the back, your signature. I think the one on the bottom, if I'm correct, Mr. Holland, that's the one that came off the nominating petition. Is that correct?
It is, yes, sir.
And then I'm sorry?
It is, yes,
Yeah,
sir.
yeah. I mean, you can see the difference in those, right?
Yeah, yes, sir.
Okay, can you help me understand?
That's what he just showed.
Well, I know what he just showed, but I just need to help me understand. Well, let me back up. I didn't get a good glimpse of it. So are you saying that what's on your registration card that was passed around matches the top or the bottom?
It matches the top.
Okay,
They're all my signature.
Yeah.
I signed it.
okay, I hear you. But,
Can I speak?
sure, absolutely, excuse me.
Okay, just like we were saying, there are factors in everything.
Yeah.
So I don't know exactly when I signed that, but I don't know the circumstances. Like, I'm a firefighter. I could be up all night. I could have signed that at 6 a.m., half asleep, dealing with stuff all night. I don't know when I signed that, but I know for a fact I signed that
By that, you mean, you don't know
Yeah,
when you
petition.
sign the petition or when you sign that top document, or both? I mean, it could be both.
I don't know the exact date of when I signed either one of them, but
Okay.
I know I signed them.
So I guess my question is, and you're kind of going that direction, can you, I mean, you've acknowledged and recognized that clearly two styles of signature, and I hear you say you signed them both, but help me understand how it can be so different. I just need to hear your heart there.
One, I could have took my time, and the other one, I was quick. Simple as that.
He was 18 when he signed the first one, and it matches the card that I just showed you. And if you look at his new card, which he pulled out of his pocket at home, and I didn't bring it, but I supplied it to in my packet, you'll see that it matches the signature. And if you look, I also supplied in my packet the council petition where Kelly Harrison approved his signature like that for my council run.
Mr. Chairman,
It's in the packet.
can I follow up?
Sure, yeah, you've got the floor.
You indicated, you pointed over there to those two signatures and said that, it matches that. Which is that are you talking
What are
about?
we talking? Okay, he signed this.
I'm just trying to understand which one you're referring to, and you said,
This was his voter registration when he was 18. If you look at the card in his pocket, it matches this signature.
okay.
Okay? If you look in the one that we got new cards because we got moved into District 10. That's why I ran for councilperson. It matches this, and it was supplied. And also, the council petition that y'all certified with this signature on it, it's like that.
Thank you, Mr. Chairman.
Commissioner Davis?
Mr. Webb, how old are you?
I'm 25.
And the first one that's on that exhibit there is when you were 18?
Yes, sir.
Okay, thank you.
Yes, Coordinator Goins, you have a question?
So there, I just want to make sure I understand which one we're talking about. Are you the one on number 14?
I couldn't tell you what number it is.
That's one I don't know.
Yes, 14.
And so the status is you weren't counted. So essentially the procedural part is you are saying that it should be counted, correct?
Absolutely.
And this is the one that I guess is probable from Ms. Peterson, where she's saying probably she didn't think it was probable that you signed it. But your testimony is that you signed it.
Yes, sir. 100%.
You signed the petition.
Yes. Yes, sir.
There is a voter registration card in the packet that you provided as evidence. Is that the one that you left at home, or is that the one you just showed?
No, it's the one we left at home. I had them
Okay.
out taking pictures of them.
Could you speak closer to the microphone, just so everybody can hear you?
No, actually, I had his and N. McWilliams's that are in the packet, and they're both sitting on my table at home. N travels for work. He could not be here tonight.
Yeah. I just want to be very clear on this too, because I know there's a lot of Webbs out there. You know, it sounds like that, you know, it's a family name, obviously. So number 14, you've looked at number 14 on that petition, and you said you signed it. That's your signature, you signed it.
Yes, sir.
Okay, all right, thank you.
Okay, I want to make sure I've got all these folks straight. We have a affidavit from Jeffrey Webb, correct? Okay.
That one.
And then we
the
also have
microphone,
him here in live testimony.
Yes.
Okay. Affidavit and live, okay. And then is the notary also testifying about,
Did you do his? I think you did his, yeah. Was it Steve McClure? I think Steve McClure did do his,
all right, okay.
which was one of the signatures up to 2:00 today that they were challenging, but took it off the list.
All
Can you
right.
just get a little closer to the microphone, please? There are people watching at home.
Okay,
and
yeah.
They want to make sure they hear you.
Okay, so, yeah, he did notarize, that is my notary that we used for them, and his signature was in question up till today at 2:00.
And then J. Allen Sipe submitted an affidavit, right? And is he here today also?
Yeah,
And he's-
he was. Yeah, that's him.
And he's testified?
Yes.
Okay. And is the notary here to testify about him also? All right. And then we have Mary Ann Sipe. Okay, and so that's live and notary, correct?
Yes, sir.
All right, and then Steve McClure, affidavit, live, and notary. Is that correct?
Yes, sir.
And then Will Sipe, affidavit, live, and notary. Is that
Yes, sir.
correct? Okay. Then we have Michelle Armistead,
She's on they had a vacation planned, so she could not be here.
right?
I mean, if you want me to, I can try to get her on Zoom, but she's on the beach.
Well, she signed an affidavit.
Absolutely.
Do you have an explanation for that affidavit? 'Cause
Well,
it's
I
kind of frustrating
I know.
that she submits an
Yeah.
affidavit.
I didn't
and then
stand over my
she
people
doesn't-
and tell them what to write. They're adults. And when people are saying affidavits, they're endorsing me as a candidate to run. I mean, I wish, yeah, but, even without her, I'll have enough if y'all certify the other one. So I'm not, but she signed it. She did an affidavit, and I can get her on the phone, just like we did earlier, if that's what y'all would want me to do. I mean, I can try. She's on vacation.
Well,
Oh,
what
and
about,
what time is it? Oh, it is 11 o'clock.
what about Ian McWilliams?
Yes.
He signed the affidavit in the same way.
Yeah, because I told him just to sign like which one was sitting there, and ours must have been the one sitting there. But
Well,
I can't get him on the phone because he's 20-something, and they don't go to bed at 11 o'clock. Totally up to y'all. Jeffrey can try to get him on the phone.
if I suggest we do it, we've done it once. And then George Sipe in boot camp.
He's in boot camp.
We don't have an affidavit, but we have his mother testifying that she saw him sign it.
Yep.
That's his signature.
And we can get that, but it'll be after boot camp.
Okay. Is there any problem with asking Ms. Webb to try to contact these two signatories, Michelle Armistead and Ian McWilliams?
So, I mean, the only thing is, I don't think it's appropriate for us to be asking her to do anything. It's her case, so she should be making the decision of what evidence it is she chooses to present. I think we are crossing over dangerously into becoming advocates or getting closer to being lawyers when we're asking for additional evidence for one side or the other. I think Ms. Webb is here to make her case, and if she chooses to ask to have that information, we should rule on it. But I think we need to be mindful of the fact that we are supposed to be here making decisions and not as advocates. So, to the extent Ms. Webb has a request, I'm sure we could talk about it, but I don't think we should be asking her for additional evidence on anything.
I mean, Armstead would be, they have little children, so I'll probably, I could try. Ian, I have no problem, he's up. If he is, I'm pretty sure he'll answer for Jeffrey.
Yes, Coordinator Goins.
Before she calls there, I understand we've got some live testimony here, and really I'm trying to get all this in my mind. So 10 and 15, number 10 and number 15 aren't here. Number 26, is that the one that has gone to boot camp?
Yes.
All right. And 27 is here.
And he's
Do
testified.
you mind if he will come back up, and so I can ask him?
How you doing?
So have you looked at the petition, and I think are you number 27?
Yes.
Is that your signature?
Yes.
Did you sign it?
Yes.
And have you been sworn today?
Yes.
Okay. All right. And for number 26, other than I don't have any other questions. Someone may have some questions for him. I don't have any more questions for him. But for number 26, this is the mother that said she saw her son. Who is that you? All right, do you mind coming up?
It would help the record if they would identify themselves for the name before speaking.
Do you mind identifying who?
My name is Mary Ann Sipe. I am the wife of Alan Sipe. This is my middle child, Will. My oldest son, Wyatt. George Wyatt is in boot camp at Fort Moore, Georgia. And I have another son, Joseph Walker Sipe.
And so Will was the one that just testified. Is that correct? He's number.
This is Will Sipe.
Yeah, he's number 27.
I think 6.
Huh?
I know.
26.
Will
Okay.
Sipe, Will Sipe is on the bottom.
Okay. Okay.
27, it's Will Sipe. Yeah,
Okay, thank you.
right there.
So you're the son that's in boot camp. And first off, thank him for your service and it sounds like you got a family full. And so of folks in the service, and we do appreciate that, of course. But the number, for the record, the person that you're saying that signed this petition, which number is he on the petition?
George Sipe.
Which?
Sorry, 26. It
Number
says
26.
number 26, George Sipe.
And
That
so-
is, okay.
Yeah, and so 26 was counted, correct? And it's Representative Mitchell is saying that this one shouldn't be counted. That's the posture that we're in. And you're saying that you personally viewed him sign that signature. Was there anyone else saw him sign that signature, or are you the only one?
I'm the only one.
Okay, I was just see if there's anyone else here, to also say the same thing. Not that I don't believe you, I'm just asking, more corroboration if there were any. Okay, all right. And when did he leave for boot camp?
The 14th, it was a Sunday, I think.
14th of April?
Uh-huh.
Okay, all right. Thank you. I don't have any more questions.
I do. If that's okay.
Commissioner Hertzfeld, you're recognized.
I just have a couple, Ms. Sipe, if you wouldn't mind. I just want to be clear, because you've got 3 boys? I've got 2 and a girl, so I understand everybody can get real confused. Okay, so Will testified, George is at boot camp, but your third one is Walker Sipe, and that's the one that everybody agrees either you or your husband signed their name for them. Is that right?
Well, Alan did, yeah.
Okay, but did you know that your husband signed your son's name? Miss Sipe?
No.
Okay, and how did you find out that your husband had signed your son Walker's name on the petition?
Jennifer called and said there was a question about the signatures.
Okay, you all live together though, right?
Yes.
Okay, Mr. Sipe, could I ask you please, because apparently your wife doesn't know anything about it. Okay, so you signed the petition for your son Walker?
Absolutely, I did.
Okay.
I had, no idea at all. I'm just a citizen. I had no idea that that was the wrong thing to do. Walker was supposed to come home on leave. He did not come home until the following week. I called. I signed a lot of stuff for him, his bank accounts. We have power to do that when he's here. He is on the USS San Diego at this time, heading to Japan. So I cannot get him. And yes, if I'm going to be purged, yes, I did. I did not know I was doing wrong. I had no idea that I was doing anything wrong there at that point in time.
I just have a couple questions. So do you have like an official power of attorney form for him?
No, I do
You
not.
just do stuff because he's gone?
Yes, correct.
Okay, and did you see when you signed it, when you signed it, it says cannot sign for another, and like,
No,
it's like the
ma'am.
first signature
No,
right
ma'am.
under there.
I tell you, all of us signed in my parking lot on the hood of Miss Webb's car. Okay?
That's when you signed?
Yes, on the hood of cars. And I just did not know.
Did you see your other children sign?
I saw I saw Will sign. Wyatt had come in and out, which I did not. Now, George Wyatt Sipe always referred to as Wyatt. But if you know in the military, you go by your first and last name. So my son started to call himself, getting ready for boot camp, George Sipe. If you call him Benet, it is George Sipe. It's not Wyatt. So it's always George. So he started signing his name, everything, preparing himself to leave. And he is at Fort Moore, Georgia at this time.
It always beeps when I'm talking.
Gotcha.
Okay, I don't think I have any more questions. Thank you.
Commissioners, are there other questions?
Can y'all still talk to him? Y'all want to talk to him?
That's, are you offering his testimony?
And this is Jennifer. Did you sign my original petition?
Wait a minute. He's gotta be sworn in.
He's gotta be sworn
Yeah,
in.
be sworn in.
Sorry.
And it's gotta be where we can see his
Do you have FaceTime?
ID.
Do you have FaceTime? Okay, can you FaceTime us and do you have your ID with you? There you go. Yeah. You need to go to the microphone, so everyone can hear you.
Yes.
Oh, she's got a minister, oh, she's got a picture right in it.
Raise your right hand.
We gotta see you do it.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
We did make some money. Okay. And did you sign my original petition?
Yes, ma'am.
Did you sign the affidavit?
Yes, I did.
And who did we use to sign your affidavit? Was it a lady named Desiree Farrar, a mobile notary that we had to come meet us because we couldn't find a notary that day?
Yes, ma'am.
Okay. Any questions?
Can you get him to explain why he filled out the affidavit the way he did?
Why did you, instead of saying, he probably don't remember how he filled it out. So do I need, I gotta tell him?
No, don't tell him.
Okay.
Just ask him the question.
Well, yeah, but he won't know what I'm asking because he's a kid. I mean,
Ask the question.
Ian, why did you, when you did the affidavit, why did you fill it out the way you filled it out instead of saying you actually signed the petition?
To affirm that I signed?
Yeah, to confirm that he signed. I mean, because, you know, to a lot of people, endorsing's endorsing.
To prove that I signed?
Yeah, that's why he signed the petition, the affidavit.
We can't hear.
Can you speak up a little more?
Yes, just.
Put it, yeah, there you go.
That I signed at the third party?
Come show me what, this is your phone.
Ask him to repeat the question.
Why did you sign, saying you endorsed me instead of saying you signed my original petition?
Because because I needed to affirm in front of someone else that I had signed.
See, he don't really understand the difference. A lot of people his age don't understand. I can shoot him a copy of it and.
No, that's all right.
I'm good.
Okay, all right.
Do y'all need the notary card?
Commissioners, do you have any questions for Ian McWilliams? All right.
Do y'all need the notary that we use for him?
I think you already put it in the record, didn't you?
Did I?
Yeah. No. Okay. Thank you.
Closing statements.
Yes.
Move on to closing statements.
I think we're ready. Now, before we close proof, Mr. Holland, I had asked for the witness to verify this document, excerpt from Attorney's Guide to Document Examination that I'd questioned the witness about. Has Ms. Peterson had an opportunity to look at that?
I think my answer was, as soon as you can authenticate it, we could go back to the court reporter and find that if necessary. But if it's not, if that was not my prior answer, I'll say it again. As soon as you can get it authenticated, we will consider it after the conclusion of Ms. Webb's case in chief.
So, okay.
So if you want to allow us to go into recess after you've authenticated it, we will, her and I will read it together.
Okay, so you refuse to allow the witness to authenticate it, and now you're saying I have to authenticate it before she'll look at it. Is that what you're saying?
I'm subtly pointing out the contrast in the hearings, lob ball versus hostile. And that happens to be with the partisanship, I guess, because you are doing trial by ambush. Because what is different between Ms. Webb and Mr. Mitchell is that, pursuant to the rules of procedure that were sent to me and adopted by this commission on April 22nd, was the rules of procedure and a sharing of evidence. Why? To prohibit trial by ambush. Yet the chairman of this commission is doing that by ambush, and while continuing to refuse to authenticate that document. And it's irrelevant, and the only reason you could be doing it is because her testimony and her expert report is devastating. And if you ask that question again, the answer is the same.
All right. Let me make this an exhibit so people will know what we're talking about.
And I, again, restate my objection to its consideration into the record for the purposes of the record. Thank you.
The 10-page document that I questioned the witness about, and which Mr. Hollins refused to allow the witness to answer further questions about, is called Collecting Exemplars, excerpt from Attorney's Guide to Document Examination by Catherine M. Kloppenhaber and Ms. Klockenhammer, according to the witness's testimony, was her mentor and somebody she studied under, and she answered some questions about this document before she was prohibited from doing so. So we ask that this be made part of the record.
Yeah, can I?
Ms. Eckes seems to have a question.
Yes, ma'am.
Yeah, I do have some concerns about the process in that the commission is sitting in a quasi-judicial capacity, and generally commissioners do not introduce evidence. They look at the evidence that's been introduced and make decisions based on those evidence, be it through records of the commission. So I do want to just mention that this is rather unusual in that the commission is sitting in a quasi judicial capacity and does not introduce evidence from outside as part of the record of a case.
So so this is different than our asking witnesses questions? Because we've been introducing a lot of evidence by asking witnesses questions. And in this case, I was asking the witness questions from a document, and I think we all need to know what the issue was. So.
Yeah, I mean,
and the judge is allowed to ask questions.
Well, this is a little different.
Even though we're not sure what our capacity is.
In that, there's a document from somewhere, I don't know where, that's being introduced as part of the record. So it just kind of feels, it's very unusual, and it's not generally how these proceedings are conducted. Generally, they are based on the evidence that's presented, and generally the commissioners, at the trial of facts, they look at the evidence that's presented, that's as opposed to going outside and digging up evidence and presenting themselves as, something from wherever it is, I don't know, internet or something like that. So generally the commissioners, that's not generally in the capacity that they operate. And generally in any hearing, you want everyone to have the same materials. When the commission is sitting in a quasi-judicial capacity, the materials are introduced, and everyone on a due process level will have the same information. All the commissioners will have the same information. And generally, the commissioners don't go gathering evidence outside to introduce in the record. So I just wanted to point that out, that's just not, I'm highly concerned about that.
So are you objecting to putting this document that we've all been talking about now for 45 minutes into the record? Is it?
I think it raises concerns because, again, the commissioner, it's almost like a judge going out there and getting something and saying, I'm putting this in the record. And it's just I think it's highly unusual, and that's just not generally how these proceedings are conducted.
Perhaps I make a suggestion? I think there's two different records that we're talking about. There's the record of the court reporter for purposes of appeal, and I think what you're talking about is perhaps making a record for purposes of identification, so we can know what it is for when, somebody inevitably takes this to a court, versus what it is we are permitted to consider in making this decision about this challenge.
Right.
And
I'm not offering it into evidence. I'm asking
finish?
that it be identified, if that's the distinction. I was not permitted to ask additional questions, so it's not admitted into evidence at this point. We just want to make it, we want to put it in the record for identification purposes.
I'm going to just disagree with you on my opinion on that just for a second, respectfully, but you questioned from it pretty extensively with all sorts of information that was outside of the record about this witness and, independent research you've done and, various other things. And at time it did feel more like a deposition than a hearing from your part. But so I don't think that it's appropriate that it be considered when we're making our determination today, or that any of the questions about anything you pulled outside of the record is appropriate for our consideration today. But I understand your position that a court record is going to be talking about a document. Nobody's going to know what that document is. Right. I don't know that I think it's relevant at all in any purpose, but if somebody slaps it on the back of a transcript and says this is what they were talking about for identification, and there was a disagreement about whether it's admissible and your questioning was appropriate or not, I think that's a little bit of a different story.
Well, I would also point out that we had an expert designated on the last day for information to be supplied to the commission. nobody had any real opportunity to designate an expert on the other side. So that's the situation we have. We have an expert that comes in that essentially tells us that, she gives an opinion on these signatures, and essentially you're saying we can't cross-examine her based on her credentials. And I most respectfully suggest that you can do that. We can cross-examine an expert based on her credentials and her background and experience. Otherwise, how are we going to evaluate what we're being told by the witness?
So I'll just say one thing just to be clear, because I don't want it to get lost in all the back and forth that's happened. I think when you are proffering a witness, an expert witness in a case as an attorney, and you are making that proffer, that is one thing. And when you are cross-examining someone else's witness as an advocate for a side, one side or the other, as a lawyer, that's another. But when we're supposed to be sitting in a capacity that we are judging, the facts, or, trying to interpret the law the best we can, acting sort of like judges, we should not ever be thinking about ourselves as advocates who are cross-examining or trying to get to the truth of whether a witness is right or wrong or qualified or not. I think when Mr. Holland started, he said, I tender this witness as an expert, and was trying to get us to say whether we did or not. And we specifically said, no, we don't, because we don't do that. I mean, we're not judges. We're not with the rules of evidence here trying to say this person qualifies as an expert or not. I think the point is Mr. Holland is saying, we think this person's an expert, and here's your information. And then I think Ms. Ecke said, you can decide what the weight is you want to give if you think this person's, that or not. But with due respect, Mr. Delanis, I know a bunch of us are lawyers here, and this is what we do for a living, but I think it was up to Councilwoman Webb to make those arguments about the qualifications of this expert or not, and that's not really the purpose or the point of this commission. So I do agree that I think that was kind of outside of our bounds, and I get it because we're trained that way and it's just what we do, but I just don't think it was appropriate, so I don't think it's appropriate that any of that be considered. But that's just my point, because I realize it's going to end up in front of a judge at some point, and I wanted it to be clear at least what my opinion was, and now I'll just hush up because it's 11:30 at night.
Mr. Chairman?
Yes.
In the interest of time, let me say I agree with probably 95% of what Commissioner Hirschfeld said, and I think it's time to move on.
And Mr. Chairman, I do as well. I think when we get into position, start presenting exhibits and information that even none of us have seen or read, I think it's something that we're going beyond what we should be going.
All right. Are we ready to deliberate?
I think they're supposed to get closing statements.
Oh, I'm sorry. Excuse me.
I'm sticking to the process, Mr. Chairman, as alerted to me. And, you still got an opportunity, at least for Robert Jeffrey Webb, to get his signature live on camera. He could sit down right here and do it. Y'all could pass it along and compare it. In addition to my general objection, anything not in the materials presented to every member of the commission that you used in your hostile cross-examination of Ms. Peterson, I would ask that it also be excluded if it's not in the binder shared with everyone, because you went outside and compiled your own evidence. And I'd also submit the standard for examination of handwritten items, as you've called that into question. That was a document from 2022, and I'm submitting that. Chairman Burns here, or Commissioner Burns, if he would send that on down. But and also object to the FaceTime or whatever the live video presentation was of Mr. McWilliams. What is undoubtedly clear is the statute that says it's voter registration, which is y'all's known exemplar, versus the petition. That's what the statute limits this commission to. For Ian McWilliams, it was a signature versus print. Michelle Armistead, as Ms. Peterson testified, it's not a match. Moreover, when confronted with an opportunity to get that correct, she submitted an affidavit that said she endorsed Jennifer Frensley Webb. That does not rebut the evidence against her. George Sipe signed Wyatt Sipe versus print George Sipe. Those do not compute. Those are not the same. That's what the statute says, not what I say. And you've already heard, I'm stunned that you heard it, Alan Sipe come up here and confess. He confessed that he signed that petition for Joseph Walker Sipe. On the face of that document that's in front of you, on page 1 of Jennifer Frensley Webb's nominating petition, it warns the signer it's a Class D felony. He admitted to it. That will be presented for criminal prosecution. It can't be, if this body is charged with election integrity, and I waived your participation at the beginning of this hearing. That waiver still stands. However, your impartiality, Mr. Chairman, is reasonably questioned because you crossed the Rubicon from independent arbiter to advocate. And all that totality, there's not enough signatures for Ms. Frensley Webb to qualify as a candidate for State House District 50.
And I'm going to say I disagree, that I have more than enough to qualify for running for this election. You know, on my way here tonight, well, I got a call from somebody and said, you know, if you just don't go in that building, he said he won't send nothing to court for fraud or anything. I'm like, he did? Well, you know what? Bring it on, because I know I didn't commit fraud knowingly. Nobody that I know did knowingly. And if he wants to be that petty, then that's something that he has to live with. And I would hope that Mr. Mitchell does not have that kind of character and that he can run this race and be open and honest and clean like I ran my council race. And I just hope y'all see that I'm deserving to be on there. I got enough signatures, and let it be. There's nothing else I can say that somebody else hadn't already said, whether it be Justin Jones, Laura Nelson. Everybody knows handwriting is not a definitive. It's not 100%. Her own contract states what she has to have her analysis up to 20 comparison signatures. She had 3 maybe, okay? Just read her contract. I mean, there wasn't enough for her to look at to say whether somebody's signature is somebody's signature. And that's all I can say.
Are we ready to deliberate?
Yes.
Chairman, just
Yes.
procedurally, I would say, if there is a motion, you have some that's being challenged that weren't counted, some that were counted, it's being challenged as not counted. For the record, for either party, if this were to go up to court, I think you need to be very specific if you're excluding any signatures or if you're including any signatures. I think that's what's fair to the parties.
I agree, actually, I was gonna make that point, if I could be recognized for 1 second. I think probably the easiest way to go about it is, I hate to ask you this, Ms. Harrison, but if we could make a list perhaps of the 5 people's names and then how each of us voted on each of the names, if we think the signature is appropriate or not. Does that sound appropriate to everyone to keep track?
Yeah. Do we need a motion for that or just go ahead and do it?
Well, presuming we're going to vote on each one individually and we'll discuss each one individually, correct?
That's what I think.
Yeah.
I don't think you can just up or down it, because I think they're all individual, and we'll all vote on each name, which can get a little complicated.
I'm good with that.
Okay, great. So the 5 names, if I understand them, are Ian McWilliams, Jeffrey Webb. If I'm going too fast, tell me.
Well, let's just, what order do we want to take them in? We'll just write it down and do it that way. So I don't care which one.
Okay, so if you do the ones that Mitchell is challenging, Representative Mitchell, apologies, that is going to be Michelle Armistead.
All right, let's start with her first, Michelle.
Which is number 10.
Uh-huh.
And then George Sipe.
Number 15.
Okay.
Make sure.
He's 26.
26.
That's like
I got him
26.
26.
26, okay.
And then I think then you go to the 3 that were kicked off that Ms. Webb would like to have put back on. And if you do those in order, I believe that is Jeffrey Webb, Ian McWilliams, and Will Sipe. Do I have that correct? Does anybody think I got that wrong?
And numbers 14, 15, and 27 respectively, correct?
Yes.
Yeah. 14. Okay, let's go over the honesty.
So I'll go first if that's okay. Okay, looking at the Michelle Armistead signature, I've been looking through my book again. Y'all saw my book earlier. Comparing everything and the back and forths, listening to the testimony that's been provided by both sides, and looking at Ms. Armistead's affidavit. Kind of looking at a, totality of information here about Ms. Armistead. You've got a handwriting person who's saying, that was the highest degree of, I don't think it matches. I think she had a lower degree. I think you'd asked that. She'd had a lower degree of it doesn't match for Mr. Webb, but had a higher one for Ms. Armistead. And Ms. Armistead's affidavit simply says, I endorse Jennifer Webb for state representative, but doesn't say she signed the thing. So I am not comfortable that it is her signature. When I look at them, I don't believe that they match. I think the burden on the challenger's burden. I think they've met that burden by bringing in, whether we call her an expert or not, somebody knows a lot more about signature matching than I do. Doesn't look the same to my naked eye, doesn't look the same to my usual eye, and somebody that knows more than I do also doesn't think it matches at a higher degree. And she had the opportunity to say otherwise in her affidavit. She didn't. She just said she endorsed. She's not here. So I would say we should reject the signature of Miss Armistead, Michelle Armistead, because there's two, so Michelle Armistead. That's signature number 10.
Commissioners, further discussion?
Mr. Chairman, if I may.
Yes.
Well, again, in the interest of time, I totally agree with what Commissioner Hirschfeld said, and have serious problems relative to the accuracy or the authenticity of Michelle Armistead's signature on the petition, most specifically because of the way she worded, not only the way she worded the affidavit, but she crossed out the lines underneath there. I agree with Commissioner Hertzfeld.
Any further discussion?
Mr. Chairman, how are we voting individually?
That seems to be, that was the suggestion by Coordinator Goins, and I thought there was a consensus on that.
That's fine. I just trying to get a clarification. Mr. Chairman, I would.
That's not to say you couldn't,
Sure.
change your mind
Sure.
before we go
Sure.
home tonight, but we're trying to do it in that way.
Well, I would vote to reject that signature.
Do we need a motion, Mr. Chairman?
I have a comment.
Okay, excuse me.
I too was troubled by the affidavit because it did not address the issue. On the other hand, I think we've heard a lot of testimony today where people clarified that they do their signature all kinds of different ways. And I don't think there's any question that I am skeptical of somebody coming in and saying there's no way that could be her signature, et cetera. But on balance, given the fact that she had a chance to address the issue, I would be inclined to not include that one. So, are we ready are we going to do a motion or just discuss them at this point? Well,
I think we,
Can I get some clarification? Are we getting individual votes on these names?
yes, we are.
So, Commissioner Davidson.
He has not weighed in
There is no
yet.
vote.
Well, we've not voted yet.
We hadn't voted.
We haven't voted yet.
We haven't voted, no.
This is just discussion.
We're talking, we're just talking.
So where were we?
Well,
On you.
everybody's spoken
So-
but you.
Right. I mean, for the record, as I asked our handwriting, it's very interesting. That's why I asked certain questions that I did. But I did find her point about print to print and cursive or writing to writing interesting in regards to that as I look at the petition. But with that being said, that's the only comments I have.
I'll make a motion to reject the signature of Michelle Armistead from Ms. Jennifer Frensley Webb's petition.
Second, Mr. Chairman.
We have a motion and a second. All in favor, say aye.
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 Any opposition? No opposition, the motion carries. All right, and then the next one I have on my list is Ian McWilliams, who's, I believe, number 15.
It's fine if that's one you want to take
Do
up.
we have comment on Mr. McWilliams?
And just to clarify, Mr. McWilliams' signature has already been rejected by the staff, so this would be on Ms. Webb's request to have that reconsidered and have Mr. McWilliams added to her petition as qualifying signature.
I think that's correct, yes.
Okay.
Mr. Chairman,
Yes.
I have problems with Mr. McWilliams' signature. I actually believe we got it correct first time. I know there's a lot of talk about people don't understand what they're saying about writing a petition, with writing an affidavit. Well, that you gotta be grown. You gotta, he said, this is my signature. And that gives us no clue whether he's talking about his signature on that affidavit or the petition. He was unclear. Now, I know we woke him up, y'all woke him up or whatever, but we got to go on what the evidence is before us. He was not a convincing witness. And I wouldn't even call him a witness. Sure, he's a fine man, but he didn't provide the information that I felt I needed to accept that signature. So, Mr. Chairman, that's kind of where I am on that.
Mr. Chairman?
Yes.
I agree with Commissioner Burns. I, appreciate the fact that he woke up and tried to talk to us, but it just wasn't enough. It was just too choppy, too many questions, and the affidavit certainly concerns me pretty greatly, as well as the original signature. So I think it should have been kicked off, and there's nothing that's changed my mind on that. So I agree with Commissioner Burns.
Mr. Chairman, I agree with that as well.
Commissioner Davis?
I think we all are doing our very best to get it right, and after hearing so much professional opinion, looking at what he signed on the nominee petition and looking what he signed as he wrote his name on the affidavit, which are legally binding, and I'm not a handwriting expert or a lawyer, as we like to point out, but I do say that if I was looking at this strictly from even having some extra knowledge now from Ms. Peterson, if that's her name correct, if I misspoke, I apologize. It does call the question that the signature here might be more inclined to be actually correct, looking at the affidavit and looking at what's on the actual petition. So you look at the Ian, looks like they look similar in scope of lines, especially with the first name. It definitely looks like there could be some potential. I do understand the commission's concern with what is said in the affidavit, but as the lawyer stated here, he was very firm about petition, the signature, and if I look at signature, it looks like it might be signature from what they said.
As I think everybody can tell, I am really, really skeptical about people's ability to look at a signature done under one set of circumstances and say, well, that's not his signature, in the face of somebody's testimony. I didn't think he was unclear at all. I mean, he may have been a little inarticulate, but he was very clear that he signed that petition. And, the document examiner basically indicated that there were 10 to 15 factors she knew nothing about. And yet here we are basically accusing somebody of forgery. And I just can't see how we can do that and even begin to be consistent with what we did earlier in the day. We accepted people's explanations not very long ago, and this is not an exact science. It's not even close. Ms. Peterson, and I'm sorry, we needed to know that you're supposed to have the original. She admitted that. She admitted she couldn't reach a conclusion without the original. That's what she said. It has nothing to do with this document that I was examining her with. She admitted that was the truth. And she admitted she testified to that in another case. So, I just don't see how we can allow someone to testify and confirm that they signed something and just because a signature looks different, we assume they didn't sign it. I mean, we all know that we sign things quickly at times, and at other times we don't sign our signatures quickly. We've got a couple exemplars. There was no consideration given really to how the copies were made, and the witness admitted that was important. We had many factors here where the witness admitted that was important, and honestly, saying that I was adversarial is one thing, but on the other hand, we needed to know how strong this information was that we were getting.
Mr. Chairman, point of order. I don't think that Ms. Pearson testified as to Mr. McWilliams.
She did not.
I'm sorry.
I don't think she had anything to do with Mr. McWilliams.
So what are we going on then? We're going on.
We're looking at the evidence that was presented by the parties. And the evidence that was presented by the parties had nothing to do with the document examiner. The signature examiner presented by Representative Mitchell was Armistead, who we've already voted on. And I believe the other one was Jeffrey Webb, who we have not yet voted on. And so I don't think the expert has anything to do with anything else.
All right, then we'll just hold that comment.
Okay.
But so in this case, basically, we have Ms. Harrison. Do I have that right? Ms. Harrison did not believe that signature was a good one.
Correct.
All right.
And the affidavit.
And the affidavit, which he's explained.
Sort of.
And we also have, and to some degree, it is applicable. We have these statements by the witness and our own common sense that tells us that making a determination about somebody's signature is very difficult to do. It's very difficult to do. We're not experts.
But it's our job today.
But we are rejecting testimony by somebody who was sworn to tell the truth.
And so if your position is you'd like to vote against it, perhaps we could just call the vote.
Well, I thought I was allowed to make a comment.
You're making it, but I mean, it's 10 o'clock till midnight now, Mr. Chairman, and we still have quite a ways to go. We've been here for 6 hours. It'll be 6 hours in 10 minutes. In 10 minutes, we will have been here for 6 hours. I'm just simply trying to get us to perhaps shorten it up a little bit so we could just vote on these last three, take our final vote. We all have to be back here tomorrow again as a commission to meet, to set the ballot. I think our staff is tired. I think everybody's tired. We could just say a couple words, we're up or down, this is why we're making our decisions, and get it done. I personally would be very appreciative. Otherwise, I'm gonna need a comfort break in a little bit, and nobody needs to be taking another break.
Well, part of what deliberation is listening to each other.
I'm listening.
Hey, if you've made up your mind and you're not going to listen to what anybody else has to say.
But Mr. Chairman, you're talking about an expert and the expert's opinion on this witness's signature when the expert didn't even opine on this witness's signature. And I don't want to be rude or disrespectful, but I suspect that because we've been here for 6 hours, perhaps people's minds are getting a little bit jumbled up. So
well, that's true. That is true. And if you'll let me finish my comment,
go ahead.
We can vote.
Let's go.
We've spent 5-10 minutes on your objecting to my finishing my comments. Yeah. So, I mean, we are basically calling that person a liar because we think his signature looks a little funny. And I'm not comfortable with that. None of us were comfortable with that a couple hours ago, and most respectfully, I don't think we should be any more comfortable with that now.
Point of order, Mr. Chairman, at the last vote, I did in fact question and voted against someone based on that I didn't feel they were a credible witness. So just, the majority didn't.
Right,
But just,
the
I just want to make sure it's
The
clear.
majority, correct, yes. That's correct. And there is such a thing as substantive, substantive compliance. And most respectfully, I think these are and good enough. This is not supposed to be a barrier to running for office. It's just not. So those are my comments. Yeah, are we ready?
May I be recognized?
Yes, ma'am.
Can we call the question, please?
Well, that's what I was asking. Yeah. Does anyone have a motion?
I will make a motion to keep the signature of Ian McWilliams not on the ballot as was previously determined by Election Commission staff.
So, point of order, so we're voting to keep him on, correct? Off. You want to keep him off, thank you, okay.
I'll second the motion.
We have a motion, we have a second. All in favor, say aye.
Aye.
Any opposition? I oppose. The motion carries 3-2. All right. What's the next one on your list?
I have Jeffrey Webb.
All right, and he's number 14. 14, okay. All right.
Jeffrey Webb was rejected initially by office staff. Jeffrey Webb was the subject of the expert testimony that was brought up by the expert for Representative Mitchell. And Jeffrey Webb did testify here today, and he is the child of the council person. Taking a look at all of it from my perspective, I do think the signature is a little bit different. I do appreciate the fact that signatures change an awful lot. I appreciate the fact that Mr. Webb is here to testify in person, that it is your signature. I appreciate that. And I also appreciated your honesty that you just can't remember when you signed it. Because I think that's probably an honest answer. You got a lot of stuff going on. You're coming and going. Your mom says, here, sign this, and you do, right? So I appreciated that. I also note that the expert, I hesitate to say expert, I'm going to say the signature examiner evidence that was presented by Mr. Mitchell's side did have a lesser degree of confidence that it wasn't a match. It didn't match as well. It wasn't quite as strong as the other one. I actually say coming in today, I actually looked at them and thought perhaps they didn't match. That was my thought coming in. But after hearing from Mr. Webb, I believe he signed it. So I'm fine putting Mr. Webb back on the petition.
Commissioners, any other commissioners?
Mr. Chairman, coming into this, I too had concerns about Jeffrey Webb's signature, but his testimony and some clarifications, as well as the fact that the professional, Ms. Peterson, had a lesser degree of confidence, I will agree that his name should be considered a valid signature for the petition.
Commissioners?
Mr. Chairman, I too had some issues with Mr. Webb's signature. It looks like it was more out of line than any of them, but listening to the testimony of Mr. Webb and also the Ms. Peterson being lesser, I too will allow it to be on. My vote is yes.
I concur with that. Like I said, he testified, he explained himself, we heard from our professional. I think definitely he's met a certain barrier.
All right. My comment is that he was here live, he's got an affidavit, and then the notary is also here to testify, so I agree with what everybody else has said. So with that, do we have a motion?
Mr. Chairman, I make a motion that we consider Jeffrey Webb on line 14 a valid signature for the purposes of this petition.
All right. Do we have a second?
I second.
We have a motion and a second. All in favor, say aye.
Aye.
Any opposition? With no opposition, the motion carries.
The next one I show is George Sipe.
Okay, and that's number 26.
Number 26.
Okay.
Looking at this, if I summarize the facts incorrectly, somebody please stop me. Mr. Sipe's signature was originally accepted. It is one that has been challenged as not appropriately belonging as a qualifying signature. And we do not have an affidavit from Mr. Sipe, and he was not available to testify here in person. His family members have testified, but we also received testimony from his family member, his father, that he had signed for one of the other sons, who's also in the military and not around. So that gives me sufficient enough pause. I don't think the signatures match. The G's don't match. I think there's sufficient enough in the comparison of the signatures that they don't match. I've got concerns about parents signing for the children. The fact that he's not here, and I understand that it's not his fault, and that we don't have an affidavit. And again, I understand that's not his fault, but we have to do the evidence that we've got in front of us. So I would move to remove Mr. George Sipe, number 26, from the petition. Oh, that's just my thoughts. I think we're still in the discussion phase.
Did the notary speak to Mr. Sipe?
No,
Oh, that's right, sure.
we don't have
Yeah.
anything.
Well, okay. Well, so for him, we have we have his original signature. We have his mother's testimony, and we have the staff, essentially. Now, that one was not the subject of expert testimony, was it? Okay. It just seems to me that our staff accepted it. His mother saw him sign it. That's her testimony. It wasn't even seen fit to be challenged by the expert. I would find it hard to accuse him and his mother of doing something improper, and of our staff of making a mistake.
I don't think anybody is trying to imply any of that, Mr. Chairman. I think we're just here to look at the evidence and try to make an analysis. I am simply looking, and I kind of resent the implication, I'm simply looking at the voter registration card that we've been provided, looking at that versus the signature that is on the petition, looking at even the signature, and I understand George and Wyatt, and he changes his name when he gets older. My kids do the same thing. So there's if you look, there's like the signature, like the cursive signature written on the voter registration card, but he also filled out, I mean, I'm doing kind of extra, right? Because clearly the signature signing one doesn't match. I mean, there's just like no question about that. But even if you go to the next step and you look at the printed signature, because, sometimes kids do that, and I think you pulled that out, Mr. Chairman, in your questioning, the George Sipe and the way that it's written by hand, the handwritten print in the thing, I mean, that doesn't match either. Like, nothing about those signatures look like they match to me. So I'm really basing that on the fact that I don't think those signatures match, like, not by a country mile, and giving all benefits of the doubt that I think I can. And again, you know, knowing that we already had an issue with the son being in the military and the father signing with the same family. I'm not trying to imply anybody intentionally did anything wrong or, you know, impugn anybody's character. I'm just simply trying to do one or the other. And I'd appreciate it if you didn't try to make it look like I was calling somebody a liar, because I really am not.
I'm sorry. I was just giving my opinion.
Mm-hmm.
And I just have a hard time, because we are saying if that's not his signature, we are saying that something improper was done here. That's what we're doing.
That's what you're
I'm
saying.
not, that's what I'm saying. Yeah,
Then
that
you
is what
say
I'm
that.
saying. I'm
Go
sorry.
ahead and you say that. I'm not saying that about a member
Okay,
here. I am not doing that.
All right. I think I'm allowed to give my opinion and talk about my basis about the way I'm looking at these things. And you know, if there's anything we've learned today is that this signature stuff is really difficult. And if somebody signs something in one setting or, you know, has an issue, I mean, it went so far as if you have an issue with your family or you're sick or you're taking medication. I mean, we heard what the expert said about this, and so
You said that, sir. You said that, not the expert. And this woman was not qualified as an expert. You said that.
She admitted those things to me because they happen to be true.
You seem to be.
They just happen to be true.
Mr. Chairman, I'm sorry, but I'm gonna have to object to your inclusion of your improper questioning of this witness.
I mean, it's just common sense for us to know these things, and the witness acknowledged that. And so,
Mr. Chairman,
and we wouldn't have known it if I hadn't asked these questions. So I'm sorry.
Mr. Chairman, but that's the point.
I'm sorry, but
The witnesses are
interrupting me.
I am.
When I'm trying to make my my views known here, and I'm sorry. I'm allowed to do that. I didn't interrupt you. You got to go through everything you wanted to say, and I should be permitted to do the same thing.
Go ahead and make your record, sir.
So, I mean, I just think that each of us turning into, you know, sleuths here and looking at these signatures and saying, you know, it's not his signature in the face of you know, in face of their testimony, it's just, you know, it's just difficult. I mean, it's just difficult to, I don't think we should do it. We should look at the testimony and if there's a serious reason to not believe it, that's one thing, but just to eyeball a signature and say, hey, you know, that doesn't look right to me. I can look at my signatures in all kinds of circumstances, and they're going to look different.
Are you finished, Mr. Chairman? May I be recognized, please?
Yes, you may be recognized.
I just want to one more time state my objection because you've again talked about the information that you were questioning the proffered signature person with, and including that now to analyze and make your determination on a signature that she didn't even opine on. And I think it's well outside of the boundaries of what we're supposed to be looking at. I actually think what we're supposed to be looking at is pretty simple. Look at the signatures. Do they look like they match? If they don't look like they match, do we have any additional evidence like an affidavit or having them live? If we don't have that, we then make our determination. I just want to object to your continued reliance on the information that you brought in from outside for a witness that didn't even opine on this signature for this petition. And then you can say what you want to say and we can move on because I really would like to go to bed tonight before 2 a.m.
Okay. I mean, the law talks about a regular signature. And this seems like a lot of them we've looked at today. These are good old regular signatures. And, you know, doesn't have to be, that part of it doesn't have to be that complicated. You know, we are saying that, I think, in effect, we're saying that he didn't sign it if we reject this, and we are saying he's not telling us the truth. And I think it ought to take a lot more before we should reject somebody who's trying to do a civic duty to sign a document and to let somebody run for office. This is not supposed to eliminate people based on technicalities. We are supposed to follow the law, and the law says if it's a regular signature, then we can accept it. And I'm just suggesting that this is one of those where there's been substantial compliance, and then we ought to accept it. Any further comment?
Mr. Chairman, if I could ask Ms. Aki a question. It's been a long time since I've been a real lawyer, so I can't remember all rules of evidence and such. But was Ms. Sipes' testimony relative to what she said she saw her son George do? That would not be considered hearsay. I mean, that's actual. She's just testifying to what she saw, and that's appropriate. Is that correct for us to consider as?
Well, let me say this. This is not a formal proceeding. It's not a court.
Yeah.
This is a quasi-judicial proceeding, so the same rules of evidence don't apply. At the end, you are the ones that weigh the evidence and determine what weight to give any piece of evidence based on the record.
Okay. You know, frankly, I don't have a lot of confidence that the signatures on the petition matches even the petition on the affidavit. But Ms. Sipes appeared to me to be a credible witness, and so I'll give the benefit of the doubt on this one and suggest that that we conform with what the commission staff found, and that it is a acceptable signature for the purposes of this petition.
Mr. Davis, do you have any comment?
All this is not easy, and I do appreciate everyone who's come out tonight. I do think my colleague makes one valid point where on one level the signatures are interesting, to say the least, but the fact that I think you do have a credible witness in the room who says that, and they testified under oath that they saw them sign it. You know, the same issues to that person would apply one way or the other under oath, especially going further. So I think that makes the case for a lot of things.
Any further comment by the commissioners? With that, do we have a motion?
Mr. Chairman, I move that we accept the signature of George Sipe as a valid signature for the purposes of Ms. Webb's petition.
All right. Do we have a second?
Second.
We have a motion and a second. All in favor, say aye. Aye. Any opposition?
No. No.
So we do have opposition.
Yes, do you have opposition? We're both voting no. 3-2.
3 yeas and 2 nays. Let's see. Who's next on your list?
The last one is Will Sipe. He's present here.
Okay. Okay.
If I'm summarizing correctly, Mr. Sipe was originally, his signature was originally rejected by the staff.
Okay. Okay.
Ms. Webb has asked to have it put back on. It was not the subject of the signature analysis done by Representative Mitchell's witness, and that is where we are.
Okay. Do any of the commissioners want to comment? Anybody have observations? Coordinator Goins, you have something to say?
I just want to make sure, I believe he was here. That's the
Correct.
only thing I would add.
Yes.
Okay.
Yes, he was here.
All right,
Yes.
just for the record, thank you.
Yes. He supplied an affidavit. He testified live, and the notary was here to support that also, if I'm not correct.
So if I may speak,
Yes, ma'am.
so I also had very significant concerns about Mr. Sipe's signature coming into this. I understand that we have a formal way of signing things and an informal way of signing things. And Mr. Sipe, I'm looking at your date of birth. You're how old? 24. That's right. And so, you all haven't really grown up signing the same way the rest of us have, and I understand that. So I had some concerns about it coming in, but, now that you've testified to it and, all the other evidence we've received today, I don't have the same concerns about Mr. Sipe's signature.
Do any other commissioners have comment?
Basically agree with Commissioner Hertzfeld.
Mr. Chairman, why was it rejected in the first place?
It doesn't match, look.
Mr. Chair, maybe we can do that on somebody's own time, Mr. Chair. I think we've determined that it's been rejected.
There's a notation that says signature differs. That's all we know.
I suspect it's because the signature here is cursive. See?
So it was actually rejected by the commission.
Mm-hmm.
Originally, it was rejected
By the staff.
Yeah, by staff.
Yes. Correct. I think that's right. Do any of the other commissioners have comment? Are we ready to call the question, Commissioner?
Nobody else has comments?
We're good.
I think we're ready to go.
Do you understand what he's saying?
Mr. Chairman,
Make motion.
I'll make a motion, Mr. Chairman, that we accept the signature of Will Sipe as a valid signature for the purposes of this petition, although I can see why it was rejected, because I think I can see why it was rejected originally, but given his testimony and credible witness that he was, maybe we accept it as valid.
Do we have a second?
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Any opposition?
Oh, sorry, aye.
Okay, all right. Is there?
No.
No. So it's a 4-1. 4-1.
4-1.
Yes. 4-1.
AJ's
yes.
no.
4-1. Yes. Okay. Are there any others? That's it. Okay.
Mr. Chairman, I lost count. What does that mean as far as Ms. Webb's candidacy? She's on?
I think she is.
She's still on the ground.
Before you conclude, Mr. Chairman, earlier I asked about Mr. Allen's site and whether or not this body was going to be reporting him to the district attorney for him confessing to an election crime, and whether or not you're going to do that, and if not, I will. I'd appreciate an answer to the question.
I don't think it's before us today. We have a limited agenda today. Okay. Let the record reflect that Mr. Holland left the room before I could answer his question. Is there anything else to do today? I'm trying to find the agenda in this pile of papers.
Motion to adjourn.
All right. We have a motion. Wait a minute. Okay. Correct. We're going to be here tomorrow at 3 o'clock.
Mr. Chairman.
I'm sorry. Yes, Commissioner Starr.
I need to know who seconded,
So,
please.
She is on the ballot.
Yes.
Okay.
We
Just
approved
want
her
to.
for the ballot. And the last second, there was a second, I believe, by Mr. Davis.
Second to adjourn.
Oh, to adjourn. Okay, to adjourn.
So the question, so for the record, I just made sure that because we were going by just to make sure that we told everybody who's watching still that we have to be here again, because that's actually on the agenda. And so Commissioner Hertzfeld's made a motion to adjourn.
We have a second. We have a motion and a second. All in favor, say aye.
Aye.
Any opposition? With no opposition, the motion carries. Thank you very much.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.